Okay, let's see how this goes. Alright, looks like YouTube may soon be getting an actual feed, meaning I am live. I am going to quickly check the audio, and then I will get us started much quicker than last time. Last time it took me 15 minutes to get started, which was way too long. Alright, you can't hear it, but I can. Okay, I'm gonna play the audio real quick.
Opinion of Kennedy.
Alright, this is me talking over it while it is actively reading. How does this sound?
46 to 48.
Okay, that sounds pretty good actually. So, I'm going to start giving you guys my desktop audio again. I will turn off my monitoring. And desktop audio is now live. Let's go ahead and load up Subnautica. Oh, I mess with my vision a little bit. Wow, that is trippy. Oh, there goes my video for a second. Passing 100 meters. 200 meters. Put this up again. Is it going to take a second for OBS to get pulled up for me? There we go. Okay, cool. Alright, double checking. We got OPS pulled up. You guys are seeing my screen. My character's probably going to drown soon. Oh wait, thankfully I'm actually in the OPS pulled up. You guys are seeing I'm in the ship, aren't I? Oh, very good. Okay. Alright. Wow, it's super laggy. Maybe because I'm using a different filter on OBS. I'll turn that filter off then. Okay. Turning off the NVIDIA audio effects filter to hopefully piss off my laptop a little bit less. Yep, it was that. It was using too much of the entire system at the same time, so that was not a great outcome. Looks like my ship is flooding. That's not a good outcome either. That's pretty bad. Wow, the screen tearing is really bad right now. I wonder if the computer's like getting hot or something. Checking some stuff to make sure I don't destroy anything. Uh-oh. Things are going crazy. Possibly in a not great way. Warning, external hull damage. Yeah, I'll consider getting right on that. 83. Yeah, the computer is most certainly getting more than a little bit warm right now, so that's not great. Well, I don't want this to have to thermal throttle the entire time I play, so I might consciously drop the resolution down today. Go to like a medium or something. I'm fine with that. Okay. We will reload with different settings. We are going to drop it to medium. Get VSync back on. Oh, that must have been the issue. That was actually probably the issue the entire time, was that I didn't have VSync on. And I should have. Okay, well, the stream goes on. Life goes on, as does the stream. Hopefully it doesn't start freaking out on me again. Double checking my audio for the 15th time. Hopefully it doesn't start freaking out on me again. Double checking my audio for the 15th time. Okay, yeah. It was probably getting annoying, but it was necessary somehow, I swear. For some reason I need that to be pulled up for it to not get all crazy on me. Okay, well, that's mostly running. It is running kind of sketchily right now. I'm going to prop up my laptop with something. See if I can get it some better airflow. Is it, after all, kind of suffering through all of this? Man, maybe I might unironically need one of those like laptop lapboard things, even though I don't really love those. Okay. Yeah, this is what I get for trying to stream, do text-to-speech, and monitor on one computer at the exact same time while running like a freaking virtual heads-up display. Okay, I'm gonna call this pretty much good enough to get playing and chilling. Welcome back once again. In this video, in this live stream, I am honestly just doing research for a Quiet Part full-length video. But what I wanted to do was share my suffering with you. What we are reading today is in the top right corner of the screen, as you can see. This is the Supreme Court opinion on a famous, well, famous to me, I guess, a very important Supreme Court decision, a Supreme Court ruling. The original case was called Citizens United versus FEC. It was a famous Supreme Court case that determined that businesses and corporations are allowed to invest in democratic campaign advertisement. So when I talk about democratic, I mean people being elected to office by vote. This Supreme Court case ruled that it is legal for corporations, no matter how big or powerful, it is legal for corporations to invest in advertisement connected to getting some person in office or keeping someone else out of office. So, this is one of those things that I feel like needs to be talked about more. I feel like isn't talked about enough. I feel like is really worth sitting down and learning about. So that's what I'm going to try to do, is I'm going to try to sit down and learn about it right now. This is a 180-page document, and previously we got to page 50 on the way that Microsoft Edge reads it. But I guess it actually says it's at page 43 right now. But it doesn't matter. This is where we left off, like pulled up exactly. So let me triple check. Yep, page 50. We're going to start from the top. It's going to be read aloud. I am going to mostly focus on listening, and I'm going to also be playing Subnautica while I listen. I will stop and reiterate things that I think are super salient and relevant as we play. I am not trying to speedrun Subnautica. I am just playing Subnautica because I feel like it, and it's easier than just sitting with this document alone as my mind goes numb and drains out of my ear. This is very hard to comprehend, but I am, yes, streaming on my laptop for one, but I am streaming on my laptop inside of the box truck tiny home that I live inside of. So I'm in the car, in the house part of it, streaming from my laptop, and I have 3 virtual screens pulled up via the heads-up display that I wear, which is something I've used for a while. So I can see my YouTube live chat in stream, I can see my game, and I can see the document and my streaming software at the same time while sitting off of this laptop. So I do not have like 4 monitors in here. It's all in this virtual display, which is, it's pretty janky, but it's enough to make all this work. Okay, I'm going to start it from the top here, and I'm going to go back to playing, and my biggest issue in the video game right now is that I am out of power, but I need to go deeper. It's not that important.
Political debts from legislators who are aided by the contributions. 459 U.S. at 207 to 208, citing automobile workers, 352 U.S. at 579, C 459 U.S. at 210, and N7, PAC, Supra, at 500 to 501, NRWC suggested a governmental interest in restricting the influence of political war chests funneled through the corporate form. NRWC, however, has little relevance here. NRWC decided no more than that a restriction on a corporation's ability to solicit funds for its segregated PAC, which made direct contributions to candidates, did not violate the First Amendment. 459 U.S. at 206. NRWC thus involved contribution limits, seen PAC, Supra, at 495 to 496, which, unlike limits on independent expenditures, have been an accepted means to prevent quid pro quo corruption, see McConnell, 540 U.S., at 136 to 138, and N40, MCFL, Supra, at 259 to 260. Citizens United has not made direct contributions to candidates, and it has not suggested that. The court should reconsider whether contribution limits should be subjected to rigorous First Amendment scrutiny. When Buckley identified a sufficiently important governmental interest in preventing corruption or the appearance of corruption, that interest was limited to quid pro quo corruption. See McConnell, Supra, at 296 to 298, opinion of Kennedy, J. Citing Buckley, Supra, at 26 to 28, 30, 46 to 48, and PAC, for 70 U.S., at 497, the hallmark of corruption is the financial quid pro quo, dollars for political favors, ID, at 498. The fact that speakers may have influence over or access to elected officials does not mean that these officials are corrupt. Favoritism and influence are not,
and that's just a fundamental disagreement that I would have with their logic. I would say that a speaker having direct access to a person in power is necessarily self-corrupting.
It is well understood that a substantial and legitimate reason, if not the Citizens United v. Federal Elections COMMN. Opinion of the court. Only reason to cast a vote for, or to make a contribution to, one candidate over another is that the candidate will respond by producing those political outcomes the supporter favors. Democracy is premised on responsiveness. McConnell, 540 U.S., at 297, opinion of Kennedy, J. Reliance on a generic favoritism or influence theory is at odds with standard First Amendment analyses because it is unbounded and susceptible to no
generic favoritism or influence theory. I guess maybe that's probably the side I'm on, maybe.
The appearance of influence or access, furthermore, will not cause the electorate to lose faith
in our democracy. I would lose faith pretty immediately.
Is political speech presented to the electorate that is not coordinated with a candidate. See Buckley, Supra,
saying it's not coordinated is so stupid, because everyone publishes their agenda publicly online. All you can do is just Google it. Not hard.
Have the ultimate influence over elected officials. This is inconsistent with any suggestion that the electorate will refuse to take part in democratic governance because of additional political speech made by a corporation or any other speaker.
No, this is so dumb. These people have so much money at stake that the political speech of a corporation would absolutely corrupt their governance.
2000. Caperton versus A. T. Massey Coal Company, 556 U.S. _____, 2009, is not to the contrary. Caperton held that a judge was required to recuse himself when a person with a personal
Uh-oh.
stake in a particular case had a significant and disproportionate influence in placing the judge on the case by raising funds or directing the judge's election campaign when the case was pending or imminent. ID @ slip up at 14. The remedy of recusal was based on a
Whoa.
litigant's due process
I'm getting the
right to
cutscene in the
appear
game.
before an unbiased
Uh-oh.
judge. See
What
Withrow
are
versus
you? Is that what she's gonna say?
421 U.S. 35,
What are you? There you go. Yep, I remember this game. I played it
Caperton's holding
once
was limited
or
to
twice.
the rule that the judge must be opinion of the court. Recused, not that the litigant's political speech could be banned. The McConnell record was over 100,000 pages long, McConnell I, 251F, Suppa 2D, at 209, yet it does not have any direct examples of votes being exchanged for expenditures, ID, at 560.
What was 200,000 pages long?
This confirms Buckley's reasoning that independent expenditures do not lead to, or create the appearance of, quid pro quo corruption. In fact, there is only scant evidence that independent expenditures even ingratiate.
I genuinely don't think whatever systems they're using to evaluate whether or not independent expenditures confer corruption are just out of touch.
Ingratiation and access, in any event, are not corruption. The BCRA record establishes that certain donations to political parties, called soft money, were made to gain access to elected officials. McConnell, Supra, at 125, 130 to 131, 146 to 152. See McConnell I, 251F Sup 2D, at 471481, 400.
Oh my god, I hate when it reads these aloud.
Opinion of Color-Catelli, J.
It's bad, but you just have to suffer through them.
858 to 859. Opinion of
Ow, this hurts.
This case, however, is about independent expenditures, not soft money. When Congress finds that a problem exists, we must give that finding due deference, but Congress may not choose an unconstitutional remedy. If elected officials succumb to improper influences from independent expenditures, if they surrender their best judgment, and if they put expediency before principle, then surely there is cause for concern. We must give weight to attempts by Congress to seek to dispel either the appearance or the reality of these influences. The remedies enacted by law, however, must comply with the First Amendment, and it is our law and our tradition that more speech, not less, is the governing rule. An outright ban on corporate political speech during the critical pre-election period is not a permissible remedy. Here Congress has created categorical bans on speech that are asymmetrical to preventing quid pro quo corruption. Citizens United v. Federal Elections.
Well, I understand that the litmus test for corruption is quid pro quo, like that is how you know something's corruption. But why can't we expand that definition? Like, please expand that definition a fair bit.
This asserted interest, like Austin's anti-distortion rationale, would allow the government to ban the political speech even of media corporations. See Supra at 35 to 37. Assume, for example, that a shareholder of a corporation that owns a newspaper disagrees with the political views the newspaper expresses. See Austin, 494 U.S.
Okay, that's actually an interesting example.
Scalia, J. Dissenting. Under the government's view that potential disagreement could give the government the authority to restrict the media corporation's political speech. The First Amendment does not allow that power. There is, furthermore, little evidence of abuse that cannot be corrected by shareholders through the procedures of corporate.
No, that's very stupid.
Bellotti, 435
Again, it's so interesting. In the oral arguments is what it's called. In the oral arguments that preceded this court opinion, so while things were still being argued by the lawyers verbally, not just on paper, it was someone in the oral argument. It might have been a lawyer. I don't know what side. I don't know if it was a justice. I can't remember. But someone said, and I've heard this before because anyone who's paid attention to economics knows this, the singular goal and responsibility of a corporation is to generate profit for its shareholders. That is just the purpose of a corporation. So to say that in one breath and then in another to say there is little evidence of abuse that cannot be corrected by shareholders through the procedures of corporate democracy. To say that those two things are true it's just ignorance to me. It just sounds like you don't understand what you were talking about. I don't like contradictions. I like picking out contradictions where I see them. That's a contradiction. Just plain and simple. Plain and simple. That's just a serious contradiction. Got to make it play again.
ID at 794 N34. Those reasons are sufficient to reject this shareholder protection interest, and, moreover, the statute is both under-inclusive and over-inclusive. As to the first, if Congress had been seeking to protect dissenting shareholders, it would not have banned corporate speech in only certain media within 30 or 60 days before an election. A dissenting shareholder's
now, banning it in like things
speech
except for books was pretty interesting.
The statute is over-inclusive because it covers all corporations, including non-profit corporations and for-profit.
I don't care, fuck them both.
Only single shareholders. As to other corporations, the remedy is not to restrict speech.
Even if it is, and this isn't the right word, even if the corporation is a sole proprietorship, even if it's a non-profit sole proprietorship, meaning it's owned and overseen by one person, so like that's me, right? I have a sole proprietorship in the form of my little engineering business. I still do not believe that just because I have more money, I should have more of a right to advertise and access free speech and sway and convince the outcomes of Democratic campaign elections. I don't think that just because I have more money, I should have the right to do that. I think, in effect, propaganda should not be allowed to exist. I don't think that should be a thing. I think instead we should, I don't know, I've been building my opinions about this as I've been reading, but I think we should build alternatives to our current systems.
The regulatory mechanism here, based on speech, contravenes the First Amendment. For we need not reach the question whether the government has a compelling interest in preventing foreign individuals or associations from influencing our nation's political process. CF2U-C Section 441E, Contribution and Expenditure Ban applied to foreign national s. Section 441B is not limited to corporations or associations that were created in foreign countries or funded predominantly by foreign shareholders. Section 441B therefore would be overbroad even if we assumed, arguendo, that the government has a compelling interest in limiting foreign influence over our political process. See Broderick, 413. U.S. at 615. See, our precedent is to be respected unless the most convincing of reasons demonstrates that adherence to it puts us on a course that is sure error.
It was in fact sure error. It was in fact sure error, the course that they put us on moving forward. Once I'm done reading this, I will look up a proper overview of a line graph showing the change in money the change in total amount of money flowing into political federal elections since this court ruling. I swear to God, I've seen one once before, and after this, it just shot up exponentially. The amount of money that flowed into our elections.
555. US ________________ 2009, slip up, at 8, overruling Saucier versus Katz, 533 U.S. 194, 2001. These considerations counsel in favor of rejecting Austin, which itself contravened this court's earlier precedents in Buckley and Bellotti. This court has not hesitated to overrule decisions offensive to the First Amendment. WRTL 551 U.S. at 500, opinion of Scalia, J. S. Ter decisis is a principle of policy and not a mechanical formula of adherence to the latest decision. Helvering versus Hollock, 309 U.S. 106.
Uh-oh, I just entered the planes, didn't I? That was stupid.
For the reasons above, it must be concluded that Austin was not well reasoned. The government defends Austin. Citizens United v. Federal Elections COMMN opinion of the court. Relying almost entirely on the quid pro quo interest, the corruption interest or the shareholder interest, and not Austin's expressed anti-distortion rationale. TR of Oral Arg 48, September 9, 2009, CID, at 45-46. When neither party defends the reasoning of a precedent, the principle of adhering to that precedent through stare decisis is diminished. Austin abandoned First Amendment principles, furthermore, by relying on language in some of our precedents that traces back to the Automobile Workers' Court's flawed historical account of campaign finance laws. See brief for campaign finance scholars as Amici Curiae, Hayward, 45 Harv. J. Legis,
I keep using the sleep mechanic in this game to just get it to be daytime, because while I'm laying in bed like this and like I have my virtual screen set kind of far away, it's just impossible to see in the darkness in this game. So I just set it to morning as soon as I can every time. Oh, I'm definitely in the dunes. This is like not a good area to be in right now. This is bad. Well, whatever.
Quoting automobile workers, 352 US at 585, MPAC, Supra at 500. Quoting NRWC, 459 US at 210, ID at 208. The
Can I go
history
down
of the
there?
movement to regulate the political contributions and expenditures of corporations and labor unions is set forth in great detail in Automobile Workers, Supra, at 570 to 584, and we need only summarize the development here. Austin is undermined by experience since its announcement. Political speech is so ingrained in our culture that speakers find ways to circumvent campaign finance laws.
Yes, they said that before.
McConnell, 540 US, at 100.
Uh-oh, it's not repeating, isn't it? Am I moving forward or no? No, it's just documents like these tend to repeat the exact same sentence multiple times.
Campaign finance laws. See, e.g., McConnell, 540 US, at 176 to 177, given BCRA's title
God,
restrictions.
academic writing is so difficult to read without getting bored. Though I guess it could be argued that I am more resilient to its mind-numbing effects than a lot of people, probably.
And informative voices should not have to circumvent onerous restrictions to exercise their First Amendment rights. Speakers have become adept at presenting citizens with sound bites, talking points, and scripted messages that dominate the 24-hour news cycle. Corporations, like individuals, do not have monolithic views on certain topics. Corporations.
No, they almost guaranteedly have monolithic views on a certain topic, and that topic is making money.
Errors or fallacies in speech of all sorts, including the speech of candidates and elected officials. Rapid changes in technology and the creative dynamic inherent in the concept of free expression counsel against upholding a law that restricts political speech in certain media or by certain speakers. See Part 2C, Supra. Today, 30-second television ads may be the most effective way to convey a political message. See McConnell, Supra, at 261.
Again, obviously the Supreme Court can't change society manually. Their job is to look at these stupid cases and pretend to be politically neutral. But can't they just step up and be like, oh, maybe we should reevaluate like how we do speech and communication between powerful groups and everyone else? Maybe we should like reevaluate how we do that stuff. Maybe 30-second television ads like aren't great or conducive to a truly viable and enlightened and informed political society. I don't know.
No serious reliance interests are at stake. As the court stated in Payne v. Tennessee, 501 U.S. 808, 828, 1991, reliance interests are important considerations in property and contract cases, where parties may have acted in conformance with existing legal rules in order to conduct transactions. Here, though, parties
The ultimate peeper,
have been banned from making independent expenditures.
Impossible to catch.
Legislatures may have enacted bans on corporate expenditures believing that those
The
bans
ultimate
were
peeper, come
constitutional.
here.
This is not a compelling interest for stare
Super
decisis.
peeper.
If it were, legislative acts could prevent us from overruling our own precedents, thereby interfering with our duty to say what the law is.
Oh, I have two peepers on me. Very funny.
1 Cranch 137, 177, 1803. Due consideration leads to this conclusion, Austin, 494. Citizens United v. Federal Elections COMMN. Opinion of the court. US 652 should be and now is overruled. We return to the principle established in Buckley and Bellotti that the government may not suppress political speech on the basis
of a speaker's corporate identity. Yeah.
No sufficient governmental interest justifies limits on the political speech of non-profit or for-profit corporations. D. Austin is overruled, so it provides no basis for allowing the government to limit corporate independent expenditures. As the government appears to concede, overruling Austin effectively invalidate not only BCRA Section 203, but also 2 U.S.C. for 41B's prohibition on the use of corporate treasury funds for express advocacy. Brief for Appellee 33 and 12. Section 441B's restrictions on corporate independent expenditures are therefore invalid and cannot be applied to Hillary. Given our conclusion, we are further required to overrule the part of McConnell that upheld BCRA Section 203's extension of Section 441B's restrictions on corporate independent expenditures. See 540 U.S. at 203 to 209. The McConnell court relied on the anti-distortion interest recognized in Austin to uphold a greater restriction on speech than the restriction upheld in Austin, see 540 U.S. at 205, and we have found this interest unconvincing and insufficient. This part of McConnell is now overruled. 4A.
Okay, wow. Now they're getting into the very specific outcomes.
Provisions as applied to Hillary and the 3 advertisements for the movie. Under BCRA Section 311, televised electioneering communications.
Okay, so interesting. We are on like page what? 57? And they just kind of officially wrapped up like, hey, here's what's being overruled and here's the new court precedent. So essentially the first half of this document, because now it sounds like they're transitioning, maybe they'll talk more about it, but that seemed pretty decisive and clear. The first half of this document was going over the idea about whether or not the government can censor speech on the basis of a person's corporate identity. Whether or not the speaker, and the issue here is that they don't define human the way you and I do. They define human by like capacity for speech. So, and I don't mean like verbally or cognitively. I mean like as a construct. So a speaker could have been an individual, but a speaker can now also be a group with like a business name. And previously it was okay to discriminate on whether or not you were a true individual or you were corporate. You could be affiliated with a party, but you are still an individual. You could say that you're representing a party. You could be on someone's campaign and being paid through small dollar donations. All of that was fine. But if you were a corporation investing in campaign advertisement, you could be censored. And now, after this decision, after what they just said, it doesn't matter if you are if you are BlackRock. It doesn't matter if you are Elon Musk's different corporations. It doesn't matter. You are allowed to make campaign advertisements that affect the outcomes of actual elections. Only guy watching right now. Check Discord. I'll check the Discord. Sorry. That sounds very fun. Yeah, I'm not surprised that no one else is watching. I'm definitely in my head just talking to myself, really. But that's what the first half of this document is. It is saying that the Supreme Court, the United States, cannot judge on the basis of So they're saying, right, that the Supreme Court cannot, the whole of the U.S. government cannot limit a group's speech just because they are a corporation, which obviously this had terrible and incomprehensible negative effects for the rest of American society moving forward. Now they're going to transition to the next challenge. So the Supreme Court case was 2 challenges wrapped into one. The first challenge was, hey, we are a corporation and we should be allowed to do free speech. That's what they were calling free speech, but we should be allowed to publish and distribute propaganda about elections, even though we're a corporation with $1 million. $12 million, I think, is how much Citizens United is worth or was worth, can't remember. And then their second challenge was also we shouldn't have to include a disclaimer for who paid for the advertisement because privacy. So they neither want to be able to be held accountable for their speech, and they also want to do it as freely as they want with as much money as they have. Let's see. 952 is 950. Okay, one sec. What these are? I've got a lot of people suddenly messaging me. Okay, back to actually streaming. So, yeah, first half of this document was essentially, we should be allowed to speak freely even though we are a multi-million-dollar company with far more influence than any individual person could ever possibly hope to have. Let us do free speech, just as much as an individual. Okay, so the Supreme Court somehow said, okay, sure. And now the second part is going to be, also, you shouldn't make us include a disclaimer for who is responsible for the content of the advertising. Usually it's a, when a politician does it, it says, this video has been sponsored by or brought to you by Michelle Obama or Kamala Harris or whoever did the advertisement. And Citizens United is like, also, we shouldn't have to denote who paid for this. What?
Citizens United next challenges BCRA's disclaimer and disclosure provisions as applied to Hillary and the 3 advertisements for the movie. Under BCRA Section 311, televised electioneering communications funded by anyone other than a candidate must include a disclaimer that ________________
That's actually so reasonable.
the content of this advertising.
You should absolutely be required to say who's responsible for the advertisement. Absolutely. That's nothing but reasonable.
Opinion of the court must be made in a clearly spoken manner and displayed on the screen in a clearly readable manner for at least 4 seconds. Ibid. It must state that the communication is not authorized by any candidate or candidates committee. It must also display the name and address, or website address, of the person or group
website
that
address would make sense. Not physical address, that's aggressive.
A3. Under BCRA Section 201, any person who spends more than $10,000 on electioneering communications within a calendar year must file a disclosure statement with the FEC. 2 U.S.C. Section 4.
The craziest thing is that I consider all of these so reasonable.
Must identify the person making the expenditure, the amount of the expenditure, the election to which the communication was directed, and the names of certain contributors.
I've already been here in the game.
Section 434, F2. Disclaimer and disclosure requirements may burden the ability to speak, but they impose no ceiling on campaign-related activities. Buckley, 424 U.S. at 64, and do not prevent anyone from speaking. McConnell, Supra, at 201, internal quotation marks and brackets omitted. The court has subjected these requirements to exacting scrutiny, which requires a substantial relation between the disclosure requirement and a sufficiently important governmental interest. Buckley, Supra, at 64, 66, internal quotation marks omitted. See McConnell, Supra, at 231. 232. In Buckley, the court explained that disclosure could be justified based on a governmental interest in Provid, ing, the electorate with information about the sources of election-related spending. For 24 U.S. at 66.
And one of the things that confuses me so much about how they ended up ruling in this is that they talk about the free market of ideas, which is something that Americans are so obsessed with. Like, we say we care about free speech, but I think ultimately we care more about the whole, market aspect of speech. The idea of, competing speech, which obviously is important for discourse, but, they just obsess over it way too hard. Oh, I'm just not doing well in this game recently. Yeah, we'll start up the audio again in a moment. I'm getting my butt kicked. Everything in this game is killing me. Right, because I'm trying to listen to a freaking Supreme Court document while also playing, and I'm definitely prioritizing the document over gameplay. Okay, let me save real quick. Start up the audio again. Yeah, they're obsessed with the free market of ideas, but then they want to make it easier to hide behind essentially anonymity. So how is it a free market of ideas if there's no finding out following acts of fucking around? How is that a free market of ideas if you can get away with being anonymous? Now you're just back to the internet, and as we all know, that is not a good system for discourse.
66. The McConnell Court applied this interest in rejecting facial challenges to BCRA sections 201 and 311. 540 U.S. at 196. There was evidence in the record that independent groups were running election-related advertisements while hiding behind dubious and misleading names.
Yeah, that's the entire problem.
Quoting McConnell I. 251F Sup 2D at 237. The court therefore upheld BCRA sections 201 and 311 on the ground that Citizens United v. Federal Elections COMMN opinion of the court. They would help citizens make informed choices in the political marketplace. 540 U.S. at 197.
Oh my god, let's not call it a marketplace. They get so obsessed with this.
See 540 U.S. at 231. Although both provisions were facially upheld, the court acknowledged that as-applied challenges would be available if a group could show a reasonable probability that disclosure of its contributors' names will subject them to threats, harassment, or reprisals from either government officials or private parties. Okay,
so this is kind of like anti-slander law, right? Like, I almost get it.
For the reasons stated below,
but like, if your speech is going to expose you to potential threats to your well-being, and it's not like a threat from like some individual extremist or something, as the word that they would use is extremist or something, if that's not going to be the threat, then I don't know, maybe you just shouldn't have such an opinion that like people fear for their lives. Again, there should be more finding out. This whole document feels like it's like, yes, the Supreme Court supports fucking around, but the Supreme Court does not support finding out.
Federal Reg 72901, 2007. Citizens United argues that the disclaimer requirements in Section 311 are unconstitutional as applied to its ads. It contends that the governmental interest in providing information to the electorate does not justify requiring disclaimers for any commercial advertisements, including the ones at issue here. We disagree. The ads fall within BCRA's definition of an electioneering communication. They referred to then-Senator Clinton by name.
One sec, let me see. What do they disagree with? Citizens United argues that the disclaimer requirements in 311 are unconstitutional as applied to its ads. It contends that governmental interest in providing information to the electorate does not justify requiring disclaimers for any commercial advertisements, including the ones at issue here. We disagree. Good. So it looks like the Supreme Court on this half of their argument is going to say, no, you do need to say who paid for this. I cannot believe that Citizens United tried to argue that they should be able to literally hide who was paying for the ad.
Shortly before a primary and contained pejorative references
Crazy.
to candidacy. See 530F Sup 2D at 276 NN 2 to 4. The disclaimers required by Section 311 provide the electorate with information, McConnell, Supra, at 196, and ensure that the voters are fully informed about the person or group. Opinion of the court. Who is speaking? Buckley, Supra, at 76, see also Bellotti, 435 U.S., at 792, and 32. Identification of the source of advertising may be required as a means of disclosure, so that the people will be able to evaluate the arguments to which they are being subjected. At the very least, the disclaimers avoid confusion by making clear that the ads are not funded by a candidate or political party. Citizens United argues that Section 311 is under-inclusive because it requires disclaimers for broadcast advertisements but not for print or internet advertising. It asserts that Section 311 decreases both the quantity and effectiveness of the group's speech by forcing it to devote 4 seconds of each advertisement to the spoken disclaimer.
Oh my God, they're complaining about how many seconds has to go to it? They're insane.
230 to 231. And we now adhere to that decision as it pertains to the disclosure provisions. As a final point, Citizens United claims that, in any event, the disclosure requirements in Section 201 must be confined to speech that is the functional equivalent of express advocacy.
Oh, so we can say things as long as it's not vote for this person or vote against that person.
Section 441B's restrictions on independent expenditures to express advocacy and its functional equivalent. 551. U.S. at 469 to 476, opinion of Roberts, C.J. Citizens United seeks to import a similar distinction into BCRA's disclosure requirements. We reject this contention.
Okay.
The court has explained that disclosure is a less restrictive alternative to more comprehensive regulations of speech. See, e.g., MCFL 470.
So the only reason they're going to continue making people disclose who paid for the advertisements is simply because they consider it less restrictive to free speech than other methods of regulation.
For 24 U.S. at 75.
But to me, as a normal human being, this is a fundamental discussion about the idea that if you're going to say something, you need to be able to be held accountable for it.
540. U.S. at 321, opinion of Kennedy, J., joined by Rehnquist, C.J., and Scalia, J. And the court has upheld Regis Tra. Citizens United v. Federal Elections COMMN. Opinion of the court. Tie-in and disclosure requirements on lobbyists, even though Congress has no power to ban lobbying itself. United States v. Harris, 347 U.S. 612, 625, 1954. Congress has merely provided for a modicum of information from those who for hire attempt to influence legislation or who collect or spend funds for that purpose. For these reasons, we reject Citizens United's contention that the disclosure requirements must be limited to speech that is the functional equivalent of express advocacy. Citizens United also disputes that an informational interest justifies the application of Section 201 to its ads, which only attempt to persuade viewers to see the film. Even if it disclosed the funding sources for the ads, Citizens United says, the information would not help viewers make informed choices in the political marketplace. This is similar to the argument rejected above with respect to disclaimers. Even if the ads only pertain to a commercial transaction, the public has an interest in knowing who is speaking about a candidate shortly before an election. Because the informational interest alone is sufficient.
Oh, more people are checking in. Hello. Hope everyone's doing good.
It is not necessary to consider the government's other asserted interests. Last, Citizens United argues that disclosure requirements can chill donations to an organization by exposing donors to retaliation. Some amici point to recent events.
Interesting to see other people are tuning in. That's very cool. Well, if anyone wants a quick basic summary of what I am reading about, oh dear. This is a Supreme Court opinion, so the Supreme Court is the highest court in the United States. They don't write laws, they just interpret them at the highest level. And they usually interpret laws at the level of the U.S. Constitution itself. This, in the year of, I believe, 2007, a nonprofit political organization, a conservative nonprofit political organization, wanted to, they made a movie targeting Hillary Clinton, who I don't really care about the topic of the movie, but they made a movie targeting Hillary Clinton. And before they did this, they knew that it was illegal for a giant corporation to release a giant piece of propaganda to the public right before an election with the purpose of making them vote against Hillary Clinton. They knew this was illegal. So they planned to get lawyers to speak at federal courts to make arguments that would allow them to use their amounts of money, their corporate money, for political propaganda connected to elections. This is the Supreme Court's opinion after essentially 3 years of discussing the topic. This was published in 2010 and officially changed the law in the United States by interpreting the law such that corporations, no matter how big, no matter how many billions of dollars they have, this 2010 decision made it so anyone could use any amount of money to make propaganda and release it publicly connected to an election. Like, as long as the speech and the propaganda wasn't full-on hate speech, they could say things like, hey, you know, white people are supreme and we deserve XYZ. Like, they could do anything. As long as they didn't call for violence against a group of people or use traditional hate speech, they were allowed to do it. And if they had $50 billion to completely carpet bomb all of YouTube and all of TikTok and all of your entire life, they are allowed to do that. So that's the first half of this court case from 2010. The second half is about whether or not those advertisements should have to disclose who paid for them. And it looks like the Supreme Court is going to say, yes, you have to disclose who paid for these advertisements. You can't just use billions of dollars to carpet bomb social media without saying who is the one that paid for these advertisements. So they're saying, yes, you can advertise with billions of dollars, but no, you can't get off scot-free. You have to put your name behind the advertisement. And then again, this was a Supreme Court decision in 2010 in the United States. So everything we've seen since then, about 15 years, right, has something to do with the fact that it became legal to do this kind of advertising in the first place. All right, back to reading.
Targeted for retaliation. See brief for Institute for Justice as Amicus Curiae.
Oh my God, get off of me.
Brief for Alliance Defense Fund as Amicus Curiae 16-22. In McConnell, the court recognized that Section 201 would be unconstitutional as applied to an organization if there were a reasonable probability that the group's members would face threats or harassment
Leave me
or reprisals if their
alone.
names were disclosed. 540 U.S. at 198. The examples cited by Amici are cause for concern. Citizens United, however, has offered
Leave me
no
alone.
evidence that its members may face similar
Leave me alone.
opinion of the court. Threats or reprisals. To the contrary, Citizens United has
Leave
been
me
disclosing
alone.
its donors for years and has identified no instance of harassment or retaliation. Shareholder objections raised through the procedures of corporate democracy, see Belotti, Supra, at
I'm in space.
794 and N34, can be more effective today because modern technology makes disclosures rapid and informative. A campaign finance system that pairs corporate independent expenditures with effective disclosure has not existed before today. It must be noted, furthermore, that many of Congress's
Oh my God, he is
policies
pushing me
passed in the CRA
sideways.
were premised on a system without adequate disclosure.
Yeah, I know.
See McConnell,
Oh, now there's two of them. Great.
540.
Great.
US at 128. The public may not have been fully informed about the sponsorship of so-called issue ads, ID, at 196 to 197, quoting McConnell I, 251F, Suppa 2D, at 237. With the advent of the internet, prompt disclosure of expenditures can provide shareholders and citizens with the information needed to hold corporations and elected officials accountable for their positions and supporters. Shareholders can determine whether their corporation's political speech advances the corporation's interest in making profits, and citizens can see whether elected officials are in the pocket of so-called moneyed interests. 540 U.S. at 259, opinion of Scalia, J. as the MCFL, Supra, at 261. The First Amendment protects political speech, and disclosure permits citizens and shareholders to react to the speech of corporate entities in a proper way. This transparency enables the electorate to make informed decisions and give proper weight to different speakers and messages. See, for the same reasons we uphold the application of BCRA sections 201 and 311 to the ads, we affirm their application to Hillary. We find no constitutional impediment to the application of BCRA's disclaimer and disclosure re. Citizens United v. Federal Elections COMMN. Opinion of the court. Requirements to a movie broadcast via video on demand. And there has been no showing that, as applied in this case, these requirements would impose a chill on speech or expression. When word concerning the plot of the movie Mr. Smith Goes to Washington reached the circles of government, some officials sought, by persuasion, to discourage its distribution. See Smudden, compulsory viewing for
Oh, what is this? Mr.
Mr.
Smith
and the
Goes to
Rhetoric of
Washington.
Reception, 35 Cinema Journal 3,
What is
19,
this?
and Anna 52, Winter 1996, citing Mr. Smith Riles Washington, time, October 30th, 1939, page
1939. How old is this? What?
Capital offense, NY Times, October 29th, 1939, PX5.
What in the world kind of court precedent are they talking about? From before World War II?
More than discourage its distribution, they could have banned the film. After all, it, like Hillary, was speech funded by a corporation that was critical of members of
Oh, except it... Ooh,
Mr.
interesting.
Smith Goes to Washington may be fiction.
So we already had the legal precedent that corporations could do free speech in general if it wasn't directly connected to an ongoing campaign for political office via the democratic process. So, interesting. One of the interesting things about this document as I continue to read it is it makes me rethink my relationship with free speech to like a very significant degree. Like I used to at one point consider myself a pretty literal free speech absolutist, but I always thought it was common sense that speech is something that is done by an individual human being, not a group or conglomerate. And I also believed that speech was something that you do kind of with your, how do I describe this? Like speech is a thing that a person should make with their name behind it and kind of like putting their name on it almost publicly, which I know has issues because there's good logic stating that like anonymity is very powerful for free speech. It's very important to have anonymity in times where the government may be so oppressive and dangerous that you can't speak safely otherwise. But I guess in thinking about the United States, I've always imagined that like free speech refers to using your name and face and publicly saying something as an individual. But the idea of like, oh, I have billions of dollars, so I'm just going to record myself saying it and force YouTube and TikTok to show everyone the same advertisement 500 times saying that, you know, RFK Jr. is a lizard person and he wants to eat my children. Like, I never considered that free speech because you're not using the person, you're using the money, right? So maybe like the difference to me is what is the mechanism of speech? Is it the person? Is it the brain behind the person that's doing the speech, or is it the money that's making the speech happen? The thing that's argued earlier on in this document is that all speech requires money because, you know, even if you're just physically speaking with your mouth, that means you need calories and you had to pay for those calories somewhere.
Television comedies,
Stuff like that.
on YouTube.com might portray public officials or public
Oh,
policies
hey, now they're
in
talking about that
flattering
stuff.
ways. Yet if a covered transmission during the blackout period creates the background for candidate endorsement or opposition, a felony occurs solely because a corporation, other than an exempt media corporation, has made the purchase, payment, distribution, loan, advance, deposit, or gift of money or anything of value in order to engage in political speech. 2 U.S.C. Section 431(9)(a)(I). Speech would be suppressed in the realm where its necessity is most evident, in the public dialogue preceding a real election. Governments are often hostile to speech, but under our law and our tradition it seems stranger than fiction for our government to make this political speech a crime. Yet this is the statute's purpose and design. Some members of the public might consider Hillary to be insightful and instructive, some might find it to be neither high art nor a fair discussion on how to set the nation's course, still others simply might suspend judgment on these points but decide to think more about issues and candidates. Those choices and assessments, however, are not for the government to make. The First Amendment underwrites the freedom to experiment and to create in the realm of thought and speech. Citizens must be free to use new forms and new forums for the expression of ideas. The civic discourse belongs to the people, and the government may not prescribe.
I am not someone who uses TikTok too aggressively, even though I've thought about it before, but it's weird to read this document and then see that the United States government is trying to ban TikTok, which is definitely like a very good forum of public free speech, especially for younger generations. It's kind of weird to see them saying stuff that's so antithetical
with this
to what
opinion.
the government is currently doing now
It is
regarding
so
social medias.
Roberts, C.J., concurring.
But I have complicated opinions on that sort of thing too, so I don't really know.
Number 08205. Citizens United, Appellant v. Federal Election Commission. On appeal from the United States District Court for the District of Columbia. January 21, 2010. Chief Justice Roberts, with whom Justice Alito joins, concurring. The government urges us in this case to uphold a direct prohibition on political speech. It asks us to embrace a theory of the First Amendment that would allow censorship not only of television and radio broadcasts, but of pamphlets, posters, the internet, and virtually any other medium that corporations and unions might find useful in expressing their views on matters of public concern.
Again, I just don't think corporations or unions should be allowed to do free speech in the place of individual humans.
Or opposing candidates for office, so long as the newspapers were owned by corporations, as the major ones are. First Amendment rights could be confined to individuals, subverting the vibrant public discourse that is at the foundation of our democracy. The court properly rejects that theory, and I join its opinion in full. The First Amendment protects more than just the individual on a soapbox and the lonely pamphleteer. I write separately to address the important principles of judicial restraint and stare decisis implicated in this case. I judging the constitutionality of an act of Congress is 2 Citizens United v. Federal Elections COMMN. Roberts, C.J., concurring. The gravest and most delicate duty that this court is called upon to perform. Blodgett v. Holden, 275 U.S., 142, 147 to 148, 1927, Holmes, J., concurring. Because the stakes are so high, our standard practice is to refrain from addressing constitutional questions except when necessary to rule on particular claims before us. C. Ashwander v. TVA, 297 U.S., 288, 346 to 348, 1936, Brandeis,
Wow.
J., concurring. This policy underlies both our willingness to construe ambiguous statutes to avoid constitutional problems and our practice never to formulate a rule of constitutional law broader than is required by the precise facts to which it is to be applied. United States v. Raines, 362. U.S. 17, 21, 1960, quoting Liverpool, New York and Philadelphia Delphia Estes, Company v. Commissioners of Immigration, 113. U.S. 33, 39, 1885. The majority and dissent are united in expressing allegiance to these principles. Ante, at 12, Post, at 14, Stevens, J., concurring in part and dissenting in part. But I cannot agree with my dissenting colleagues on how these principles apply in this case. The majority's step-by-step analysis accords with our standard practice of avoiding broad constitutional questions except when necessary to decide the case before us. The majority begins by addressing, and quite properly rejecting, Citizens United's statutory claim that 2 U.S.C. Section 441b does not actually cover its production and distribution of Hillary, the movie, Hereinafter Hillary. If there were a valid basis for deciding this statutory claim in Citizens United's favor, and thereby avoiding constitutional adjudication, it would be proper to do so. Indeed, that is precisely the approach the court took just last term in Northwest Austin Municipal Udall. DIST No. 1 versus Holder, 557 U.S. ____, 2009, when 8 members of the court agreed to decide the case on statutory grounds instead of reaching the appellant's broader argument that the Voting Rights Act is unconstitutional. It is only because the majority rejects Citizens United's statutory claim that it proceeds to consider the group's various constitutional arguments, beginning with its narrowest claim, that Hillary is not the functional equivalent of express advocacy, and proceeding to its broadest claim, that Austin versus Michigan Chamber of Commerce, 494. U.S. 652, 1990, should be overruled. This is the same order of operations followed by the controlling opinion in Federal Election Com. v. Wisconsin Right to Life Incorporated, 551 U.S. 449, 2007, WRTL. There the appellant was able to prevail on its narrowest constitutional argument because its broadcast ads did not qualify as the functional equivalent of express advocacy. There was thus no need to go on to address the broader claim that McConnell v. Federal Election Comment 540 U.S. 93, 2003, should be overruled. WRTL 551 U.S. at 482, ID at 482 to 483, Alito, J.
It looks like I have to go this direction of the game right now.
Not, as the dissent suggests, because the approach taken in WRTL has been deemed a failure, post, at 11, but because, in the absence of any valid narrower ground of decision, there is no way to avoid Citizens United's broader constitutional argument. The dissent advocates an approach to addressing Citizens United's
God, this is a scary environment.
Perplexing. It presumably agrees with the majority that Citizens United's narrower statutory and constitutional arguments lack merit, otherwise its conclusion that the group should lose this case would make no sense. Despite agreeing that these narrower arguments fail, however, the dissent argues that the majority should nonetheless latch onto one of them in order to avoid reaching the broader constitutional question of whether Austin remains good law. It even suggests that the court's failure to adopt one of these conceitedly meritless arguments is a sign that the majority is not serious about judicial restraint. Post, at 16. This approach is based on a false premise, that are Citizens United v. Federal Election COMMN Roberts, CEJ, concurring. Practice of avoiding unnecessary, and unnecessarily broad, constitutional holdings somehow trumps our obligation faithfully to interpret the law. It should go without saying, however, that we cannot embrace a narrow ground of decision simply because it is narrow, it must also be right. Thus, while it is true that
oh my god, so much logical rhetoric.
It is necessary not to decide more.
Man, at least I'm understanding. At least I'm learning something.
Sometimes it is necessary.
Still, this is a lot.
There is a difference between judicial restraint and judicial abdication. When constitutional questions are indispensably necessary,
hey, I'm in the right place finally.
The court must meet and decide them. Ex part Randolph, 20
Go away.
Cass. 242, 254, number 11, 558, CC Virginia 1833, Marshall, C.J. Because it is necessary to reach Citizens United's broader argument that Austin should be overruled, the debate over whether to consider this claim on an saplight or facial basis strikes me as largely beside the point. Citizens United has standing, it is being injured by the government's enforcement of the act. Citizens United has a constitutional claim, the act violates the First Amendment, because it prohibits political speech. The government has a defense, the act may be enforced, consistent with the First Amendment, against corporations. Whether the claim or the defense prevails is the question before us. Given the nature of that claim and defense, it makes no difference of any substance whether this case is resolved by invalidating the statute on its face or only as applied to Citizens United. Even if considered in as-applied terms, a holding in this case that the act may not be applied to Citizens United because corporations as well as individuals enjoy the pertinent First Amendment rights would mean that any other
I found the entrance
the same challenge would also win.
To the Lost River.
Likewise, a conclusion that the act may be applied to Citizens United because it is. Roberts, C.J., concurring. Constitutional to prohibit corporate political speech would similarly govern future cases. Regardless whether we label Citizens United's claim a facial or as-applied challenge, the consequences of the court's decision are the same. Point 1. To the text and purpose of the First Amendment point in the same direction, Congress may not prohibit political speech, even if the speaker is a corporation or union. What makes this case difficult is the need to confront our prior decision in Austin. This is the first case in which we have been asked to overrule Austin, and thus it is also the first in which we have had reason to consider how much weight to give stare decisis in assessing its continued validity. The dissent erroneously declares that the court reaffirmed Austin's holding in subsequent cases, namely, Federal Election Com. v. Beaumont, 539 U.S. 100.
Alright, I have found the Lost River. This is very important for game progress.
Post, at 48 to 50. Not so. Not a single party in any of those cases asked us to overrule Austin, and as the dissent points out, post, at 4 to 6, the court...
So, mouth exhaust. Regarding the section that's being read right now, now what they're getting into is focusing in on the original context of the case itself, right? So Citizens United was a nonprofit conservative advocacy organization. They went to the federal court to make these arguments based on pre-existing court cases. So there's a couple that you'll hear mentioned like 5 different times, but all you really need to know is that these previous court cases, which will always sound like, oh yeah, like Austin versus Michigan Chamber of Commerce, these previous court cases went to the Supreme Court, and the Supreme Court said, okay, we are allowed to, they didn't rule that the Supreme Court or the government was allowed to censor free speech for corporations, but they also didn't say no or yes. So they ruled that it was a gray area. And what they're going to keep mentioning throughout the rest of this section is the original context of, hey, we as the Supreme Court left this gray. We generally don't want corporations to do this kind of propaganda and get away with it. But we also aren't going to say no to it entirely because the Supreme Court tries to be extremely careful about what it says yes or no to. Now it's just rehashing some of the worst thing about this document is that it said the same 5 things like 10 different times.
Constitutional arguments that have not properly been raised. Austin's validity was therefore not directly at issue in the cases the dissent cites. The court's unwillingness to overturn Austin in those cases cannot be understood as a reaffirmation of that decision.
Okay, yeah, that perfectly summarizes everything in this section. The court's unwillingness to overturn Austin in those cases cannot be understood as a reaffirmation of that decision. So Austin was one of these prior court cases that essentially helped them rule that either advertising needs to have a disclaimer of who paid for it, or this is about independent expenditure, which is the using of money by a corporation for political means, not connected directly to a candidate, but instead for their own propaganda and advocacy. Austin was one of these previous court cases that they ruled on, and what the court is trying to say is that the court didn't want to overturn it, but that also doesn't mean that they are 100% agreeing with it. So that's the annoying thing, is that they're just talking about, hey, we tried our best, and now they're really focusing on this idea of stare decisis, which is one of these Latin things. Stare decisis, the legal principle determining points in litigation according to precedent. Okay, so that's kind of what I was getting at. The idea is that the Supreme Court should follow existing precedent, but existing precedent shouldn't also prohibit them from reevaluating things. So this entire section is just going to be talking about the history of other Supreme Court cases and whether or not departure from precedent is allowed or not allowed. Whether or not you're allowed to look at history and say no, or change how the court has worked historically because new evidence has been provided to them. So they're just going to go over 20 different court cases.
That I am much too quick to reach this conclusion because I ignore Citizens United's narrative.
Where are we at now? Yeah. Stare decisis. Stare decisis.
Federal Election COMMN Roberts, CEJ, concurring. UCAS 203, 212, 1984. At the same time, stare decisis is neither an inexorable command. Lawrence versus Texas, 539 U.S. 558, 500.
So stare decisis is just an informally agreed upon rule for how Supreme Courts should operate.
1940, especially in constitutional cases, see United States versus Scott, 437 U.S. 82, 101, 1978. If it were, segregation would be legal, minimum wage laws would be unconstitutional, and the government could wiretap ordinary criminal suspects with...
Crazy. At the same time, stare decisis is neither an inexorable command. So they're saying we need to follow our history, but obviously they're acknowledging that throughout the United States history, we have overruled the Constitution several times. We've amended it and we've reinterpreted it multiple times. The one that I know was Brown versus Board of Education. So, Yeah, stare decisis is neither an inexorable command nor a mechanical formula for adhering to the latest decision. If it were, segregation would be legal, minimum wage laws would be unconstitutional, and the government could wiretap ordinary criminal suspects without first obtaining warrants. So that's Plessy versus Ferguson was, I actually know some of these. Plessy versus Ferguson was segregation. Brown versus Board was segregation in schools. I don't know the rest of these. Atkins versus Children's Hospital, DC, I don't know these ones that well. But they're just talking about how stare decisis is instead a principle of policy. So it's just an idea that they like to follow. And the question comes whether or not can they or should they overturn their previous agreements just because they've been presented new evidence. So their previous agreement was, hey, generally speaking, corporations can't do political propaganda next to a campaign happening. Can't happen at the same time. Now they're debating amongst themselves, well, should we try to stick to what we've done before or should we change? And obviously they voted to change and allow corporations to invest in campaigns like this.
Covering Supra at 119. When considering whether to re-examine a prior erroneous holding, we must balance the importance of having constitutional questions decided against the importance of having them decided right. As Justice Jackson explained, this requires a sober appraisal of the disadvantages of the innovation as well as those of the question case, a weighing of practical effects of one against the other. Jackson, Decisional Law and Stare Decisis, 30 ABJ 334, 1944. In conducting this balancing, we must keep in mind that stare decisis is not an end in itself. It is instead the means by which we ensure that the law will not merely change erratically, but will develop in a principled and intelligible fashion. Vasquez versus Hillary, 474 U.S. 254, 265, 1986. Its greatest purpose is to serve a constitutional ideal, the rule of law. It follows that in the unusual circumstance when fidelity to any particular precedent does more to damage this constitutional ideal than to advance it, we must be more willing to depart from that precedent. Thus, for example, if the precedent under consideration itself departed from the court's jurisprudence, returning to the intrinsically sounder doctrine established in prior cases may better serve, the values of stare decisis than would following, the more recently decided case inconsistent with the decisions that came before it. Adaran Constructors Incorporated via Pena, 515 U.S. 200, 231, 1995, see also Helvering, Supra, at 119, Randall, Supra, at 274, Stevens, J., dissenting. Abrogating the errant precedent, rather than reaffirming or extending it.
Oh my god, I've never seen the word abrogating in my entire life. Abrogating. Ending a law? A head of state or member of royal family voluntarily renouncing a position. Abrogating refers to ending a law, agreement, or custom. Oh, so breaking away from their stare decisis idea of always following precedent. Is it when they said not to raise broad constitutional questions? Essentially, like what they're saying is we cannot attempt to reconsider previous agreements. We should just operate on the ones that we have for the sake of being consistent, which would have been a great argument for not allowing corporations to affect campaigns, because that's what they had ruled previously. But that is one of their things that they're really obsessed with. They really, really do not like doing cases that address broad constitutional questions, because what they want to focus on is only things that have a very narrow definition that they can actually debate over and write really specific and actionable policy and interpretations about. Which definitely changes, actually, my previous understanding of how the Supreme Court works. I always thought their entire job was to interpret broad questions, but no, I was just taught the broad question once, like Plessy versus Ferguson as a kid.
Likewise, if adherence to a precedent actually impedes the stable and orderly adjudication of future cases, its stare decisis effect is also diminished. This can happen in a number of circumstances, such as when the precedent's validity is so hotly contested that it cannot reliably function as a basis for decision in future cases, when its rationale threatens to upend our settled jurisprudence in related areas of law, and when the precedents underlying Citizens United v. Federal Election COMMN Roberts, CEJ, concurring. Reasoning has become so discredited that the court cannot keep the precedent alive without jury-rigging new and different justifications to shore up the original mistake. See, e.g., Pearson vs. Callahan, 555 U.S. ___________, 2009, slip up, at 10, Montejo vs. Louisiana, 556 U.S. __________, 2009, slip up, at 13, stare decisis does not control when adherence to the prior decision requires fundamentally revising its theoretical basis. These considerations weigh against retaining our decision in Austin. First, as the majority explains, that decision was an aberration insofar as it departed from the robust protections we had granted political speech in our earlier cases. Ante, at 39, see also Buckley, Supra, First Nat Bank of Boston vs. Bellotti, 435 U.S. 765, 1978. Austin undermined the careful line that Buckley drew to distinguish limits on contributions to candidates from limits on independent expenditures on speech. Buckley rejected the asserted government interest in regulating independent expenditures, concluding that restrict, the speech of some elements of our society in order to enhance the relative voice of others is wholly foreign to the First Amendment.
Ooh, interesting. What did they just say? Okay. Buckley rejected the asserted government interest in regulating independent expenditures, concluding that restricting the speech of some elements of our society in order to enhance the relative voices of others is wholly foreign to the First Amendment. So what they are saying is that the United States history, the First Amendment of the U.S. Constitution, does not agree with the idea of equity, of social equity, the idea of lifting up some voices and regulating others in pursuit of giving everyone an equal playing field. I really should look up this Buckley Supreme Court case, because I've heard it about 20 times. Yeah, I'll Google it real quick. Okay, landmark decision on campaign finance. A majority of justices held that limits on election expenditures are unconstitutional. So this was limits. This was about how much money a person could put into. Was it independent expenditures or something else? So wait, again, is this direct oh, this was campaign contributions. So this was direct contributions. So Buckley was just a previous court case that said people are allowed to put as much money into their candidates as they want. This is the reason that Elon Musk is allowed to give people hundreds of millions of dollars. Even though no individual human being could ever even realistically hope to do that. So they're using that precedent about the fact that it interpreted the First Amendment to not make room for the fact that multi-billionaires exist. They're using that as reason to argue that corporations should be allowed to independently make as much propaganda as they want similarly. Austin, however, allowed the government to prohibit these same expenditures out of concern for the corrosive and distorting effects of immense aggregations of wealth in the marketplace of ideas. Consistent. So these are two conflicting court cases. Austin Supreme Court case. No, that doesn't seem right. Supreme Court case. Independent expenditures. This was Austin versus Michigan State of Chamber of Commerce. So again, these are just previous court case rulings that kind of contradict each other. Can just pour $1 trillion like that? Yes, that's essentially what the Buckley one ruled. The Buckley one ruled that it doesn't matter how wealthy a person is or isn't, they are allowed to give $1 billion to whichever political candidate they want. Doesn't matter. It could be their entire worth. It could be hundreds of billions. Doesn't matter. You're allowed to give, let's say like an actual literal Nazi was running for office. Elon could literally give that Nazi $100 billion to run their campaign, which almost guarantees that person will win because they will have so much propaganda that it will convince people to vote. So that's what Buckley confirmed, whereas Austin versus Michigan State of Commerce was the one that corporations, political funds, tailored. Austin kind of said something to the contrary, at least in their own writing. They're saying that Austin, however, allowed the government to prohibit expenditures out of concern for the corrosive and distorting effects of super billionaires, essentially. Austin's reasoning was and remains inconsistent with Buckley. So essentially, the reason that the Supreme Court case ever even happened was because these two previous court cases were contradictory. But it looks like they're definitely arguing, at least the part of the court that won this vote. So those are the people that support allowing corporations to do independent expenditures. They're all dunking on Austin, this Austin versus Michigan State Chamber of Commerce. The law was upheld. The chamber sought to make an independent expenditures for a newspaper advertising supporting a candidate for legislature and establish separate fund. The organization prohibit independent expenditures made with corporate treasury funds. The chamber filed suit. Michigan Secretary of State challenging the constitutionality of it. The law was upheld by the district court. The appeals court overturned the lower court's decision, finding the prohibition unconstitutional as applied to the chamber. These things are so hard to comprehend quickly. So, yeah, in the Austin Supreme Court case, it's saying that the court agreed that as long as a corporation can make a political action committee to do their advocating, it was okay to have it be illegal for the corporation itself to invest money into free speech connected to political advertising and whatnot. So yeah, these are contradictory court cases. Like, just rhetorically, they are contradictory. And I guess that is how Citizens United got this case to go the way they wanted.
Same expenditures out of concern for the corrosive and distorting effects of immense aggregations of wealth in the marketplace of ideas. 494 US at 660. Austin's reasoning was and remains inconsistent with Buckley's explicit repudiation of any government interest in equalizing the relative ability of individuals and groups to influence the outcome of elections. 424 US at 48 to 49. Austin was also inconsistent with Belotti's clear reject. Tie-in of the idea that speech that otherwise would be within the protection of the First Amendment loses that protection simply because its source is a corporation. 435. US at 784. The dissent correctly points out that Belotti involved a referendum rather than a candidate election, and that Belotti itself noted this factual distinction, ID, at 788 and 26, post, at 52. But this distinction does not explain why corporations may be subject to prohibitions on speech in candidate elections when individuals may not.
That's a bad noise.
Second, the validity of Austin's rationale itself adopted over two spirited dissents, Payne, 501 US, at 829, has proved to be the consistent subject of dispute among members of this court ever since. See, e.g., WRTL, 551 U.S. at 483, Scalia, J., joined by Kennedy and Thomas, J.J., concurring in part and concurring in judgment, McConnell, 540 U.S. at 247, 264, 286, opinions of Scalia, Thomas, and Kennedy, J.J., Beaumont, 539 U.S. at 163, 164, opinions of Kennedy and Thomas, J.J. The simple fact that one of our decisions remains controversial is, of course, insufficient to justify overruling it. But it does undermine the precedent's ability to contribute to the stable and orderly development of the law. In such circumstances, it is entirely appropriate for the court, which in this case is squarely asked to reconsider Austin's validity for the first time, to address the matter with a greater willingness to consider new approaches capable
Dang, I won't have enough oxygen.
restoring our doctrine to sounder footing. Third, the Austin decision is uniquely destabilizing because it threatens to subvert our court's decisions even outside the particular context of corporate express advocacy. The First Amendment theory underlying Austin's holding is extraordinarily broad. Austin's logic would authorize government prohibition of political speech by a category of speakers in the name of equality, a point that most scholars acknowledge, and many celebrate, but that the dissent denies. Compare, e.g., Garrett, New Voices in Citizens United v. Federal Elections COMMN. Roberts, C.J., concurring. Politics, Justice Marshall's Jurisprudence on Law and Politics, 52 Howard L. J. 655, 669, 2009. Austin has been understood by most commentators to be an opinion driven by equality considerations, albeit disguised in the language of political corruption, with Post, at 74. Austin's rationale is manifestly not just an equalizing ideal in disguise. Point 2. It should not be surprising, then, that members of the court have relied on Austin's expansive logic to justify greater incursions on the First Amendment, even outside the original context of corporate advocacy on behalf of candidates running for office. See, e.g., Davis vs. Federal Election Comment, 554 U.S. _________, 2008, slip up, at 78, Stevens, J., concurring in part and dissenting in part, relying on Austin and other cases to justify restrictions on campaign spending by individual candidates, explaining that there is no reason that their logic, specifically, their concerns about the corrosive and distorting effects of wealth on our political process, is not equally applicable in the context of individual wealth. McConnell, Supra, at 203 to 209, extending Austin beyond its original context to cover not only the functional equivalent of express advocacy by corporations, but also electioneering speech conducted by labor unions. The dissent in this case, SUC, comes to the same temptation, suggesting that Austin justifies prohibiting corporate speech because such speech. To see also, e.g., R. Hassan, the Supreme Court and Election Law, Judging Equality from Baker v. Carr to Bush v. Gore 114, 2003, EUS 10 represents the first and only case, before McConnell, in which a majority of the court accepted, indeed if not in word, the equality rationale as a permissible state interest. Strauss, Corruption, Equality, and Campaign Finance Reform, 94 column. Eld Rev 1369, 1369, and N.1, 1994, noting that Austin's rationale was based on equalizing political speech, Ashdown, controlling campaign spending and the new corruption, waiting for the court, 44 Vand. Elk Rev 767, 781, 1991, Yule, promoting speaker diversity, Austin and Metro Broadcasting, 1990s, CT Rev 105, 108 to 111. Might unduly influence the market for legislation. Post, at 82. The dissent reads Austin to permit restrictions on corporate speech based on nothing more than the fact that the corporate form may help individuals coordinate and present their views more effectively. Post, at 82. A speaker's ability to persuade, however, provides no basis for government regulation of free and open public debate on what the laws should be. If taken seriously, Austin's logic would apply most directly to newspapers and other media corporations. They have a more profound impact on public discourse than most other speakers. These corporate entities are, for the time being, not subject to Section 441B's otherwise generally applicable prohibitions on corporate political speech. But this is simply a matter of legislative grace. The fact that the law currently grants a favored position to media corporations is no reason to overlook the danger inherent in accepting a theory that would allow government restrictions on their political speech. See Generally McConnell, Supra, at 283 to 286, Thomas, J., concurring in part, concurring in judgment in part, and dissenting in part. These readings of Austin do no more than carry the decision's reasoning to its logical endpoint. In doing so, they highlight the threat Austin poses to First Amendment rights generally, even outside its specific factual context of corporate express advocacy. Because Austin is so difficult to confine to its facts, and because its logic threatens to undermine our First Amendment jurisprudence and the nature of public discourse more broadly, the costs of giving it stare decisis effect are unusually high. Finally and most importantly, the government's own effort to defend Austin, or, more accurately, to defend something that is not quite Austin, underscores its weakness as a precedent of the court. The government concedes that Austin is not the most lucid opinion, yet asks us to reaffirm its holding. TR of Oral Arg 62, September 9th. Citizens United v. Federal Elections COMMN. Roberts, C.J., concurring. 2009, but while invoking stare decisis to support this position, the government never once even mentions the compelling interest that Austin relied upon in the first place: the need to diminish the corrosive and distorting effects of immense aggregations of wealth that are accumulated with the help of the corporate form and that have little or no correlation to the public's support for the corporation's political ideas. 494 U.S. at 660. Instead of endorsing Austin on its own terms, the government urges us to reaffirm Austin's specific holding on the basis of two new and potentially expansive interests: the need to prevent actual or apparent quid pro quo corruption, and the need to protect corporate shareholders. See Supper Brief for Appellee 8 to 10.
God, the need to protect corporate
Those
shareholders.
interests may or may not support the result in Austin, but they were plainly not part of the reasoning on which Austin relied.
It's just crazy hearing them say
To
this
its
stuff.
credit, the government forthrightly concedes that Austin did not embrace either of the new rationales it now urges upon us. See, e.g., Supper Brief for Appellee 11, the court did not decide in Austin whether the compelling interest in preventing actual or apparent corruption provides a constitutionally sufficient justification for prohibiting the use of corporate treasury funds for independent electioneering. TR of Oral Arg 45, September 9, 2009. AUS 10 did not articulate what we believe to be the strongest compelling interest, ID, at 61, the court, smiley face, I take it we have never accepted your shareholder.
Smiley face, what?
Protection interest. This is a
That's
new
funny.
argument. The government, I think that's fair, ID, at 64, the court, smiley face, in other words, you are asking us to uphold Austin on the basis of two arguments, two principles, two compelling interests we have never accepted in the context of limits on political expenditures. The government, and this particular context. Fair enough. To be clear, the court in Austin nowhere relied upon the only arguments the government now raises to support that decision. In fact, the only opinion in Austin endorsing the government's argument based on the threat of quid pro quo corruption was Justice Stevens's concurrence. 494 U.S. at 678. The court itself did not do so, despite the fact that the concurrence highlighted the argument. Moreover, the court's only discussion of shareholder protection in Austin appeared in a section of the opinion that sought merely to distinguish Austin's facts from those of Federal Election Com. NV and Massachusetts Citizens for Life Incorporated, 479 U.S. 238, 1986. Austin, Supra, at 663. Nowhere did Austin suggest that the goal of protecting shareholders is itself a compelling interest authorizing restrictions on First Amendment rights. To the extent that the government's case for reaffirming Austin depends on radically reconceptualizing its reasoning, that argument is at odds with itself. Stare decisis is a doctrine of preservation, not transformation. It counsels deference to past mistakes, but provides no justification for making new ones. There is therefore no basis for the court to give precedential sway to reasoning that it has never accepted, simply because that reasoning happens to support a conclusion reached on different grounds that have since been abandoned or discredited. Doing so would undermine the rule of law values that justify stare decisis in the first place. It would effectively license the court to invent and adopt new principles of constitutional law solely for the purpose of rationalizing its past errors, without a proper analysis of whether those principles have merit on their own. This approach would allow the court's past missteps to spawn future mistakes, undercutting the very rule of law values that stare decisis is designed to protect. None of this is to say that the government is barred from making new arguments to support the outcome in Austin. On the contrary, it is free to do so. And of course the court is free to accept them. But the government's Citizens United v. Federal Election COMMN Roberts, CEJ, concurring. New arguments must stand or fall on their own. They are not entitled to receive the special deference we accord to precedent. They are, as grounds to support Austin, literally unprecedented. Moreover, to the extent the government relies on new arguments and declines to defend Austin on its own terms, we may reasonably infer that it lacks confidence.
So now they're just really aggressively debating
because
these previous
Austin threatens to subvert the principled and intelligible
court cases.
First Amendment jurisprudence, Vasquez, 474 U.S. At 265, I support the court's determination to overrule that decision. Asterisk, 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 we have had 2 rounds of briefings in this case, 2 oral arguments, and 54 amicus briefs to help us carry out our obligation to decide the necessary constitutional questions according to law. We have also had the benefit of a comprehensive dissent that has helped ensure that the court has considered all the relevant issues. This careful consideration convinces me that Congress violates the First Amendment when it decrees that some speakers may not engage in political speech at election time, when it matters most. Scalia,
Need
J.
another
concurring.
ingot.
Supreme Court of the United States. Number 08205. On appeal from the United States District Court for the District of Columbia. January 21, 2010. Justice Scalia, with whom Justice Alito joins, and with whom Justice Thomas joins in part, concurring. I join the opinion of the court. Point 1.
Okay,
I write separately.
what section are we on now? So, Citizens United on appeal from the United States District Court for the District of Columbia. So now this is just written. With whom Justice joins in parts concurring. I join the opinion of the court. So this is now people writing why they agree with the ruling. And now it's going to focus more on individual justices and why it is they seem to agree, it looks like. But that last section was just going back and forth about, well, here's why we disagree with the previous court cases and what the precedent means and why we're going against it.
Justice
Yeah,
Scalia,
now
with whom Justice Alito joins.
Mouth exhaust. Now we're just on. Now it's just going to be individual judges explaining why they agree and their logic. I was kind of interested. I'm used to Supreme Court cases having like letters of dissent, like dissenting opinion. Opinion of Stevens J. Yeah, now it's just going to go through each group or individual justice, and it's going to explain what their opinions are and why, and kind of break it down. This is going to be super long, just listening to their opinions. There's like 8 of them, and they definitely don't seem to all agree. So essentially, like, I'd say unfortunately, I'd say kind of like the important part of this document that I valued reading is kind of over. It was the sort of collective court's opinion and logic. And now it's just going to break down to each individual justice or little clique or grouping of justices and where they stand. Oh, God, it looks like Chief Justice Stevens goes on forever. Holy crap. He is going on forever. Okay, the rest of the document is mostly him. Oh wait, no, who is it? Oh, now it's Thomas. Yeah, so either they'll say they concur with the court's opinion, which means they agree with letting corporations spend money on campaigns, or they're going to say they dissent, which means they disagree, or they're going to say concurring in part and dissenting in part, meaning they have their own unique opinion that they want to talk about and hash out. Holy crap, this is just going to be so much listening to these people. Okay. At least now I can kind of attribute what they're saying. Was this the right spot? I believe this was the right spot. Nope, I think I went too far forward, maybe. Where am I at? Scalia, Jake, concurring. Alito joins, Thomas joins. Original understandings, post at 34. Yep, okay, this is where we were. Page 79 out of 183. This sucks. Okay. So yeah, now it's just going to be individual opinions broken down by who's agreeing with them, who's on their side, stuff like that. Sure, Mouth, you can message me occasionally. I'm just going to try to focus in on reading mostly, though. Speaking of that, I want to speed up the reading voice because now it's going to be opinions.
Justice Scalia, with whom Justice Alito joins, and with whom Justice Thomas joins in part, concurring. I join the opinion of Court Point 1. I write separately to address Justice Stevens' discussion of original understandings, post, at 34, opinion concurring in part and dissenting in part, hereinafter referred to as the dissent. This section of the dissent purports to show that today's decision is not supported by the original understanding of the First Amendment. The dissent attempts this demonstration, however, in splendid isolation from the text of the...
Wait. So, Scalia, Alito, and Thomas concurring. I join the opinion of the court. I write separately to address Justice Stevens' discussions of original understandings. This section of the dissent purports to show that today's decision is not supported by the original understanding. The dissent attempts a demonstration, however, in splendid isolation from the text of freedom of speech. How did Justice... What's this one's name? Scalia vote in Citizens United? Scalia voted. Okay, so that is what they mean. When he says, I join the opinion of the court, he means he's joining the way the court voted. So, he's disagreeing with Justice Stevens. How did Justice Stevens vote on Citizens United? Which one is it? Nonsense in the American people. So he was dissenting. So now they're infighting. That's what this is going to be. It's going to be him infighting with Justice Stevens' arguments earlier on. I'm going to go up and restart to look at Justice Stevens so I can kind of put a face to a name better. Oh, weird. It's almost like it's out of order. What is up with that? What? What am I not understanding here? Weird. It's it's kind of written out of order, where like he's addressing the dissent's argument before the dissent has had a chance to make their argument yet. I mean, weird. Either way, okay, cool. We'll start this. So these are the people that agree with it. We're going to listen to them for a while, and then we will hear the dissent after this, which I will much prefer to hear the dissent, because obviously I agree with the dissent.
It never shows why the freedom of speech that was the right of Englishmen did not include the freedom to speak in association with others.
Hey, Andrea.
Including association
I'm tired.
To be sure, in 1791, set forth in their charters, but the dissent provides no evidence that their speech in the pursuit of those objectives could be censored. Instead of taking this straightforward approach to determining the amendment's meaning, the dissent embarks on a detailed exploration of the framers' views about the role of corporations in society. Post at 35. The framers didn't like corporations, the dissent con. 1 Justice Thomas does not join Part 4 of the court's opinion. Citizens United v. Federal Elections COMMN. Scalia, J., concurring. Concludes, and therefore it follows, as night the day, that corporations had no rights of free speech. Of course, the framers' personal affection or disaffection for corporations is relevant only insofar as it can be thought to be reflected in the understood meaning of the text they enacted, not, as the dissent suggests, as a freestanding substitute for that text. But the dissent's distortion of proper analysis is even worse than that. Though faced with a constitutional text that makes no distinction between types of speakers, the dissent feels no necessity to provide even an isolated statement from the founding era to the effect that corporations are not covered, but places the burden on petitioners to bring forward statements showing that they are. There is not a scintilla of evidence to support the notion that anyone believed the First Amendment would preclude regulatory distinctions based on the corporate form. Post at 34 to 35. Despite the corporation-hating quotations the dissent has dredged up, it is far from clear that by the end of the 18th century corporations were despised. If so, how came there to be so many of them? The dissent's statement that there were few business corporations during the 18th century, only a few hundred during all of the 18th century, is misleading. Post at 35 and 53. There were approximately 335 charters issued to business corporations in the United States by the end of the 18th century. 2C2 J. E. Davis, Essays in the Earlier History of American Corporations 24, 1917, reprint 2006, hereinafter Davis. This was a considerable extension of corporate enterprise. To the dissent protests that 1791 rather than 1800 should be the relevant date, and that more than half of the century's total business charters were issued between 1796 and 1800. Post at 35 and 53. I used 1800 only because the dissent did. But in any case, it is surely fanciful to think that a consensus of hostility towards corporations was transformed into general favor.
Titanium wiring kit lubricant.
1791 and 1796. In the field of business, Davis ate and represented unprecedented growth, ID, at 309. Moreover, what seems like a small number by today's standards surely does not indicate the relative importance of corporations when the nation was considerably smaller. As I have previously noted, by the end of the 18th century the corporation was a familiar figure in American economic life. McConnell v. Federal Election Comment, 540 U.S. 93, 256, 2003, Scalia, J., concurring in part, concurring in judgment in part, and dissenting in part, quoting C. Cook, Corporation Trust and Company 92, 1951, hereinafter Cook. Even if we thought it proper to apply the dissent's approach of excluding from First Amendment coverage what the founders disliked, and even if we agreed that the founders disliked founding-era corporations, modern corporations might not qualify for exclusion. Most of the founders' resentment towards corporations was directed at the state-granted monopoly privileges that individually chartered corporations enjoyed. 3 Modern corporations do not have such privileges, and would probably have been favored by most of our enterprising founders, excluding, perhaps, Thomas Jefferson and others favoring perpetuation of an agrarian society. Moreover, if the founders' specific intent with respect to corporations is what matters, why does the dissent ignore the founders' views about other legal entities that have more in common with modern business corporations than the founding-era COR? 3-inch B. Equal in 1800 identified corporations with franchise monopolies. Ella Friedman, A History of American Law 194, 2D edition 19.
Oh man, they're getting into the history. So now they're going crazy about
business corporations that marked the opening of the 19th century was the elimination of their inherent monopolistic character. This was accomplished primarily by an
So their entire argument is, ooh, the founding fathers didn't like corporations, but corporations were like monarchs back in the day. They were like friends with the monarchs, and they were evil because they were connected to the monarchy. So no, they might like our corporations nowadays. They might love capitalism. Interesting. They're just going heavy into history.
Corporations? At the time of the founding,
Which kind of tells me something. It kind of tells me that conservative-leaning justices tend to be like constitutional literalists. They try to follow the Constitution as literally as the founding fathers wrote it, whereas the more progressive judges likely interpret the Constitution for the sake of the well-being of people at the modern day. Probably.
Founding, religious, educational, and literary corporations were incorporated under general incorporation statutes, much as business corporations are today. 4C Davis 16-17, Art Seaboy, Origins of the American Business Corporation, 1784-1855, page 5, 1982, Cook 94. There were also small unincorporated business associations, which some have argued were the true progenitors of today's business corporations. Friedman 200, quoting S. Livermore, Early American Land Companies, Their Influence on Corporate Development 216, 1939, see also Davis 33. Were all of these silently excluded from the protections of the First Amendment? The lack of a textual exception for speech by corporations cannot be explained on the ground that such organizations did not exist or did not speak. To the contrary, colleges, towns and cities, religious institutions, and guilds had long been organized as corporations at common law and under the King's Charter, C1W of Blackstone, Commentaries on the Laws of England 455-473, 1765, 1s. Kidd, A Treatise on the Law of Corporations 1-32, 63, 1793, reprinted 2006, and as I have discussed, the practice of incorporation only expanded in the United States. Both corporations and voluntary associations actively petitioned the government and expressed their views in newspapers and pamphlets. For example, an anti-slavery Quaker corporation petitioned the first Congress, distributed pamphlets, and communicated through the press in 1790. W. D. Giacomo Antonio, for the gratification of a volunteering society, anti-slavery, and pressure group. For at times, though not always, the dissent seems to exclude such non-business corporations from its denial of free speech rights. See Post, at 37. Finding in a seemingly categorical text a distinction between the rights of business corporations and the rights of non-business corporations is even more imaginative than finding a distinction between the rights of all corporations and the rights of other associations. Scalia, J., concurring. Politics in the First Federal Congress, 15J. Early Republic 169, 1995. The New York Sons of Liberty sent a circular to colonies farther south in 1766. P. Meyer, From Resistance to Revolution 79-80, 1972. And the Society for the Relief and Instruction of Poor Germans circulated a bi-weekly paper from 1755 to 1757. Adams,
So now they're just providing examples of corporations throughout history that have done something positive for society in their mind, in their eyes, and in their opinion. But I don't really find that to be a strong argument, because corporations have also done incomprehensible harm to society as a collective through their free speech.
unqualified text was originally understood to exclude such associational speech. Section point 5. 5. The best the dissent can come up with is that P. A stratification practice supports its reading of the First Amendment. Post, at 40. In point 56, for this proposition, the dissent cites Justice White's statement, in dissent, that the common law was generally interpreted as prohibiting corporate political participation. First Nat Bank of Boston de Bellotti, 435 U.S. 765, 819, 1978. The sole authority Justice White cited for this proposition, ID, at 819 in 14, was a law review note that made no such claim. To the contrary, it stated that the cases dealing with the propriety of corporate political expenditures were few. Note, Corporate Political Affairs Programs, 70 Yale J, 821, 852, 1961. More specifically, the note cites only 2 holdings to that effect, one by a federal district court, and one by the Supreme Court of Montana. ID, at 852, N197. Of course, even if the common law was generally interpreted to prohibit corporate political expenditures as ultra vires, that would have nothing to do with whether political expenditures that were authorized by a corporation's charter could constitutionally be suppressed. As additional stratification practice, the dissent notes that the court did not recognize any First Amendment protections for corporations until the middle part of the 20th century. Post at 40 and 56. But it did that in Grosjean versus American Press Company, 297 U.S. 233, 1936, a case involving freedom of the press, which the dissent acknowledges did cover corporations from the outset. The relative recency of that first case is unsurprising. All of our First Amendment jurisprudence was slow to develop. We did not consider application of the First Amendment to speech restrictions other than prior restraints until 1919, see Schenck versus United States, 249 U.S. 47, 1919. We did not invalidate a state law on First Amendment grounds until 1931, see Citizens United.
They write about it as if they were alive in 1931.
Concurring. Historical evidence relating to the textually similar clause, the freedom of the press, also provides no support for the proposition that the First Amendment excludes conduct of artificial legal entities from the scope of its protection. The freedom of the press was widely understood to protect the publishing activities of individual editors and printers. See McIntyre v. Ohio Elections Comment, 514 U.S. 334, 360, 1995, Thomas, J. Concurring in judgment, see also McConnell, 540 U.S. at 252-253, Opinion of Scalia, J. But these individuals often acted through newspapers, which, much like corporations, had their own names, outlived the individuals who had founded them, could be bought and sold, were sometimes owned by more than one person, and were operated for profit. See generally F. Mott, American Journalism, A History of Newspapers in the United States Through 250 Years 3 to 164, 1941, J. Smith, Freedom's Fetters, 1956. Their activities were not stripped of First Amendment protection simply because they were carried out under the banner of an artificial legal entity. And the notion which follows from the dissent's view, that modern newspapers, since they are incorporated, have free speech rights only at the sufferance of Congress, boggles the mind. 6. Stromberg versus California, 283 U.S. 359, 1931, and a federal law until 1965. See Lamont versus Postmaster General, 381 U.S. 301, 1965. Point 6. The dissent seeks to avoid this conclusion, and to turn a liability into an asset, by interpreting the freedom of the press clause to refer to the institutional press, thus demonstrating, according to the dissent, that the founders did draw distinctions, explicit distinctions, between types of speakers, or speech outlets or forms. Post, at 40 and N. 57. It is passing strange to interpret the phrase, the freedom of speech, or of the press to mean, not everyone's right to speak or publish, but rather everyone's right to speak or the institutional press's right to publish. No one thought that is what it meant. Patriot Noah Webster's 1828 dictionary contains, under the word press, the following entry: liberty of the press, in civil policy, is the free right of publishing. Scalia, J., concurring. In passing, the dissent also claims that the court's conception of corruption is unhistorical. The framers would have been appalled, it says, by the evidence of corruption in the congressional.
So this is interesting. At the end of each little section, the dissent is allowed to put little asterisks, kind of rebuttaling the other side. I like it. I can tell the difference in tone and logic between the people that are thinking with common sense to be anti-corruption and the people that are definitely wanting to be pro-corruption. What's definitely interesting as I continue reading is how I can kind of see the pro-corruption people's arguments. Now, I don't see pro-corruption, but I unfortunately am starting to see their argument. Like, yeah, I get it. There have been times in history where corporations did right by the American people and spoke openly and freely in a way that was beneficial and good for people's well-being. But I don't know. I just think it's extremely naive. And when I say I see what they're saying, I mean that I understand their logic. Because as Supreme Court justices, all they can go off of is history. That's all they've got. So I can kind of see what it is they are attempting to say. As much as I myself disagree with the consequences of what they are attempting to say, I can kind of see it. I can see their logic, even if I don't agree with their underlying principles and beliefs, and especially the consequences of their logic as they employ it this way. Oh, it hit my thing, didn't it? I'm getting rocked left and right. This is not good. I should probably go back to playing it. Oops. Started playing the game too hard.
Comment 514 you guess 334, 360, 1995, Thomas, J. Concurring in judgment, see also McConnell, 540 U.S. at 252-253, opinion of Scalia, J. But these individuals often acted through newspapers, which, much like corporations, had their own names, outlived the individuals who had founded them, could be bought and sold, were sometimes owned by more than one person, and were operated for profit. See generally F. Mott, American Journalism, A History of Newspapers in the United States through 250 years 3 to 164, 1941, J. Freedom's Fetters, 1956. Their activities were not stripped of First Amendment protection simply because they were carried out under the banner of an artificial legal entity. And the notion which follows from the dissent's view, that modern newspapers, since they are incorporated, have free speech rights only at the sufferance of Congress, boggles the mind. 6. Stromberg vs. California, 283 U.S. 359, 1931, and a federal law until 1965. See Lamont vs. Postmaster General, 381 U.S. 301, 1965. Point 6. The dissent seeks to avoid this conclusion and turn the liability into an asset by interpreting the freedom of the press clause to refer to the institutional press, thus demonstrating, according to the dissent, that the founders did draw distinctions, explicit distinctions, between types of speakers, or speech outlets or forms. Post, at 40 NN 57. It is passing strange to interpret the phrase the freedom of speech or of the press to mean not everyone's right to speak or publish, but rather everyone's right to speak or the institutional press's right to publish. No one thought that is what it meant. Patriot Noah Webster's 1828 dictionary contains, under the word press, the following entry: liberty of the press, in civil policy, is the free right of publishing. Scalia, J., concurring. In passing, the dissent also claims that the court's conception of corruption is unhistorical. The framers would have been appalled, it says, by the evidence of corruption in the congressional findings supporting the Bipartisan Campaign Reform Act of 2002. Post, at 61. For this proposition, the dissent cites a law review article arguing that corruption was originally understood to include moral decay and even actions taken by citizens in pursuit of private rather than public ends. Teach out, the anti-corruption principle, 94 Cornell L. Rev. 341, 373, 378, 2009. It is hard to see how this has anything to do with what sort of corruption can be combated by restrictions on political speech. Moreover, if speech can be prohibited because, in the view of the government, it leads to moral decay or does not serve public ends, then there is no limit to the government's censorship power. The dissent says that when the framers constitutionalized the right to free speech in the First Amendment, it was the free speech of individual Americans that they had in mind. Post, at 37. That is no doubt true. All the provisions of the Bill of Rights set forth the rights of individual men and women, not, for example, of trees or polar bears. But the individual person's right
Nice.
to speak
That's a funny
includes
reference.
the right to speak in association with other individual persons. Surely the dissent does not believe that speech.
So I've been saying it for the past, how many pages are we on? 85 pages. I've been saying the exact same damn thing. The Constitution was written about real human beings made of flesh and blood, not the concept of a thing that can speak. It was about people and their abilities as individuals to speak, not polar bears. Finally, they're saying the thing I've been saying.
Rights set forth the rights of individual men and women, not, for example, of trees or polar bears. But the individual person's right to speak includes the right to speak in association with other individual persons. Surely the dissent does not believe that speech. Books, pamphlets, or papers without previous restraint, or the unrestrained right which every citizen enjoys of publishing his thoughts and opinions, subject only to punishment for publishing what is pernicious to morals or to the peace of the state. 2 American Dictionary of the English Language, 1828, reprinted 1970. As the court's opinion describes, ante, at 36, our jurisprudence agrees with Noah Webster and contradicts the dissent. The liberty of the press is not confined to newspapers and periodicals. It necessarily embraces pamphlets and leaflets.
Wow, they are actually fighting here with each other. This is crazy. Surely the dissent does not believe that that speech by the Republican or Democrat Party can be censored because it is not speech of an individual American. Honestly, I'd believe it. I'd agree. I mean, I don't think that's what they're arguing, but like, I'd say fuck it. Go for it. That was on text, just listening. What are we at? We are on 85. I'm jumping back to 37. I don't know what they mean when they say at 37, like page 37. That doesn't make any sense to me. Alright, I'm going back to 85 now. Which is the conformity of today's opinion with the original meaning of the First Amendment. The amendment is written in terms of speech, not speakers. Oh, that is their main argument. They're focusing on the concept of speech and not the fact that it's done by individuals or individual human beings. Any category of speaker. The dissent says that speech refers to oral communication to human beings. I agree.
The original meaning of the First Amendment. The amendment is written in terms of speech, not speakers. Its text offers no foothold for excluding any category of speaker from. 7. The dissent says that speech refers to oral communications of human beings, and since corporations are not human beings, they cannot speak. Post at 37 and 55. This is sophistry. The authorized spokesman of a corporation is a human being who speaks on behalf of the human beings who have formed that association, just as the spokesman of an unincorporated association speaks on behalf of its members. The power to publish thoughts, no less than the power to speak thoughts, belongs only
that guy's
to
gonna
human
kill me,
beings,
huh?
But the dissent sees no problem with the corporations enjoying the freedom of the press. The same footnote asserts that it has been claimed
One
that the
diamond?
notion of institutional speech did not exist in post-revolutionary America. This is quoted from a law review article by a Bigelow Fellow at the University of Chicago, Fagundes, State Actors as First Amendment Speakers, 100 NW, Rev. 1637.
Nope, I don't want gold, I want diamond.
2006, which offers as the
Good.
sole support for its statement a treatise dealing with government. Speech, M. Udoff, When Government Speaks 42 to 50, 1983. The cited pages of that treatise provide no support whatever for the statement unless, as seems overwhelmingly likely, the institutional speech referred to was speech by the subject of the law review article, governmental institutions. The other authority cited in the footnote, a law review article by a professor at Washington and Lee Law School, Bazanson, Institutional Speech, 80 Iowa L. Rev. 735, 775, 1995, in fact contradicts the dissent, in that it would accord free speech protection to associations. Scalia, J., concurring. Single individuals to partnerships of individuals, to unincorporated associations of individuals, to incorporated associations of individuals,
diamond?
and the dissent offers no
Good.
evidence about the original meaning of the text to support any such exclusion. We are therefore simply left with the question whether the speech at issue in this case is speech covered by the First Amendment. No one says otherwise. A documentary film critical of a potential presidential candidate is core political speech, and its nature as such does not change simply because it was funded by a corporation. Nor does the character of that funding
Uh-oh.
produce any reduction whatever in the
I might
inherent
not
worth of the
dodge
speech
that.
and its capacity for informing the public. First Nat Bank of Boston versus
Whoa,
Maloney,
barely survived. That was
435
terrible.
U.S. 765, 777, 1978. Indeed, to exclude or impede corporate speech is to muzzle the principal agents of the modern free economy. We should celebrate rather than condemn the addition of this speech to the public debate. Opinion of Stevens, J. Supreme Court of the United States. Number 08205. Citizens United, Appellant v. Federal Election Commission. On appeal from the United States District Court for the District of Columbia. January 21, 2010. Justice Stevens, with whom Justice Ginsburg, Justice Breyer, and Justice Sotomayor join, concurring in part and dissenting in part. The real issue in this case concerns how, not if, the appellant may finance its electioneering. Citizens United is a wealthy nonprofit corporation that runs a political action committee, PAC, with millions of dollars in assets. Under the Bipartisan Campaign Reform Act of 2002, BCRA, it could have used those assets to televise and promote Hillary, the movie, wherever and whenever it wanted to. It also could have spent unrestricted sums to broadcast Hillary at any time other than the 30 days before the last primary election. Neither Citizens United nor any other corporation's speech has been banned, at one. All that the parties dispute is whether Citizens United had a right to use the funds in its general treasury to pay for broadcasts during the 30-day period. The notion that the First Amendment dictates an affirmative answer to that question is, in my judgment, profoundly misguided. Even more misguided is the notion that the court must rewrite the law relating to campaign expenditures by for-profit corporations and unions to decide this case. The basic premise underlying the court's ruling is its iteration, and constant reiteration, of the proposition that the First Amendment bars regulatory distinctions based. Citizens United v. Federal Elections COMMN. Opinion of Stevens, J. On a speaker's identity, including its identity as a corporation. While that glittering generality has rhetorical appeal, it is not a correct statement of the law. Nor does it tell us when a corporation may engage in electioneering that some of its shareholders oppose. It does not even resolve the specific question whether Citizens United may be required to finance some of its messages with the money in its PAC. The conceit that corporations must be treated identically to natural persons in the political sphere is not only inaccurate but also inadequate to justify the court's disposition of this case. In the context of election to public office, the distinction between corporate and human speakers is significant. Although they make enormous contributions to our society, corporations are not actually members
That
of
was
it.
funny.
They cannot vote or run for office. Because they may be managed and controlled by non-residents.
Oh, that's an
their
interesting
interests may
side
conflict in
argument.
fundamental respects with the interests of eligible voters. The financial resources, legal structure, and instrumental orientation of corporations raise legitimate concerns about their role in the electoral process. Our lawmakers have a compelling constitutional basis, if not also a democratic duty, to take measures designed to guard against the potentially deleterious effects of corporate spending in local and national races.
Is the giant sea worm still trying to destroy my thing right now? No? Has it left me alone? Good.
Limitations on campaign spending by corporations ever since the passage of the Tillman Act in 1907, ch. 420, 34 Stat. 864. We have unanimously concluded that this reflects a permissible assessment of the dangers posed by those entities to the electoral process. FEC v. National Right to Work Calm, 459 U.S. 197, 209,
Lithium and titanium.
1982, NRWC, and have accepted the legislative judgment that the special characteristics of the corporate structure require particularly careful regulation, ID, at 209 to 210. The court today rejects a century of history when it treats the distinction between corporate and individual campaign spending as an invidious novelty born of Austin versus Michigan Chamber of Commerce, 494 U.S. 652, 1990. Relying largely on individual dissenting opinions, the majority blazes through our precedents, overruling or disavowing a body of case law.
Oh, that thing
including
is so
FEC v.
angry.
Wisconsin Right to Life Incorporated, 551 U.S. 449.
Oh god, now they're mentioning 30 more.
WRTL, McConnell v. FEC, 540. U.S. 288, 346, 1936, Justice Brandeis stressed the importance of adhering to rules the court has developed for its own governance when deciding constitutional case tie-ins. Because departures from those rules always enhance the risk of error, I shall review the background of this case in some detail before explaining why the court's analysis rests on a faulty understanding of Austin and McConnell and of our campaign finance jurisprudence more generally. Point 1. I regret the length of what follows, but the importance and novelty of the court's opinion require a full response. Although I concur in the court's decision to
Wow, he's about to go really into it, I guess. Okay, so we are now thoroughly and officially in the opinion of the dissent. We already got into it, but I'm tempted to restart and reread the dissent a couple of times, honestly. But I already see where they're getting at, so I'll start it back up and just go for it straight. I regret the length of what follows, but the importance is whatever. Part 3, Part 2 addresses the court's treatment of anti-corruption, anti-distortion, and shareholders. The court's ruling threatens to undermine the integrity of elected institutions across the nations. Ooh, I like this one. I'm probably going to cite this one a couple of times. Cite this section of the document. This is all very good. This is page 91.
Citizens United v. Federal Elections COMMN opinion of Stevens, J. The court's ruling threatens to undermine the integrity of elected institutions across the nation. The path it has taken to reach its outcome will, I fear, do damage to this institution. Before turning to the question whether to overrule Austin and part of McConnell, it is important to explain why the court should not be deciding that question. The first reason is that the question was not properly brought before us. In declaring Section 203 of BCRA facially unconstitutional on the ground that corporations' electoral expenditures may not be regulated any more stringently than those of individuals, the majority decides this case on a basis relinquished below, not included in the questions presented to us by the litigants, and argued here only in response to the court's invitation. This procedure is unusual and inadvisable for a court. Point 2. Our colleagues' suggestion that we are asked to reconsider Austin and, in effect, McConnell, at 1, would be more accurate if rephrased to state that we have asked ourselves to reconsider those cases. 2 CE versus Escondido, 503 U vs 519, 535, 1992, U. Enter this court's Rule 14.1, A. Only questions set forth in the petition, or fairly included therein, will be considered by the court, internal quotation marks and alteration omitted, Wood versus Allen, ante, at _ slip up, at 13, T. The fact that petitioner discussed, and the issue in the text of his petition for certiorari does not bring it before us. Rule 14.1, A, requires that a subsidiary question be fairly included in the question presented for our review, internal quotation marks and brackets omitted, Cooper Industries Incorporated v. Avial Services Incorporated, 543 U.S., 157, 168 to 169, 2004. We ordinarily do not decide in the first instance issues not decided below, internal quotation marks omitted. Opinion of Stevens, J. Zens United expressly abandoned its facial challenge, 1:07 CV 2240 RCLORWR, docket entry number 52, pages 1-2, May 16, 2008, and the parties stipulated to the dismissal of that claim, ID, numbers 53, May 22, 2008, 54, May 23, 2008, App 6A. The district court therefore resolved the case on alternative grounds. 3. And in its jurisdictional statement to this court, Citizens United properly advised us that it was raising only an as-applied challenge to the constitutionality of BCRA Section 203. Juris. Statement 5. The jurisdictional statement never so much as cited Austin, the key case the majority today overrules. And not one of the questions presented suggested that Citizens United was surreptitiously raising the facial challenge to Section 203 that it previously agreed to dismiss. In fact, not one of those questions raised an issue based on Citizens United's corporate status. Juris. Statement I. Moreover, even in its merits briefing, when Citizens United injected its request to overrule Austin, it never sought a declara. Tie-in that Section 203 was facially unconstitutional as to all corporations and unions. Instead, it argued only that the statute could not be applied to it because it was funded overwhelmingly by individuals. Brief for Appellant 29, see also ID, at 10, 12, 16, 28, affirming his applied character. 3. The majority states that, in denying Citizens United's motion for a preliminary injunction, the District Court addressed the facial valid ITY of BCRA Section 203. Ante, at 13. That is true, in the narrow sense that the court observed the issue was foreclosed by McConnell v. FEC, 540. U.S. 93, 2003. C530F, Sup. 2D 274, 278, DC 2008, per curiam. Yet as explained above, Citizens United subsequently dismissed its facial challenge, so that by the time the District Court granted the Federal Election Commission's, FEC, motion for summary judgment, App 261A 262A, any question about statutory validity had dropped out of the case. That latter ruling by the District Court was the final decision from which Citizens United appealed to this court under BCRA Section 403A.3. As regards the lower court decision that has come before us, the claim that Section 203 is facially unconstitutional was neither pressed nor passed upon in any form. Citizens United v. Federal Elections COMMN opinion of Stevens, J. Of challenge to Section 203 TR of Oral Arg 4-9, March 24, 2009, Counsel for
Oh
Citizens
man,
United
that killed me.
conceding that
That's so
Section
stupid.
203 could be applied to General Motors, ID, at 55. Counsel for Citizens United stating that we accept the court's decision in Wisconsin.
Wow, that's
right to
unfortunate.
life. It is only in exceptional cases coming here from the federal courts that questions not pressed or passed upon below are reviewed. Joachim versus Miller, 425 U.S. 231, 234, 1976, per curiam, quoting Dignan versus United States, 274 U.S. 195, 200, 1927, and it is only in the most exceptional cases that we will consider issues outside the questions presented. Stone versus Powell, 428 U.S. 465, 481, N15, 1976. The appellant in this case did not so much as assert an exceptional circumstance, and one searches the majority opinion in vain for the mention of any. That is unsurprising, for none exists. Setting the case for re-argument was a constructive
Oh,
step,
I'm gonna get
but
killed
it did
again.
not cure this fundamental problem. Essentially, 5 justices were unhappy with the limited nature of the case before us, so they changed the case to give themselves an opportunity to change the law. This court has repeatedly emphasized in recent years that facial challenges are disfavored. Washington State Grange versus Washington State Republican Party, 552 U.S. 442, 450, 2008. See also Ayotte versus Planned Parenthood of Northern New England, 546 U.S. 320, 329, 2006. The normal rule is that partial, rather than facial, invalid attaion is the required course, such that a statute may be declared invalid to the extent that it reaches too far, but otherwise left intact. Quoting Brockett versus Spokane Arcades Incorporated, for 72 U.S. 491, 504, 1985, alteration in origin ill. By declaring Section 203 facially unconstitutional, our colleagues have turned an as-applied challenge into a facial challenge, in defiance of this principle. Opinion of Stevens, J. This is not merely a technical defect in the court's decision. The unnecessary resort to a facial inquiry runs contrary to the fundamental principle of judicial restraint.
Sure, and tonight. Dang it, that's not useful.
Question of constitutional law in advance of the necessity of decid ing.
Get out of here.
A rule of constitutional law broader than is required by the precise facts to which it is to be applied. Washington State Grange, 552 U.S. at 450, internal quotation marks omitted. Scanting that Princi PLE threatens to short-circuit the democratic process by preventing laws embodying the will of the people from being implemented in a manner consistent with the Constitution. ID, at 451. These concerns are heightened when judges overrule settled doctrine upon which the legislature has relied. The court operates with a sledgehammer rather than a scalpel when it strikes down one of Congress's most significant efforts to regulate the role that corporations and unions play in electoral politics. It pounds the offense by implicitly striking down a great many state laws as well. The problem goes still deeper, for the court does all of this on the basis of pure speculation.
Pure speculation.
Had
And
Citizens
United
United
maintain a facial challenge.
thus argued that there are virtually no circumstances in which BCRA Section 203 can be applied constitutionally, the parties could have developed.
Oh, now they're actually calling them out for what they did.
The actual effects of Section 203, its actual burdens and its actual benefits.
Oh, I'm glad to see that thinking people with brains on the Supreme Court were like, hey, they really didn't need to escalate this to the Supreme Court. If the BRCA had been used on them, it would have been unconstitutional anyway. What they wanted was to force us as a court to rule that corporations are allowed to spend for independent expenditures related to campaigns. They're acknowledging that these people were scamming the Supreme Court specifically to get a new ruling that would allow more corporations to do this.
For shortly before Citizens United mooted the issue by abandoning its facial challenge, the government advised the district court that it require time to develop a factual record regarding the facial challenge. 1:07 CV 2240 RCLORWR, docket entry number 47, page 4, March 26, 2008. By reinstating a claim that Citizens United abandoned, the court gives it a perverse litigating advantage over its adversary, which was deprived of the opportunity to gather and present information necessary to its rebuttal. Citizens United v. Federal Elections COMMN. Opinion of Stevens, J. Claims of facial invalidity often rest on speculation, and consequently raise the risk of premature interpretation of statutes on the basis of factually bare-bones records. ID, at 450, internal quotation marks omitted. In this case, the record is not simply incomplete or unsatisfactory, it is non-existent. Congress crafted BCRA in response to a virtual mountain of research on the corruption that previous legislation had failed to avert. The court now negates Congress's efforts without a shred of evidence on how Section 203 or its state law counterparts have been affecting any entity other than Citizens United. 5. Faced with this gaping empirical hole, the majority throws up its hands. Were we to confine our inquiry to Citizens United's as-applied challenge, it protests, we would commence an extended process of draw, ing, and then redraw, ing, constitutional lines based on the particular media or technology used to disseminate political speech from a particular speaker. Ante, at 9. While tacitly acknowledging that some applications of Section 203 might be found constitutional, the majority thus posits a future in which novel First Amendment standards must. 5 inches fact, we do not even have a good evidentiary record of how Section 203 has been affecting citizens.
Get me out of here before this guy blows me up. Don't blow me up, bro. Leave me alone. Leave me alone.
We likewise have no evidence of how Section 203 and comparable state laws were expected to affect.
Oh, I'm getting hit. This is so bad.
It is true, as the majority points out, that the
Leave me alone.
court evaluated the facial validity of Section 203 in light of an extensive record. See ante, at 15.
Silver ore? I need nickel
but that
ore.
record is not before us in this case. And in any
What do I have on me?
The majority's argument for striking down Section 203 depends on its contention that the statute has proved too chilling in practice, and in particular,
Do
on the
not come
contention
over
that
here.
controlling
Leave me
opinion
alone.
in WRTL 551. US 449, 2007, failed to bring sufficient clarity and breathing space to this area of law. See ante, at
I only got
12,
2 things in nickel ore. I
16 to 20.
definitely need like 3.
We have no record with which to assess that claim. The court complains at length about the burdens of complying with Section 203, but we have no meaningful evidence to show how regulated corporations and unions have experienced its restrictions.
Oh my god. I didn't even know it could do that. It's about to break my thing.
Be devised on an ad hoc basis.
I didn't even know it could do that until now.
To the unfounded conclusion that such complexity counsels the abandonment of all normal restraint. Yet it is a pervasive feature of regulatory systems.
I didn't even remember it had an animation for that.
Such as new technologies may raise some unanticipated difficulties at the margins. The fluid nature of electioneering communications does not make this case special. The fact that a court can hypothesize situations in which a statute might, at some point down the line, pose some unforeseen as-applied problems, does not come close to meeting the standard for a facial challenge. Point 6. The majority proposes several other justifications for the sweep of its ruling. It suggests that a facial ruling is necessary because, if the court were to continue on its normal course of resolving as-applied challenges as they present themselves, that process would itself run afoul of the First Amendment. See, e.g., ante, at 9, as-applied review process would raise questions as to the court's own lawful authority. Ibid, courts, too, are bound by the First Amendment. This suggestion is perplexing. Our colleagues elsewhere trumpet our duty to say what the law is, even when our predecessors on the bench and our counterparts in Congress have interpreted the law differ. 6. Our cases recognize a type of facial challenge in the First Amendment context under which a law may be overturned as impermissibly overbroad because a substantial number of its applications are unconstitutional. Washington State Grange vs. Washington State Republican Party, 552 U.S. 442, 449, N6, 2008, internal quotation marks omit TED. Citizens United has not made an overbreadth argument, and W.E. generally do not apply the strong medicine of overbreadth analysis where the parties fail to describe the instances of arguable overbreadth of contested law, ibid, internal quotation marks omitted. If our colleagues nonetheless concluded that Section 203's fatal flaw is that it affects too much protected speech, they should have invalidated it for overbreadth and given guidance as to which applications are permissibly, so that Congress could go about repairing the error. Citizens United v. Federal Elections COMMN. Opinion of Stevens, J. Antley. Ante, at 49, quoting Marbury v. Madison, 1 Cranch 137, 177, 1803. We do not typically say what the law is not as a hedge against future judicial error. The possible ity that later courts will misapply a constitutional provision does not give us a basis for pretermitting litigation relating to that provision. Point 7. The majority suggests that a facial ruling is necessary because anything else would chill too much protected speech. See ante, at 9 to 10, 12, 16 to 20. In addition to begging the question what types of corporate spending are constitutionally protected and to what extent, this claim rests on the assertion that some significant number of corporations have been cowed into quiescence by FEC censorship. Ante, at 18 to 19. That assertion is unsubstantiated, and it is hard to square with practical experience. It is particularly hard to square with the legal landscape following WRTL, which held that a corporate communication could be regulated under Section 203 only if it was susceptible of no reasonable interpretation other than as an appeal to vote for or against a specific candidate.
Wow, that killed me. Well, there goes my prawn suit. That's gone forever.
Added.
I really do not have enough stuff necessary to remake that right now.
The court does not explain how, in the span of a single election cycle, it has determined the Chief Justice's project to be. 7. Also perplexing is the majority's attempt to pass blame to the government for its litigating position. By hold, ing, up the possibility of ruling for Citizens United.
Oh, there it goes.
Refrain,
yep, I'm screwed.
That position, the majority says,
I'll never catch it in time.
Added uncertainty that demonstrates the necessity to address the question of statutory validity. Ante, at 17. Our colleagues have apparently never heard of an alternative argument. Like every litigant, the government would prefer to win its case outright. Failing that, it would prefer to lose on a narrow
Wow, they're getting mean with each other in these disagreements. Our colleagues have apparently never heard of an alternative argument. Holy crap. They're like really going mean at each other right now.
Opinion of Stevens, J. A failure. In this respect, too, the majority's critique of line drawing collapses into a critique of the as-applied review method generally. Point 8. The majority suggests that, even though it expressly dismissed its facial challenge, Citizens United nevertheless preserved it, not as a freestanding claim, but as a potential argument in support of a claim that the FEC has violated its First Amendment right to free speech. Ante, at 13, see also ante, at 4, Roberts, CEJ, concurring, describing Citizens United's claim as, the act violates the First Amendment. By this novel logic, virtually any submission could be reconceptualized as a claim that the government has violated my rights, and it would then be available to the court to entertain any conceivable issue that might be relevant to that claim's disposition. Not only the as-applied/facial distinction, but the basic relationship between litigants and courts, would be upended if the latter had free rein to construe the former's claims at such high levels of generality. There would be no need for plaintiffs to argue their case, they could just cite the constitutional provisions they think relevant and leave the rest to us. Point 9. 8. The majority's chilling argument is particularly inapposite with respect to 2 U.S.C. Section 441b's long-standing restriction on the use of corporate general treasury funds for express advocacy. If there was ever any significant uncertainty about what counts as the functional equivalent of express advocacy, there has been little doubt about what counts as express advocacy since the magic words test of Buckley v. Valeo, 424 U.S. 1, 44, N. 52, 1976, per curiam. Yet even though Citizens United's briefs never once mentioned Section 441b's restriction
I
on
am
express
struggling
advocacy,
right now. This
even
is
though
hard.
restriction does not generate chilling concerns, and even though no one has suggested that Hillary counts as express advocacy, the majority nonetheless reaches out to opine that this statutory provision is invalid as well. Ante, at 50. 9. The majority adds that the distinction between facial and as-applied challenges does not have some automatic effect that mechanically controls the judicial task. Ante, at 14. I agree, but it does not follow that in any given case we should ignore the distinction, much less Citizens United v. Federal Elections COMMN. Opinion of Stevens, J. Finally, the majority suggests that though the scope of Citizens United's claim may be narrow, a facial ruling is necessary as a matter of remedy. Relying on a law review article, it asserts that Citizens United's dismissal of the facial challenge does not prevent us from making broader pronouncements of invalidity in properly as applied cases. Ante, at 14, quoting Fallon, as applied and facial challenges in third-party standing, 113 Harv. Elk Rev 1321, 1339, 2000, hereinafter Fallon, Accord, Ante, at 5, opinion of Roberts, C. J. Regardless whether we label Citizens United's claim a facial or as applied challenge, the consequences of the court's decision are the same. The majority is on firmer conceptual ground here. Yet even if one accepts this part of Professor Fallon's thesis, one must proceed to ask which as-applied challenges, if successful, will properly invite or entail invalidation of the underlying statute. Point 10. The paradigmatic case is a judicial determination that the legislature acted with an impermissible purpose in enacting a provision, as this carries the necessary implication that all future as-applied challenges to the provision must prevail. See Fallon 1339 to 1340. Citizens United's as-applied challenge was not of this sort. Until this court ordered re-argument, its contention was that BCRA Section 203 could not lawfully be applied to A. Inverted. Point 10. Professor Fallon proposes an intricate answer to this question that the majority ignores. Fallon 1327 to 1359. It bears mention that our colleagues have previously cited Professor Fallon's article for the exact opposite point from the one they wish to make today. In Gonzalez v. Carhart, 550 U.S. 124, 2007, the court explained that it is neither our obligation nor within our traditional institutional role to resolve questions of constitutionality with respect to each potential situation that might develop, and for this reason, as-applied challenges are the basic building blocks of constitutional adjudication. ID, at 168, opinion for the court by Kennedy, J. Quoting Fallon 1328, second alteration in original. Feature-length video-on-demand film, such as Hillary, or to a non-profit corporation exempt from taxation under 26 U.S.C. Section 501, C. 11 and funded overwhelmingly by individuals, such as itself. See brief for appellants 16 to 41. Success on either of these claims would not necessarily carry any implications for the validity of Section 203 as applied to other types of broadcasts, other types of corporations, or unions. It certainly would not invalidate the statute as applied to a large for-profit corporation.
Oh, no way, I might have actually made it out.
March 24th,
Holy cow, that took so much work.
for Citizens United emphasizing
And I still don't think I got the right materials.
nonprofit organization, which is very much like an MCFL corporation, and affirming that its argument definitely would not be the same if Hillary were distributed by General Motors. Point 12, there is no legitimate basis for resurrecting a facial chal. 11 Internal Revenue Code Section 501(c)(4) applies, inter alia, to non-profit organizations operated exclusively for the promotion of social welfare, the net earnings of which are devoted exclusively to charitable, educational, or recreational purposes. 12 The Chief Justice is therefore much too quick when he suggests that, even if considered in as-applied terms, a holding in this case that the act may not be applied to Citizens United, because corporate tie-ins as well as individuals enjoy the pertinent First Amendment rights would mean that any other corporation raising the same challenge would also win. Ante, at 4, concurring opinion. That conclusion.
I need 3, and I still don't have 3.
Citizens
Crap.
Plausible as applied arguments and instead take the implausible position that all corporations and all types of expenditures enjoy the same First Amendment protections, which always trump the interests in regulation. At times, the majority appears to endorse this extreme view. At other times, however, it appears to suggest that non-profit corporations have a better claim to First Amendment protection than for-profit corporations. See ante, at 2039. Advocacy organizations have a better claim than other non-profits. Ante, at 20. Domestic corporations have a better claim than foreign corporations. Ante, at 46 of 47. Small corporations have a better claim than large corporations. Ante, at 38 to 40. And printed matter has a better claim than broadcast communications. Ante, at 33. The majority never uses a multinational business corporation in its hypotheticals. Citizens United v. Federal Elections.
That's an interesting argument.
Opinion of Stevens, J. It is all the more distressing that our colleagues have manufactured a facial challenge, because the parties have advanced numerous ways to resolve the case that would facilitate electioneering by non-profit advocacy corporate tie-ins such as Citizens United, without toppling statutes and precedents. Which is to say, the majority has transgressed yet another cardinal principle of the judicial process. If it is not necessary to decide more, it is necessary not to decide more. PDK Labs, Inc. v. Drug Enforcement Admin, 362 F. 3D 786, 799, CADC 2004, Roberts, J. Concurring in part and concurring in judgment. Consider just 3 of the narrower grounds of decision that the majority has bypassed. First, the court could have ruled, on statutory grounds, that a feature-length film distributed through video on demand does not qualify as an electioneering communication under Section 203 of BCRA, 2 U.S.C. Section 441b. BCRA defines the term to encompass certain communications transmitted by broadcast, cable, or satellite. Section 434, F, 3a. When Congress was developing BCRA, the video-on-demand medium was still in its infancy, and legislators were focused on a very different sort of programming, short advertisements run on television or radio. See McConnell, 540 U.S., at 207. The sponsors of BCRA acknowledge that the FEC's implementing regulations do not clearly apply to video-on-demand transmissions. See brief for Senator John McCain et al. As Amici Curiae 17-19. In light of this ambiguity, the distinctive characteristics of video on demand, and the elementary rule that every reason able construction must be resorted to in order to save a statute from unconstitutionality. Hooper versus California, 155 U.S. 648, 657.
So what this really means is that the dissenting group of justices really genuinely tried their best to not let it go like this. Like, they genuinely put in some effort to use logic, to use existing case law, to use notably what the other team is not using, which is common sense.
Its brief says it is funded predominantly by donations from individuals who support its ideological message. Brief for appellant. 5. Numerous courts of appeal have held that de minimis business support does not, in itself, remove an otherwise qualifying organization from the ambit of MCFL. Point 14. This court could have simply followed their lead. Point 15. Finally, let us not forget Citizens United's as-applied constitutional challenge. Precisely because Citizens 13. The court entirely ignores this statutory argument. It concludes that Section 203 applies to Hillary on the basis of the film's content, ante, at 7 to 8, without considering the possibility that Section 203 does not apply to video-on-demand transmissions generally. 14. See Colorado Right to Life Calm, Inc. v. Kaufman, 498 F. 3D 1137, 1148, CA 10 2007, adopting this rule and noting that every other circuit to have addressed this issue has done likewise. Brief for independent sector as amicus curiae 10 to 11, collecting cases. The court rejects this solution in part because the government merely suggests it and does not say that it agrees with the interpretation. Ante, at 11. Our colleagues would thus punish a defendant for showing insufficient excitement about a ground it has advanced, at the same time that they decide the case on a ground the plaintiff expressly abandoned. The court also protests that a de minimis standard would require intricate case
I need this dice too.
Ante, at 12. But de minimis tests need not be intricate at all. A test that granted MCFL status to Section 501(c)(4) organizations if they received less than a fixed dollar amount of business donations in the previous year, or if such donations represent less than a fixed percentage of their total assets, would be perfectly easy to understand and administer. 15. Another bypassed ground, not briefed by the parties, would have been to revive the Snow-Jeffords Amendment in BCRA Section 203,
What amendment?
allowing certain non-profit corporations to pay for electioneering communications with general treasury funds, to the extent they can trace the payments to individual contributions. See brief for National Rifle Association as amicus curiae 5 to 15, arguing forcefully that Congress intended this result. Citizens United v. Federal Elections COMMN opinion of Stevens, J. United looks so much like the MCFL organizations we have exempted from regulation, while a feature-length video-on-demand film looks so unlike the types of electoral advocacy Congress has found deserving of regulation. This challenge is a substantial one. As the appellant's own arguments show, the court could have easily limited the breadth of its constitutional holding had it declined to adopt the novel notion that speakers and speech acts must always be treated identically and always spared expenditures restrictions in the political realm. Yet the court nonetheless turns its back on the as-applied review process that has been a staple of campaign finance litigation since Buckley v. Valeo, 424 U.S. 1, 1976, per curiam, and that was affirmed and expanded just 2 terms ago in WRTL, 551 U.S. 449. This brief tour of alternative grounds on which the case could have been decided is not meant to show that any of these grounds is ideal, though each is perfectly valid. Ante, at 12, majority opinion. Point 16. It is meant to show that there were principled, narrower paths that a court that was serious about judicial restraint could have taken. There was also the straightforward path, applying Austin and McConnell, just as the district court did in Holding. 16. The Chief Justice finds our discussion of these narrower solutions quite perplexing because we suggest that the court should latch on to one of them in order to avoid reaching the broader constitutional question, without doing the same ourselves. Ante, at 3. There is nothing perplexing about the matter, because we are not similarly situated to our colleagues in the majority.
Okay.
We do not share their view of the First Amendment. Our reading of the Constitution would not lead us to strike down any statutes or overturn any precedents in this case, and we therefore have no occasion to practice constitutional avoidance or to vindicate Citizens United's as-applied challenge. Each of the arguments made above is surely at least as strong as the statutory argument the court accepted in last year's Voting Rights Act case, Northwest Austin Municipal Util. DIST No. 1 versus Holder, 557 U.S. __, 2009. Opinion of Stevens, J. 2. The final principle of judicial process that the majority violates is the most transparent, stare decisis. I am not an absolutist when it comes to stare decisis, in the campaign finance area or in any other. No one is. But if this principle is to do any meaningful work in supporting the rule of law, it must at least demand a significant justification, beyond the preferences of 5 justices, for overturning settled doctrine. A decision to overrule should rest on some special reason over and above the belief that a prior case was wrongly decided. Planned Parenthood of Southeastern Pa v. Casey, 505 U.S. 833, 864, 1992. No such justification exists in this case, and to the contrary there are powerful prudential reasons to keep faith with our precedents. Point 17. The court's central argument for why stare decisis ought to be trumped is that it does not like Austin. The opinion was not well reasoned, our colleagues assert, and it conflicts with First Amendment principles. Ante, at 47. 48. This, of course, is the court's merits argument, the many defects in which we will soon consider. I am perfectly willing to concede that if one of our precedents were dead wrong in its reasoning or irreconcilable with the rest of our doctrine, there would be a compelling basis for revisiting it. But neither is true of Austin, as I explain at length in parts 3 and 4, infra, at 23 to 89, and restating a merits argument with additional vigor does not give it. 17. I will have more to say shortly about the merits, about why Austin and McConnell are not doctrinal outliers, as the court contends, and why their logic is not only defensible but also compelling. For present purposes, I limit the discussion to stare decisis specific considerations. Citizens United v. Federal Elections COMMN opinion of Stevens, J. Perhaps in recognition of this point, the court supplements its merits case with a smattering of assertions. The court proclaims that Austin is undermined by experience since its announcement. Ante, at 48. This is a curious claim to make in a case that lacks a developed record. The majority has no empirical evidence with which to substantiate the claim. We just have its ipse dixit that the real world has not been kind to Austin. Nor does the majority bother to specify in what sense Austin has been undermined. Instead it treats the reader to a string of non sequiturs. Our nation's speech dynamic is changing. Ante, at 48, as speakers have become adept at presenting citizens with sound bites, talking points, and scripted messages. Ibid. See, corporations do not have monolithic views. Ibid. How any of these ruminations weakens the force of stare decisis escapes my comprehension. Point 18. The majority also contends that the government's hesitation to rely on Austin's anti-distortion rationale, diminutive-ish, the principle of adhering to that precedent. Ante, at 48, see also Ante, at 11, opinion of Roberts, C.J. Government's litigating position is most important, T. 18. The Chief Justice suggests that Austin has been undermined by subsequent dissenting opinions. Ante, at 9. Under this view, it appears that the more times the court stands by a precedent in the face of requests to overrule it, the weaker that precedent becomes. The Chief Justice further suggests that Austin is uniquely destabilizing because it threatens to subvert our court's decisions even outside its particular facts, as when we applied its reasoning in McConnell. Ante, at 9. Once again, the theory seems to be that the more we utilize a precedent, the more we call it into question. For those who believe Austin was correctly decided, as the federal government and the states have long believed, as the majority of justices to have served on the court since Austin have believed, and as we continue to believe, there is nothing destabilizing about the prospect of its continued application. It is gutting campaign finance laws across the country, as the court does. Today, that will be destabilizing. Opinion of Stevens, J. Factor undermining Austin. Why it diminishes the value of stare decisis is left unexplained. We have never thought fit to overrule
I've been
precedent because
occupied grabbing some food and
nor should we.
taking care of a couple of things in real life, but I've had my wireless earbuds in the whole time while I've been setting stuff aside, and hey, at least it's nice to know that like Supreme Court justices aren't total idiots. They seemed to comprehend that having the decision be what it was prior to this was very good for society and not, you know, terribly disagreeable. States agreed with it. Every single Supreme Court justice since the people that ruled on it agreed with it. So why this $15 million conservative, why should this $15 million conservative political action committee slash non-profit group, why should they get to rewrite all of that idea that was well supported and accepted by American society after the
beginning of the 20th century. Why should we allow these people to totally rewrite that?
We have recognized that ius ter decisis has special force when legislators or citizens have acted in reliance on a previous decision, for in this instance overruling the decius. 19. Additionally, the majority cites some recent scholarship challenging the historical account of campaign finance. 1957. Ante, at 48. Austin did not so much as allude to this historical account, much less rely on it. Even if the scholarship cited by the majority is correct that certain campaign finance reforms were less deliberate or less benignly motivated than automobile workers suggested, the point remains that this body of law has played a significant and broadly accepted role in American political life for decades upon decades. Citizens United v. Federal Elections COMMN. Opinion of Stevens, J.
All right.
Schaum would dislodge settled rights and expectations or require
I am now
extensive
back.
legislative response. Hubbard versus United States.
My mouse live. There we go. I'm live.
695, 714, 1995, quoting Hilton versus South Carolina Public Railways comment.
I'm going to check real quick. I'm going to pause the reading. I'm going to check how YouTube audio sounds right now. Actually, it sounds pretty much fine. Cool. Sounds good. Actually, it sounds... Yep, good enough. All right, back to reading. I probably can do another few hours, realistically.
Stare decisis protects not only personal rights involving property or contract but also the ability of the elected branches to shape their laws in an effective and coherent fashion. Today's decision takes away a power that we have long permitted these branches to exercise. State legislatures have relied on their authority to regulate corporate electioneering, confirmed in Austin. For more than a century. 20, the federal Congress has relied on this authority for a comparable stretch of time, and it specifically relied on Austin throughout the years it spent developing and debating BCRA. The total record it compiled was 100,000 pages long. 21 Pulling out the rug beneath Congress after affirming the constitutionality of Section 203 6 years ago shows great disrespect for a co-equal branch. By removing one of its central components, today's ruling is a hash out of BCRA's delicate and interconnected regulatory scheme.
So now they're making the argument that the Bipartisan Campaign Reform Act... Hey, Aunt Noel. The Bipartisan Campaign Reform Act, or BCRA, which is... I hate the name of this act. Not the name, but the acronym, because it's BCRA. When I was in genetics in college, there was a gene that we learned about that's highly associated with breast cancer in humans, which I'm pretty sure is BRCA, the BRCA gene, which all women should attempt to get tested for because it's a really good indicator of whether or not a person may develop breast cancer throughout their lifetime. Highly affiliated. It's a gene that is very comorbid with this issue. That's the BRCA1 gene, and this stupid act in government, not in biology, is BCRA. And every time I read it, I go insane. But it's an act that denotes law, which was put together by, as they were saying, Congress, which is co-equal with the Supreme Court. So now they're getting into an argument of... It's not the kind of argument I would ever make, but it's the kind of argument someone who is so deeply entrenched into the existing systems that it's the best argument they could make, which is, hey, we have separation of powers, and you guys are acting out beyond a way that you're supposed to. You are stepping on the toes of Congress, who is our equal and who we divide power with. So we can't just spit in the face of their act and disregard the way that it could be applied just because some $15 million political propaganda company decided to talk to us about whether or not something they were going to do was going to be legal. I am enjoying the dissent's opinion.
540 U.S. at 172. Consider just one example of the distortions that will follow. Political parties are barred under BCRA from soliciting or spending soft money, funds that are not subject to the statute's disclosure requirements or its source and amount limitations. 2 FEC Section 441 I.
Okay.
McConnell, 540 U.S. at 122 to 126. Going forward, corporations and unions will be free to spend as much general treasury money as they wish on ads that support or attack specific 20 See brief for State of Montana et al. As Amici Curiae 5-13. See also Supper brief for Senator John McCain et al. As Amici Curiae 1A8A, listing 24 states that presently limit or prohibit independent electioneering.
Wow, I feel like the text-to speech is starting to struggle more.
The importance of the record in McConnell v.
It's really getting confused.
285, 2004. Opinion of Stevens, J. Candidates, whereas national parties will not be able to spend a dime of soft money on ads of any kind. The court's ruling thus dramatically enhances the role of corporations and unions, and the narrow interests they represent, vis-a-vis the role of political parties, and the broad coalitions they represent, in determining who will hold public office. Point 22.
Alright, I'm gonna try something to sketch.
At stake, the other stare decisis factors also
I'm gonna try to swim down there.
Considerations of antiquity are significant for similar reasons. McConnell is only 6 years old, but Austin has been on the books for 2 decades, and many of the statutes called into question by today's opinion have been on the books for a half-century or more. The court points to no intervening change in circumstances that warrants revisiting Austin. Certainly nothing relevant has changed since we decided WRTL 2 terms ago. And the court gives no reason to think that Austin...
The Wisconsin Right to Life. I know what that act is now.
In fact, no one has argued to us that Austin's rule has proved impracticable, and not a single for-profit corporate tie-in, union, or state has asked us to overrule it. Quite to the
It's
contrary,
just this extremely biased propaganda company that constructed this court case with the express purpose of pushing
22 to be sure. The majority may respond
things
that
like this.
Congress can correct the imbalance by removing BCRA's soft money limits. CFTR of Oral Arg 24, September 9, 2009, query of Kennedy, J. But this is no response to any legislature that takes campaign finance regulations seriously. It merely illustrates the breadth of the majority's deregulatory vision. Point 23 See brief for Committee for Economic Development as Amicus Curiae, brief for American Independent Business Alliance as Amicus Curiae. But see Supper brief for Chamber of Commerce of the United States of America as Amicus Curiae. Point 24 See brief for American Federation of Labor and Congress of Industrial Organizations as Amicus
Well, you were
Curiae.
not allowed to just manifest from a random wall.
For Independent Sector as Amicus Curiae 16.
It's not fair.
26 See brief for State of Montana et al. As Amici Curiae. Citizens United v. Federal Elections COMMN. Opinion of Stevens, J. Preserve Austin. As for McConnell, the portions of BCRA it upheld may be prolix, but all 3 branches of government have worked to make Section 203 as user-friendly as possibly. For instance, Congress established a special mechanism for expedited review of constitutional challenges. See note following 2 U.S.C. Section 437H. The FEC has established a standardized process, with clearly defined safe harbors, for corporations to claim that a particular electioneering communication is permissible under WRTL. See 11 CFR Section 114.15, 2009, 27 and, as noted above, the Chief Justice crafted his controlling opinion in WRTL with the express goal of maximizing clarity and administrability. 551 U.S. at 469 to 470, 473 to 474. The case for stare decisis may be bolstered, we have said, when subsequent rulings have reduced the impact of a precedent while reaffirming the decision's core ruling. Dickerson versus United States, 530. U.S. 428, 443, 2000, point 28. In the end, the court's rejection of Austin and McCann, 27. The FEC established this process following the court's June 2007 decision in that case, 551 U.S. 449. In the brief interval between the establishment of this process and the 2008 election, corporations and unions used it to make $108.5 million in electioneering communications. Supper brief for Appellee 22 to 23, FEC, Electioneering Communication Summary, online FEC.gov/forward/FEC.gov/finance/disclosure/
Oh no, not a link.
HTML.
Every time it reads a link, it's terrible.
January 18, 2010, and available in Clerk of Court's case file. Point 28 Concealy, Austin and McConnell were constitutional decisions, and we have often said that claims of stare decisis are at the weakest in that field, where our mistakes cannot be corrected by Congress. Veith versus Jubileer, 541 U.S. 267, 305, 2004, plurality opinion. As a general matter, this principle is a sound one. But the principle only takes on real force when an earlier ruling has obstructed the normal democratic process. It is the fear of
Oh,
making
nickel. Wow, I
mistakes
found it. Cool.
that cannot be corrected by Congress
Oh, that was easy.
that motivates us to review constitutional precedents with a more critical eye. Austin and McConnell did not obstruct state or congressional legislative power in any way. Although it is unclear how high a bar today's decision will pose to future attempts to regulate corporate electioneering, it will clearly restrain much legislative action. Nell comes down to nothing more than its disagreement with their results. Virtually every one of its arguments was made and rejected in those cases, and the majority opinion is essentially an amalgamation of resuscitated dissents. The only relevant thing that has changed since Austin and McConnell is the composition of this court. Today's ruling thus strikes at the vitals of stare decisis, the means by which we ensure that the law will not merely change erratically, but will develop in a principled linear way that permits society to presume that bedrock principles are founded in the law rather than in the proclivities of individuals. Vasquez versus Hillary, 474. U.S. 254, 265, 1986. 3. The novelty of the court's procedural dereliction and its approach to stare decisis is matched by the novelty of its ruling on the merits. The ruling rests on several premises. First, the court claims that Austin and McConnell have banned corporate speech. Second, it claims that the First Amendment precludes regulatory distinctions based on speaker identity, including the speaker's identity as a corporation. Third, it claims that Austin and McConnell were radical outliers in our First Amendment tradition and our campaign finance jurisprudence. Each of these claims is wrong. The so-called ban. Pervading the court's analysis is the ominous image of a categorical ban on corporate speech. Ante, at 45. Indeed, the majority invokes the specter of a ban on nearly every page of its opinion. Ante, at 1, 4, 7, 10, 11, 12, 13, 16, 20, 21, 22, 23, 26, 27, 28, 29, 30, 31, 33, 35,
Oh my god,
38,
what in the world are they listing?
45, 46, 47, 49, 54, 56. This characterization is highly misleading and needs to be corrected. In fact, it already has been. Our cases have repeatedly. Citizens United v. Federal Elections COMMN opinion of Stevens, J. pointed out that, contrary to the majority's critical assumptions, the statutes upheld in Austin and McConnell do not impose an absolute ban on all forms of corporate political spending. Austin, 494 U.S. at 660, see also McConnell, 540 U.S. at 203 to 204, Beaumont, 539 U.S. at 162 to 163. For starters, both statutes provide exemptions for PACs, separate segregated funds established by a corporation for political purposes. C2 Section 441B, B2, C, Michigan Comp Laws in Section 169.255, West 2005. The ability to form and administer separate segregated funds, we observed in McConnell, has provided corporations and unions with a constitutionally sufficient opportunity to engage and express advocacy. That has been this court's unanimous view. 540 U.S. at 203. Under BCRA, any corporation's stockholders and their families and its executive or administrative personnel and their families can pool their resources to finance electioneering communications. 2 U.S.C. Section 441B, B, 4, A, I. A significant and growing number of corporations avail themselves of this option. 29 during the most recent election cycle, corporate and union PACs raised nearly $1 billion. 30
Jesus.
Some
We should ban the existence of PACs too. That's clearly half of what I'm getting at here. But I'm going to learn more about PACs after I learn about this court case. That'll be a different video in a long time. Probably a month or two probably, as I slowly kind of learn and build up an understanding of these things.
29 FEC, number of federal PACs increases, http://fec.gov/press/press 2008/200808112poc count.html.30 see subbrief for Appellee 16, citing FEC statistics placing this figure at $840 million. The majority finds the PAC option inadequate in part because a. PAC is a separate association from the corporate tie-in. Ante, at 21. The formal separateness of PACs from their host corporations, which administer and control the PACs but which cannot funnel general treasury funds into them or force members to support them, is, of course, the whole point of the PAC mechanism. This issue, it is important to keep in mind that we have no record to show how substantial the burden really is, just the majority's own unsupported fact-finding, see ante, at 21 to 22. Like all other natural persons, every shareholder of every corporation remains entirely free under Austin and McConnell to do however much electioneering she pleases outside of the corporate form. The owners of a mom-and-pop store can simply place ads in their own names, rather than the store's. If ideologically aligned individuals wish to make unlimited expenditures through the corporate form, they may utilize an MCFL organize a tie-in that has policies in place to avoid becoming a conduit for business or union interests. CMCFL, for 79 US, at 263 to 264. The laws upheld in Austin and McConnell leave open many additional avenues for corporations' political speech. Consider the statutory provision we are ostensibly evaluating in this case, BCRA Section 203. It has no relation to genuine issue advertising, a category of corporate speech Congress found far more substantial than election-related advertising, see McConnell, 540 US, at 207, or to internet, telephone, and print advocacy. Point 31 like Numer. 31 roaming far afield from the case at hand, the majority worries that the government will use Section 203 to ban books, pamphlets, and blogs. Ante, at 20, 33, 49. Yet by its plain terms, Section 203 does not apply to printed material. C2USC Section 434, F3A, I, see also 11 CFR Section 100.29, C1E, electioneering communication does not include communications appearing in print media. And in light of the ordinary understanding of the terms broadcast, cable, and satellite, Section 434, F3A, I, coupled with Congress's clear aim of targeting a virtual torrent of televised election-related ads, McConnell, 540 US, at 207, we highly doubt that Section 203 could be interpreted to apply to a website or book that happens to be transmitted at some stage over airwaves or cable lines, or that the FEC would ever try to do so. See 11 CFR Section 100.26, exempting most Internet communications from regulation is advertising, Section 100.155, exempting uncompensated Internet activity from regulation as an expenditure, brief for Center for End. Pendant Media et al. As Amici Curiae 14, explaining that the FEC has Citizens United v. Federal Elections COMMN opinion of Stevens, J. US statutes, it exempts media companies' news stories, commentaries, and editorials from its electioneering restrictions, in recognition of the unique role played by the institutional press in sustaining public debate. Point 32c2. USC Section 434, F3B, I, McConnell, 540 US, at 208 to 209, see also Austin, 494 US, at 666 to 668. It also allows corporations to spend unlimited sums on political communications with their executives and shareholders, Section 441B, B2, A, 11 CFR Section 114.3, A1, to fund additional PAC activity through trade associations, 2 USC Section 441B, B4, D, to distribute voting guides and voting records, 11 CFR Sections 114.4, C4, 5, to underwrite voter registration and voter turnout activities, Section 114.3, C4, Section 114.4, C2, to host fundraising events for candidates within certain limits, Section 114.4, C, Section 114.2, F2, and to publicly endorse candidates through a press release and press conference, Section 114.4, C6. At the time Citizens United brought this lawsuit, the only types of speech that could be regulated under Section 203 were 1. Broadcast, cable, or satellite communications, 33. 2. Capable of reaching at least 50,000 persons in the relevant electorate, 34. 3. Made within 30 days of a primary or 60 days of a general federal election, 35. 4. By a labor union or a non-MCFL, non-media corporation, 36. 5. Paid for. Consistently construed, BCRA's media exemption to apply to a variety of non-traditional media. If it should, the government acknowledges there would be quite a good as-applied challenge. TR of Oral Arc 65, September 9, 2009, point 32. As the government points out, with a media corporation there is also a lesser risk that investors will not understand, learn about, or support the advocacy messages that the corporation disseminates. Sup. Reply brief for Apple E10. Everyone knows and expects that media outlets may seek to influence elections in this way. Point 332 U.S.C. Section 434 F3 A.I. Point 34 Section 434 F3 C. Point 35 Section 434 F.
Oh no. Oh no, they're listing a bunch of laws. Oh, dude, it sounds like a beat. This is terrible.
With general treasury funds, 37 and 6, susceptible of no reasonable interpretation other than as an appeal to vote for or against a specific candidate, 38. The category of communications meeting all of these criteria is not trivial, but the notion that corporate political speech has been suppressed, altogether, at 2, that corporations have been dead from the general public dialogue, at 25, or that a work of fiction such as Mr. Smith Goes to Washington might be covered, at 56 of 57, is nonsense. Point 39. Even the plaintiffs in McConnell, who had every incentive to depict BCRA as negatively as POS Cybele, declined to argue that Section 203's prohibition on certain uses of general treasury funds amounts to a complete ban. See 540 U.S. at 204. In many ways, then, Section 203 functions as a source restrict tie-in or a time, place, and manner restriction. It applies in a viewpoint-neutral fashion to a narrow subset of advocacy messages about clearly identified candidates for federal office, made during discrete time periods through discrete channels. In the case at hand, all Citizens United needed to do to broadcast Hillary right before the primary was to absorb business contributions or use the funds in its PAC, which by its own account is one of the most active conservative PACs in America, Citizens United Political Victory. 37 Section 441B, B, 2, C. Point 38 WRTL, 551 U.S. 449, 470, 2007, opinion of Roberts, C.J. 39. It is likewise nonsense to suggest that the FEC's business is to censor. At 18, quoting Friedman versus Maryland, 380 U.S. 51, 57, 1965. The FEC's business is to administer and enforce the campaign finance laws. The regulatory body at issue in Friedman was a state board of censors that had virtually unfettered discretion to bar distribution of motion picture films it deemed not to be moral and proper. CID, at 52 to 53, and N2. No movie could be shown in the state of Maryland that was not first approved and licensed by the Board of Censors. ID, at 52, N1. It is an understatement to say that Friedman is not on point, and the majority's characterization of the FEC is deeply
disconcerting.
Citizens United v. Federal Elections COMMN. Opinion of Stevens, J. Fund, http://www.cupbf.org/.http://40. So let us be clear, neither Austin nor McConnell held or implied that corporations may be silenced. The FEC is not a censor, and in the years since these cases were decided, corporations have continued to play a major role in the national dialogue. Laws such as Section
Even
203
when they
target a
couldn't
class
do
of
advertisements.
communications that is
Interesting
especially likely
argument.
to corrupt the political process, that is at least one degree removed from the views of individual citizens, and that may not even reflect the views of those who pay for it. Such laws burden political speech, and that is always a serious matter, demanding careful scrutiny. But the majority's incessant talk of a ban aims at a straw man. The second pillar of the court's opinion is its assertion that the government cannot restrict political speech based on the speaker's identity. Ante, at 30, accord, ante, at 1, 24, 26, 30, 31, 32, 33, 34, 49, 50. The case on which it relies for this proposition is First Nat Bank of Boston versus Bellotti, 435 U.S. 765, 1978. As I shall explain, infra, at 52 to 55, the holding in that case was far narrower than the court implies. Like its paeans to unfettered discourse, the court's denunciation of identity-based distinctions may have rhetorical appeal, but it obscures reality. Our jurisprudence over the past 216 years has rejected an absolutist interpretation of the First Amendment. WRTL 551 U.S. at 482, opinion of Roberts, C.J. The 40 Citizens United has administered this PAC for over a decade. See defendant FEC's memorandum in opposition to plaintiff's second motion for preliminary injunction in numbers 07-2240, RCL, RWR,
Lithium and
page
kyanite
20.
now.
Citizens United also operates multiple 527 organizations that engage in partisan political activity.
You have kyanite, I just need
See
lithium now.
defendant FEC's statement of material facts as to which
A little
there is
more
no
lithium and
genuine
I'll be
dispute in
done.
numbers
I'll be able to go down really,
07-2240
really deep.
DC, paragraphs 22 through 24. First Amendment provides that Congress shall make no law abridging the freedom of speech or of the press. Apart perhaps from measures designed to protect the press, that text might seem to permit no distinctions of any kind. Yet in a variety of contexts, we have held that speech can be regulated differentially on account of the speaker's identity, when identity is understood in categorical or institutional terms. The government routinely places special restrictions on the speech rights of students, 41 prisoners, 42 members of the armed forces, 43 foreigners, 44 and its own employees. 45 When such restrictions are justified by a legitimate governmental interest, they do not necessarily raise constitutional problems. 46 In 41C, e.g., Bethel School DST number 403 V. Fraser, 478 U.S. 675, 682, 1986, T. Constitutional rights of students in public school are not automatically coextensive with the rights of adults in other settings. 42C, e.g., Jones v. North Carolina Prisoners Labor Union Incorporated, 433. U.S. 119, 129, 1977, in a prison context, an inmate does not retain those First Amendment rights that are inconsistent with his status as a prisoner or with the legitimate penological objectives of the correction system, internal quotation marks omitted. 43C, e.g., Parker v. Levy, 417 U.S. 733, 758, 1974. While the members of the military are not excluded from the protection granted by the First Amendment, the different character of the military community and of the military mission requires a different application of those protections. 44C, e.g., 2 U.S.C. Section 441E, A.1, foreign nationals may not directly or indirectly make contributions or independent expenditures in connection with a U.S. election. 45C, e.g., Civil Service Com. N.V. Letter carriers, 413 U.S. 548, 1973, upholding statute prohibiting executive branch employees from taking any active part in political management or in political campaigns, internal quotation marks omitted, Public Workers v. Mitchell, 330 U.S. 75, 1947, same, United States v. Wurzbach, 280 U.S. 396, 1930, upholding statute prohibiting federal employees from making contributions to members of Congress for any political purpose whatever, internal quotation marks omitted, ex part. Curtis, 106 U.S. 371, 1882, upholding statute prohibiting certain federal employees from giving money to other employees for political purposes. 46 The majority states that the cases just cited are inapposite. B. Citizens United v. Federal Elections COMMN. Opinion of Stevens, J. Contrast to the blanket rule that the majority espouses, our cases recognize that the government's interests may be more or less compelling with respect to different classes of speakers. 47 CF Minneapolis Star and Tribune Company v. Minnesota Comar of Revenue, 460 U.S. 575, 585, 1983.
Oh my gosh, stop listing more laws. I don't know a single human being, including these justices, that could ever possibly have all of these memorized at the same time.
Rights of certain categories of speakers, in certain contexts, are not automatically coextensive with the rights that are normally accorded to members of our society. Morse v. Frederick, 551 U.S. 393, 396 to 397, 404, 2007, quoting Bethel School DST number 403 v. Fraser, 478
Oh my God.
U.S. 675, 682, 1986. The free speech guarantee thus does not render every other public interest an illegitimate basis for qualifying a speaker's autonomy. Society could scarcely function if it
Wow,
did.
I'm gonna run out of air. That'll be the
It's
first
fair to
time in
say
a
that
long
our
time
First
that I've made that
Amendment
exact
argument
mistake in
has
this
frowned
game.
on certain identity-based distinctions.
Usually
Los
I don't
Angeles
mess
Police
that exact
Department
thing up.
v. United
Weird.
Recording Publishing Corporation. Because they stand only for the
Yep, there you
proposition
go.
that
I'm
there are
gonna die.
certain governmental functions
Dang.
that cannot operate without some restrictions on
When was the
particular
last time
kinds
I
of
ever made
speech.
that mistake in this game?
Ante at 25.
I just got way too locked in, I
Authority's
guess.
creative suggestion that these cases stand only for that one
Yep,
proposition
I lost some
is quite
items.
implausible. In any event,
Wow.
the proposition lies at the
Weird.
heart of this case, as Congress and half the state legislatures have concluded, over many decades, that their core functions of administering elections and pass ing legislation cannot operate effectively without some narrow restrictions on corporate electioneering paid for by general treasury funds. Point 47. Outside of the law, of course, it is a commonplace that the identity and incentives of the speaker might be relevant to an assessment of his speech. See Aristotle, Poetics 43-44. Heath translate 1996. In evaluating any utterance or action, one must take into account not just the moral qualities of what is actually done or said, but also the identity of the agent or speaker, the addressee, the occasion, the means, and the motive. The insight that the identity of speakers is a proper subject of regulatory concern, it bears noting, motivates the disclaimer and disclosure provisions that the court today upholds. 528 U.S. 32, 47, N4, 1999.
Leave me alone.
Stevens, J.
Leave me alone.
Particularly those that may reflect invidious discrimination or preferential treatment of a politically powerful group. But it is simply incorrect to suggest that we have prohibited all legislative distinctions based on identity or content. Not even close. The election context is distinctive in many
Warning,
ways,
creature
and
attack.
the court, of course, is right that the First Amendment closely guards political speech. But in this context, too, the authority of legislatures to enact viewpoint-neutral regulations based on content and identity is well settled. We have, for example, allowed state-run
Oh, I'm charging.
broadcasters
Good.
to exclude
That's what I wanted.
independent candidates from televised debates.
Alright, I'm gonna wait until this is fully recharged.
Arkansas Edit Television Com NV Forbes, 523 U.S. 666, 1998, .48. We have upheld statutes that prohibit the distribution or display of campaign materials near a polling place. Burson vs. Freeman, 504 U.S. 191, 1992, .49. Although we have not reviewed them directly, we have never cast doubt on laws that place special restrictions on campaign spending by foreign nationals. See, e.g., TUSC Section 441E, A1. And we have consistently approved laws that bar government employees, but not others, from contribution. 48. I dissented in Forbes because the broadcaster's decision to exclude the respondent from its debate was done on the basis of entirely subjective, ad hoc judgments. 523 U.S. at 690, that suggested anti-competitive viewpoint discrimination, ID, at 693 to 694, and lacked a compelling justification. Needless to say, my concerns do not apply to the instant case. 49. The law at issue in Burson was far from unusual. LL 50 states, the court observed, limit access to the areas in or around polling places. 504 U.S. at 206, see also note, 91 Kentucky LJ 715, 729, N89, 747 to 769, 2003, collecting statutes. I dissented in Burson because the evidence adduced to justify Tennessee's law was exceptionally thin, 504 U.S. at 219, and the reason for the restriction had disappeared over time, ID at 200.
Oh man, the voice, the text-to-speech is really struggling. I don't think it likes the formatting of these documents.
Regulation of campaign-related expression. ID at 225. These criticisms are inapplicable to the case before us. Citizens United v. Federal Elections COMMN opinion of Stevens, J. Doing to or participating in political activities. CN 45, Supra. These statutes burden the political expression of one class of speakers, namely, civil servants. Yet we have sustained them on the basis of long-standing practice in Congress's reasoned judgment that certain regulations which leave untouched full participation in political decisions at the ballot box, civil service Com NV. Letter carriers, 413 U.S. 548, 556, 1973, internal quotation marks omitted, help ensure that public officials are sufficiently free from improper influences, ID, at 564, and that confidence in the system of representative government is not eroded to a disastrous extent, ID, at 565. The same logic applies to this case with additional force because it is the identity of corporations, rather than individuals, that the legislature has taken into account. As we have unanimously observed, legislatures are entitled to decide that the special characteristics of the corporate structure require particularly careful regulation in an electoral context. NRWC 459 U.S. at 209 and 210.50 not only has the distinctive potential of corporations to corrupt the electoral process long been recognized, but within the area of campaign finance, corporate spending is also furthest from the core of political expression, since corporations' First Amendment speech and association interests are derived largely from those of their members and of the public in receiving information. Beaumont, 539 U.S. at 161 N8, citation omitted. Campaign finance distinctions based on corporate identity tend to be less worrisome, in other words, because the speakers are not natural persons, much less members of our political community, and 50. They are likewise entitled to regulate media corporations differently from other corporations to ensure that the law does not hinder or prevent the institutional press from reporting on and publishing editorials about newsworthy events. McConnell, 540 U.S. at 208, quoting Austin versus Michigan Chamber of Commerce, 494 U.S. 652, 668, 1990. The governmental interests are of the highest order. Furthermore, when corporations, as a class, are distinguished from non-corporations, as a class, there is a lesser risk that regulatory distinctions will reflect invidious discrimination or political favoritism. If taken seriously, our colleagues' assumption that the identity of a speaker has no relevance to the government's ability to regulate political speech would lead to some remarkable conclusions. Such an assumption would have accorded the propaganda
Every second and a half or so.
Well,
Well, I essentially have to get fully charged because I have to go back up to the surface and scan a tablet that I forgot to scan because I'm dumb and trying to interpret Supreme Court speech.
Enhance the relative voice of some, i.e., humans, over others, i.e., non-humans. Ante, at 33, quoting Buckley, 424 U.S., at 49.51 under the majority's view, I suppose it may be a First Amendment problem that corporations are not permitted to vote, given that voting is, among other things, a 51. The court all but confesses that a categorical approach to speaker identity is untenable when it acknowledges that Congress might be allowed to take measures aimed at preventing foreign individuals or associations from influencing our nation's political process. Ante, at 46 to 47. Such measures have been a part of U.S. campaign finance law for many years. The notion that Congress might lack the authority to distinguish foreigners from citizens in the regulation of electioneering would certainly have surprised the framers, whose obsession with foreign influence derived from a fear that foreign powers and individuals had no basic investment in the well-being of the country. Teach out, the Anti-Corruption Principle, 94 Cornell L. Rev. 341, 893. In point 245, 2009, hereinafter teach out, see also U.S. I, Section 9, CL 8, N. O person holding any office of trust or trust shall, without the consent of the Congress, except of any present, emolument, office, or title, of any kind whatever, from any king, prince, or foreign state. Professor Teachout observes that a corporation might be analogized to a foreign power in this respect, inasmuch as its legal loyalties necessarily exclude Teachout 393 and 245. Citizens United v. Federal Elections COMMN opinion of Stevens, J. Form of speech point 52.
Well, what's nice is while this charges, I just get to focus on the document, so that's pretty okay.
Identity-based distinctions, without ever explaining why corporate identity demands the same treatment as individual identity. Only the most wooden approach to the First Amendment could justify the unprecedented line it seeks to draw.
That might perfectly summarize what it is I think I might want to say in my video about this. In short, the court dramatically overstates its critique of identity-based distinctions without ever explaining why corporate identity demands the same treatment as individual identity. Businesses are not people. It's not that complicated. Thank you, Justice Stevens. Good God, I can't believe I'm agreeing with the Supreme Court Justice.
In short, the court dramatically overstates its critique of identity-based distinctions, without ever explaining why corporate identity demands the same treatment as individual identity. Only the most blatant approach to the First Amendment could justify the unprecedented line it seeks to draw. A third fulcrum of the court's opinion is the idea that Austin and McConnell are radical outliers, aberration S, in our First Amendment tradition. Ante, at 39, see also Ante, at 45, 56, professing fidelity to our law and our tradition. The court has it exactly backwards. It is today's holding that is the radical departure from what has been settled First Amendment law. To see why, it is useful to take a long view. 1. Original understandings. Let us start from the beginning. The court invokes ancient First Amendment principles, ante,
Whoa.
1, internal quotation marks omitted, and original understandings, ante, at 37 to 38, to defend today's ruling, yet it makes only a perfunctory attempt to ground its analysis in the principles or understandings of those who drafted and ratified the amendment. Perhaps this is because there is not a scintilla of evidence to support the notion that anyone.
It does suck how it cuts up stuff like this.
And the idea of progress 59 to 60, 1978, a Mickeljohn, political freedom, the constitutional powers of the people 39 to 40, 1965, Tokaji, First Amendment equal protection on discretion, inequality, and participation, 101 Michigan L. 2409, 2508 to 2509, 2000. Electoral outcomes. C.F. Strauss, Corruption, Equality, and Campaign Finance Reform, 94 column. Eld. Rev. 1369, 1383 to 1384, 1994, hereinafter Strauss. Opinion of Stevens, J. Believed it would preclude regulatory distinctions based on the corporate form. To the extent that the framers' views are discernible and relevant to the disposition of this case, they would appear to cut strongly against the majority's position. This is not only because the framers and their contemporaries conceived of speech more narrowly than we now think of it, see Bork, Neutral Principles and Some First Amendment Problems, 47 INDL J1, 22, 1971, but also because they held very different views about the nature of the First Amendment right and the role of corporations in society. Those few corporations that existed at the found ING were authorized by grant of a special legislative charter. 53 corporate sponsors would petition the legislature, and the legislature, if amenable, would issue a charter that specified the corporation's powers and purposes and authoritative corporate organization, including the internal structure. 53 scholars have found that only a handful of business corporations were issued charters during the colonial period, and only a few hundred during all of the 18th century. American Business Corporations until 1860, page 197, 1954, Ella Friedman, A History of American Law 188 to 189, 2D edition 1985, Baldwin, American Business Corporations before 1789, 8 a.m. History.
Oh, I'm still getting attacked. Oh, my thing's gonna explode soon, probably.
1903.
Oh, I see. I've got a bunch of these lava things
Whereas we say that a few hundred charters
stuck to the outside of my ship.
During the 18th century, he says that the number is approximately 335. Ante, at 2, concurring opinion. Justice Scalia also raises the more serious point that it is improper to assess
Time to mess him up.
by today's standards. Ante, at 3, though I believe he fails to substantiate his claim that the corporation was a familiar figure in American
what can I hit that?
life by the century's end, ibid, internal quotation marks omitted. His formulation of that claim is also misleading, because the relevant reference point is not 1800 but the date of the First Amendment's ratification, in 1791. And at that time, the number of business charters must have been significantly smaller than 335, because the pace of chartering only began to pick up steam in the last decade of the 18th century. More than half of the century's total business charters were issued between 1796 and 1800. Friedman, History of American Law, at 189. Citizens United v.
Oh no, he's staring right at me.
Opinion of Stevens.
Oh, that killed me instantly.
Corporation.
The shame.
J. Hurst, The Legitimacy of the Business Corporation in the Law of the United States 1780 to 1970. Pages
I died. I am noticing that.
1970, reprint 2004. Corporations were CRE-aided, supervised, and conceptualized as quasi-public entities, designed to serve a social function for the state. Hanlon and Hanlon, Origin of the American Business Corporation, 5J.
340. I'm still so far from being fully charged. This sucks.
1945. It was as some that they were legally privileged organizations that had to be closely scrutinized by the legislature because their purposes had to be made consistent with public welfare. R. Sevoy, Origins of the American Business Corporation, 1784 to 1855, page 5, 1982. The individualized charter mode of incorporation reflected the cloud of disfavor under which corporations labored in the early years of this nation. 1 W. Fletcher, Cyclopedia of the Law of Corporations, Section 2, page 8, Rev. Edition 2006. See also Lewis K. Liggett Company v. LE, 288 U.S. 517, 548 to 549, 1933. Brandeis, J. Dissenting, Discussing Fears of the Evils of Business Corporations, Ella Friedman. A History of American Law 194, 2D Edition 1985. The word soulless constantly recurs in.
Let me see mouth exhaust. I'm not sure what's not being seen well.
Concentrate the worst urges of whole groups of men. Thomas Jefferson famously fretted that corporations would subvert the Republic. 54 General Incorporation Statutes and widespread acceptance of business
I see.
corporations as socially
It does leave
useful
some out.
actors did not emerge until the 1800s. See Hans Mann and Krachman, The End of History for Corporate Law, 89 GOLJ, 439, 440, 2001, hereinafter Hansman. And Krachman, A. LL General Business Corporation Statute.
I'll see if that fixes things.
Statutes appear to date from well after 1800 inch. 54C letter from Thomas Jefferson to Tom Logan, November 12, 1816, and 12 The Works of Thomas Jefferson 42, 44, P. Ford edition 1905. I hope we shall crush in its birth the aristocracy of our moneyed corporations which dare already to challenge our government to a trial of strength and bid defiance to.
Whoa, Thomas Jefferson, you're getting into it. Do a trial of strength and bid defiance to the laws of this country. Wow, I don't know how I feel about that. That sounds like very pro big government and strong government, hearing Thomas Jefferson say that. What am I seeing? Okay. Weird. I'm vibing with the fact that Thomas Jefferson is being like, hey, corporations can't be trusted. They're going to try to bend the rules. But I also don't really fuck with the extent to which Thomas Jefferson is like, ooh, the law. The law means everything. Don't stand in the face of our powerful government. I don't like the vibe of that. That sounds a little slippery slope to fascism-y to me, but whatever.
The laws of our country. Opinion of Stevens, J. The framers thus took it as a given that corporations could be comprehensively regulated in the service of the public welfare. Unlike our colleagues, they had little trouble distinguishing corporations from human beings, and when they constitutionalized the right to free speech in the First Amendment, it was the free speech of individual Americans that they had in mind. 55 While individuals might join together to exercise their speech rights, Business corporations, at least, were plainly not seen as facilitating such associational
Right, that
or
works.
expressive ends. Even the notion
Okay,
that
it
business
should be set now.
corporations could invoke the First
It's gonna cut off this like subtitle, but this will be read about 100 times for each page. This will be read, so it should show the entire document for the very first sentence better. But I'm okay with cutting off this little top part here. It's just gonna say whose opinion is whose and like what subtitle is which.
First Amendment would probably have been quite a novelty, given that at the time, the legitimacy of every corporate activity was thought to rest entirely in a concession of the sovereign. Shelby, Autonomy, Debate, and Corporate Speech, 18 Hastings Constable L. 541 Quetzales, 578, 1991, CF Trustees of Dartmouth College vs. Woodward, for Wheat. 518, 636. 55 inches normal usage then, as now, the term speech referred to oral communications by individuals. See, e.g., 2S. Johnson, Dictionary of the English Language 1853 to 1854, 4th edition
124 of 183, so 40 more pages. You know what? There's no way I beat Subnautica before this is over.
Dartmouth
Not a single
College
chance.
vs. Woodward, for Wheat. 518, 636. 55 inches normal usage then, as now, the term speech referred to oral communications by individuals. See, e.g., 2S. Johnson, Dictionary of the English Language 1853 to 1854, 4th edition 1773, reprinted 1978, listing as primary definition of speech, the power of articulate utterance, the power of expressing thoughts by vocal words, 2N. Webster, American Dictionary of the English Language, 1828, reprinted 1970, listing as primary definition of speech, the faculty of uttering articulate sounds or words, as in human beings, the faculty of expressing thoughts by words or articulate sounds. Speech was given to man by his creator for the noblest purposes. Indeed, it has been claimed that the notion of institutional speech did not exist in post-revolutionary America. Fagundes, state actors as First Amendment speakers, 100 NW UL Rev. 1637, 1654, 2006. See also Bazanson, Institutional Speech, 80 Iowa Elk Rev. 735.
Alright, my microphone transmitter is now fully charged, but my microphone receiver is now dying.
Of the 18th century,
So I'm
the
going
idea
to
that
plug it in.
was
I'm gonna have to check to see if charging introduces a bunch of electrical noise or not.
Given that corporations were
Let me check
conceived of as
this.
artificial entities and do not
I'll
have
pause the
technical-
audio. I'm gonna mute my desktop audio for you all. I mean, it sounds fine. I didn't notice how noticeable the overall noise floor of where I am sticks out. Because of the noise gate that I have set up. I didn't realize how annoying that is. Well, so it goes. Right, let me unmute. There you go.
Citizens United v. Federal Elections COMMN. Opinion of Stevens, J. 1819, Marshall, C.J. A corporation is an artificial being, invisible.
Yeah, I'm getting the lava
and
larva
existing
now.
only in contemplation of law. Being the mere creature of law, it possesses only those properties which the charter of its
I'm having to deal with that.
Speaker diversity, Austin and Metro Broadcasting.
The Sea Dragon is not
1990
being nice.
SCC Rev 105, 129. The framers of the First Amendment could scarcely have anticipated its application to the corporation form. That, of course, ought not to be dispositive.
Oh my god.
What is
You already killed me once
is
earlier.
an understanding of who was supposed to be the
Oh
beneficiary
god.
of the free speech
Get away! Stop!
In light of these background
Leave me
practices and
alone!
understandings, It seems to me implausible that the framers believed the freedom of speech would extend equally to
Dude,
all
I'm just
corporate
trying to
entities,
charge.
much
Leave
less
me
that it would
alone.
preclude legislatures from taking limited measures
Alright, I
guard
think I
against
know what I'm
corporate
doing. I'm just
capture of
gonna go back
elections.
up. I'm gonna grab my stuff. I'm gonna
The
do my
court
thing.
observes that the
I'm getting out
framers
of
drew
here.
on diverse intellectual sources, communicated through
40%
newspapers,
should be
and
enough,
aimed to provide
hopefully.
greater freedom of speech than had existed in England.
Get off of me, bro.
At 37.
Get
Having
off!
made accurate observations, the court concludes that
Are you helping me
the
up
First
now? What are you
Amendment was
doing?
certainly not understood to condone the suppression of political speech in society's most salient media. Ibid. This conclusion is far from certain, given that many historians believe the framers were focused on prior restraints on publication and did not understand the First Amendment to prevent the subsequent punishment of such publications as may be deemed contrary to the public welfare. Near versus Minnesota XREL.
Well, now I should be near a
Also,
ghost leviathan. Where's it at?
283 U.S. 696,
Oh, I found it. It's currently attacking me.
1931.
Wow.
Yet,
I never
even if
saw
the
that coming.
majority's
I really
conclusion
never
were
did.
correct, it would tell us only that the First Amendment was understood to protect political speech in certain media.
Holy
It would
crap,
tell
what
us
is this
little
thing
about
doing?
whether the amendment was understood to protect general treasury election. Earring expenditures by
Oh my
corporations,
God.
and to what extent?
This is so annoying.
Opinion of Stevens, J. As a matter of original expectation,
Leave me
it seems
alone.
absurd to
Holy
think that
cow.
The First Amendment prohibits legislators from taking into account the corporate identity of a sponsor.
Oh,
of
leave me
electoral
alone.
advocacy. As a matter of original meaning, it likewise seems baseless unless one evaluates the First Amendment's principles, ante, at 1:48.
Good God.
Its purpose, ante, at 5, opinion of Roberts, C.J., at such a high level of generality that the historical understandings of the amendment cease to be a meaningful constraint on the judicial
God,
branch.
stupid
This
hammerhead
sheds a
centipede thing.
revelatory light on the assumption of some that an impartial judge's application of an originalist methodology
Leave
is
me
likely
alone.
to yield more determinate answers, or to play a more
Just
decisive role in the
get a hobby,
decisional
bro.
process than his or
Get a
her views
life.
about sound
Go away.
policy.
Literally,
Justice Scalia
touch
criticizes
grass.
the foregoing
Go
discussion for
away.
failing to adduce statements
You
from the
centipede
founding era
thing.
show ING that
Oh,
corporations
that's
were
bad.
understood
I
to
think
be
I run out of
excluded
power or
from the
something.
First Amendment's free speech guarantee. Ante, at 1:29.
No, I
Of
guess it
course,
just attacked
Justice
it a
Scalia
bunch,
adduces
probably.
no statements to suggest the contrary
Yeah,
proposition,
it just
or
attacked
even
it a
to
bunch.
suggest that the contrary proposition better reflects the
Well,
kind of right that the
who
drafters
goes?
and ratifiers of the free speech clause thought they were
Let's see.
enshrining.
Five
Although
real quick.
Justice Scalia makes a perfectly
Alright.
sensible argument that an individual's
Ridiculous.
right to speak entails a right to speak with others for a common cause, CFM-CFL, for 79 U.S. 238, he does not explain why those two rights must be precisely identical, or why that principle applies to electioneering by corporate tie-ins that serve no common cause. Ante, at 8. Nothing in his account dislodges my basic
Go
belief
away.
that members of the founding generation
Go away.
held a cautious view of corporate
No!
and a narrow view of corporate rights, not that they
Leave me alone.
despised corporations, ante, at 2, and that they conceptualized
Oh my God,
speech
bro,
in
you are
individualistic
actually...
terms. If no prominent
What
framer
is wrong
bothered
with you?
to articulate that corporate speech would. Citizens United v. Federal Election COMMN opinion of Stevens, J.
Creature attack?
have
I
thus
didn't
established
notice.
an individual speech that may well
I
be
never
because the
knew
contrary
until right now.
proposition,
Thank you
if
for
not
letting me
also
know.
the very notion of corporate speech was inconceivable. 56. Justice Scalia also emphasizes the unqualified nature of the First Amendment text. Ante, at 2:8. Yet he would seemingly
Leave
read
me
out the Free
alone.
Press Clause. How else could he claim that my purported views on newspapers
External hull
must track
damage?
my
Who
views
knew?
on corporations generally? Ante,
Fire
at
detected.
6:57.
Not this
Like
again.
virtually all modern lawyers, Justice Scalia presumably believes that the First Amendment restricts the executive, even though its language refers to Congress alone. In any event,
The
text
fire's
only leads us
usually
back
down
to the
here, isn't it?
question
Yeah,
for
it
what
is.
is guaranteed the freedom of speech, and, just as critically, what that freedom consists of and under what circumstances it may be limited. Justice Scalia appears to believe that because corporate tie-ins are created and utilized by individuals, it follows, as 56 post-ratification practice bolsters the conclusion that the First Amendment, as originally understood, ante, at 37, did not give corporations political speech rights on a par with the rights of
You're
individuals.
kidding me.
Well into the modern era of general incorporation statutes, common law was generally interpreted as prohibiting corporate political participation. First Nat Bank of Boston versus Bellotti, 435 U.S. 765, 819.
I swear to God, if you don't leave me alone.
J. Dissenting. And this court did not recognize any First Amendment protections for corporations until the middle part of the 20th century. See ante, at 25 to 26, listing cases, point 57. In fact, the Free Press Clause might be turned against Justice Scalia, for two reasons. First, we learn from it that the drafters of the First Amendment did draw distinctions, explicit distinctions, between types of speakers, or speech outlets or forms. Second, the court's strongest historical evidence all relates to the framers' views on the press. See ante, at 37 to 38, ante, at 4 to 6, Scalia, J.
Get the hell out of here.
While the court tries to sweep this evidence into the Free Speech Clause, the Free Press Clause provides a more natural textual home. The text in history highlighted by our colleagues suggests why one type of corporate tie-in, those that are part of the press, might be able to claim special First Amendment status, and therefore why some kinds of identity-based distinctions might be permissible after all. Once one accepts that much, the intellectual edifice of the majority opinion crumbles.
I'm half tempted to just go out and kill that thing, but I won't.
By the First Amendment and equally
Making it hard to pay attention to the document I actually want to listen to.
At 7 to 8. That conclusion certainly does not follow as a logical matter, and Justice Scalia fails to explain why the original public meaning leads it to follow as a matter of interpretation. The truth is we cannot be certain how a law such as BCRA Section 203 meshes with the original meaning of the First Amendment. Point 58. I have given several reasons why I believe the Constitution would have been understood then, and ought to be understood now, to permit reasonable restrict tie-ins on corporate electioneering, and I will give many more reasons in the pages to come. The court enlists the framers in its defense without seriously grappling with their understandings of corporations or the free speech right, or with the Republican principles that underlay those understandings. In fairness, our campaign finance jurisprudence has never attended very closely to the views of the framers. See Randall versus Sorrell, 548 U.S. 230, 280, 2006, Stevens, J. Dissenting, whose political universe differed profoundly from that of today. We have long since held that corporations are covered by the First Amendment, and many legal scholars have long since rejected the Constitution theory of the corporation. But historical context is usually relevant, ibid, internal quotation marks omit TED, and in light of the court's effort to cast itself as guardian of ancient values, it pays to remember that nothing in our constitutional history dictates today's outcome. To the contrary, this history helps illuminate just how extraordinarily dissonant the decision is. 58 CFL, Levy, Legacy of Suppression, Freedom of Speech and Press in Early American History 4, 1960. The meaning of no other clause of the Bill of Rights at the time of its framing and ratification has been so obscure to us as the Free Speech and Press Clause. Citizens United v. Federal Elections COMMN. Opinion of Stevens, J. 2. Legislative and judicial interpretation. A century of more recent history puts to rest any notion that today's ruling is faithful to our First Amendment tradition. At the federal level, the express distinction between corporate and individual political spending on elections stretches back to 1907, when Congress passed the Tillman Act, ch. 420, 34 Stat. 864, banning all corporate contributions to candidates. The Senate report on the legislation observed that, the evils of the use of corporate money in connection with political elections are so generally recognized that the committee deems it unnecessary to make any argument in favor of the general purpose of this measure. It is in the interest of good government and calculated to promote purity in the selection of public officials. S. Republic No. 3056, 59th Con, First Session, 2, 1906. President Roosevelt, in his 1905 annual message to Congress, declared, all contributions by corporations to any political committee or for any political purpose should be forbidden by law. Directors should not be permitted to use stockholders' money for such purposes, and, moreover, a prohibition of this kind would be, as far as it went, an effective method of stopping the evils aimed at in corrupt practices acts. United States versus Otto. The court has surveyed the history leading up to the Tillman Act several times. See WRTL, 551 U.S., at 508 to 510, Souter, J. Dissenting, McConnell, 540 U.S., at 115, Automobile Workers, 352 U.S., at 507.
Alright, I'm going to the surface, and I'm scanning the crap that I need to scan.
It is enough to say that the act was primarily driven by two pressing concerns. First, the enormous power corporations had come to wield in federal elections, with the accompanying threat of both actual corruption and a public perception of corruption. Opinion of Stevens, J. And second, a respect for the interest of shareholders and members in preventing the use of their money to support candidates they opposed. Seabed, United States v. CIO, 335 U.S. 106, 113, 1948, Winkler, Other People's Money, Corporations, Agency Costs, and Campaign Finance Law, 92 GOLJ 871, 2004. Over the years, the limitations on corporate political spending have been modified in a number of ways, as Congress responded to changes in the American economy and political practices that threatened to displace the Commonweal. Justice Souter recently traced these developments at length.
Displace the Commonwealth? Was that an actual spelling error? The Commonwealth? That threatened to displace the Commonwealth. Unless the word Commonweal is a word. The word Commonweal is not a word.
McConnell, 251F, Sup 2D, at 188 to 205. The Taft-Hartley Act of 1947 is of special significance for this case. In that act passed more than 60 years ago, Congress extended the prohibition on corporate support of candidates to cover...
Wow, I can't believe I've watched, I've read these documents hard enough that I can tell when there's spelling errors. You know, I recall very few spelling errors in all of Project 2025. Like, very few. Maybe one.
Easily able to defeat the purposes of the act by supporting candidates through other means. WRTL, 551 US, at 511. Souter, J., dissenting, citing S., Republic No. 1, 80th Cong. First session, 38 to 39, 1947. Our colleagues emphasized that in two cases from the middle of the 20th century, several justices wrote SEPA. 59 as the majority notes, there is some academic debate about the precise origins of these developments. Ante, at 48, see also N. 19, Supra. There is always some academic debate about such developments. The motives of legislatures are never entirely clear or unitary. Yet the basic shape and trajectory of 20th century campaign finance reform are clear, and one need not take a naive or triumphalist view of this history to find it highly relevant. The court's skepticism does nothing to mitigate the absurdity of its claim that Austin and McConnell were outliers. Nor does it alter the fact that 5 justices today destroy a long-standing American practice. Citizens United v. Federal Elections COMMN opinion of Stevens, J. Rightly to criticize the expenditure restriction as applied to unions, even though the court declined to pass on its constitutionality. Ante, at 27 to 28. Two features of these cases are of far greater relevance. First, those justices were writing separately, which is to say, their position failed to command a majority. Prior to today, this was a fact we found significant in evaluating precedents. Security on, each case in this line expressed support...
Oh wow, I cannot charge. It's because it's charging my other thing. This is so annoying.
Collected voluntarily from the organization stockholders or members, receives greater protection than speech financed with general treasury funds. 60.
Well, I might as well
60C pipefitters
do something with this time, try to get some upgrades done.
385, 409, 414 to 415, 1972. Reading the
Engine efficiency module. I already have that. I've had that for a while, haven't I?
Donations of employees when maintained in a separate account because he dominant legislative concern in requiring that contributions
Engine efficiency module. Yep, I already have it.
Protect the dissenting stockholder or union member, automobile workers, 352 US, at 592, advising the district court to consider on remand whether the broadcast in question was...
Oh, I can't make a shield generator. Shame.
Or whether the funds could be fairly said to have obtained on a voluntary basis. United States v. CIO, 335 U.S. 106, 123, 1948, observing that funds voluntarily contributed by union members or corporate stockholders for election...
Wait. All of my... What happened? All of my stuff disappeared. No way.
Congress's
What?
goal of reducing the effect of aggregated wealth on federal.
Wait, what kind of glitch did I just
Elections
encounter?
understood as wealth drawn from a corporate or union general treasury without the
Did getting
stockholders
hit by
or
those things so
free and
hard,
willing choice.
it got rid of all of my
407
storage.
US at 416. See automobile
What?
352 US at 5.
I got hit so hard that all of my storage disappeared?
Would not have read the statutory provision in question, a successor to Section 304 of the Tax Equity Act, to allow such robust use of
There's
corporate
no
and union
way.
funds to finance otherwise prohibited electioneering.
Okay.
This opening of the door to extensive corporate and union influence on the elected and legislative processes, Justice
Wow.
must be viewed
Wow,
with
I got
genuine
hit so
concern.
hard that I lost all of my
This seems
storage
to be a
forever. I
progressive
wonder if
step
I
as
can just
contrasted
quit.
with the numerous legislative
Okay,
and
I'm fine with
judicial
losing 32 minutes of
designed to
gameplay. I'm
ensure
totally fine with that.
elections are indeed free and representative.
Wow.
407
Wow.
US.
I wonder if I can recover this. If not, I'm just going to play a different game, but holy crap.
Opinion of Stevens, J. This principle
Oh, my
was
stuff's
carried
back.
forward.
Holy crap.
Congress enacted comprehensive campaign
You know, I probably could have just saved and reloaded, but I would have been way too afraid to risk that. Oh my god.
Which retained the restriction on using general treasury
Holy
funds for
cow.
contributions and expenditures.
That was ridiculous.
USC Section 441B A.
I still have everything I should. Is the Cyclops docked? It's not. Okay, so that's what I was doing last.
To finance contributions and expenditures forbidden to the corporation or union itself. Section 441B B. By the time Congress passed FECA in 1971, the bar on corporate contributions and expenditures had become such an accepted part of federal campaign finance regulation that when a large number of plaintiffs, including several nonprofit corporations, challenged virtually every aspect of the act in Buckley, for 24 U.S. 1, no one even bothered to argue that the bar as such was unconstitutional. Buckley famously, or infamously,
Okay, interesting.
distinguished direct
By the time Congress passed the Federal Election Campaign Act of 1971, the bar on corporate contributions and expenditures had become such an accepted part of federal campaign finance regulation that when a large number of plaintiffs, including several nonprofit orgs, challenged virtually every aspect of the act in Buckley, no one even bothered to argue that the bar as such was unconstitutional. Buckley famously, or infamously, distinguished direct contributions from independent expenditures, but its silence on corporations only reinforced the understanding that corporate expenditures could be treated differently from individual expenditures. Wow.
direct contributions from independent expenditures, ID, at 58 to 59, but its silence on corporations only reinforced the understanding that corporate expenditures could be treated differently from individual expenditures. Since our decision in Buckley, Congress's power to prohibit corporations and unions from using funds in their treasuries to finance advertisements expressly advocating the election or defeat of candidates in federal elections has been firmly embedded in our law. McConnell, 540 U.S., at 203. Thus, it was unremarkable, in a 1982 case holding that Congress could bar non-profit corporations from soliciting non-members for PAC funds, that then Justice Rehnquist wrote for a unanimous court that Congress's careful legislative adjustment of the federal electoral laws, in a cautious advance, step by step, to account for the particular legal and economic attributes of corporations, warrants considerable deference, and reflects a permissible as of Powell, J., joined by Berger, C.J. Citizens United v. Federal Elections COMMN opinion of Stevens, J. Assessment of the dangers posed by those entities to the electoral process. NRWC, 459 U.S., at 209, internal quotation marks and citation.
Oh my god, I ran out of power.
The governmental
Oh
interest
my
in
god.
preventing both actual corruption and the appearance of corruption of elected representatives has long been recognized, the unanimous court observed.
Holy
and there is
crap.
no reason why
This
it may
has
not
been
be
terrible.
accomplished by treating corporations differently from individuals. ID at 210 to 211. The corporate/individual distinction was not questioned by the court's disposition, in 1986, of a challenge to the expenditure restriction as applied to a distinctive type of nonprofit corporation. In MCFL, for 79 U.S. 238, we stated again that the special characteristics of the corporate structure require particularly careful regulation, ID, at 256, quoting NRWC, 459 U.S., at 209 to 210, and again we acknowledge that the government has a legitimate interest in regulate, the substantial aggregations of wealth amassed by the special advantages which go with the corporate form, 479 US, at 257, internal quotation marks omitted. Those aggregations can distort the free trade in ideas crucial to candidate elections, IBID, at the expense of members or shareholders who may disagree with the object of the expenditures, ID, at 260, internal quotation marks omitted. What the court held by a 5-4 vote was that a limited
Stop
class of
attacking me, I
corporations must be
swear.
allowed to use their general treasury funds for independent expenditures, because Congress's interests in protect ING shareholders and restrict ING the influence of political war chests funneled through the corporate form, ID, at 257, quoting FEC v. National Conservative Political Action Com, 470 U.S. 480, 501, 1985, PAC, did not apply to corporations that were structurally insulated from those concerns. 61. 61 specifically, these corporations had to meet 3 conditions. First,
Fire detected crap, dude. I just cannot catch a break.
For present purposes that the 4 MCFL dissenters, led by Chief Justice Rehnquist, thought the court was carrying the First Amendment too far. They would have recognized congressional authority to bar general treasury electioneering expenditures even by this class of nonprofits. They acknowledged that the threat from corporate political activity will vary depending on the particular characteristics of a given corporation, but believed these distinctions among corporations were distinctions in degree, not in kind, and thus more properly drawn by the legislature than by the judiciary. For 79 U.S., at 268, opinion of Rehnquist, C.J. Internal quotation marks omitted.
Oh my god, it's coming at me again.
Regulation of corporate political speech could be no more stringent than of speech by an individual. For years later, in Austin, 494 U.S. 652, we considered whether corporations falling outside the MCFL exception could be barred from using general treasury funds to make independent expenditures in support of, or in opposition to, candidates. We held they could be. Once again recognizing the importance of the integrity of the marketplace of political ideas in candidate elections, MCFL, for 79 U.S., at 257, we noted that corporations have special advantages such as limited liability, perpetual life, and favorable treatment of the accumulation and distribution of assets, 494 U.S. at 658 to 659, that allow them to spend prodigious general treasury sums on campaign messages. They had to be formed for the express purpose of promoting political ideas, so that their resources reflected political support rather than commercial success. MCFL, 479 U.S., at 264. Next, they had to have no shareholders, so that persons connected with the organization will have no economic disincentive for disassociating with it if they disagree with its political activity. IBID. Finally, they could not be established by a business corporation or a labor union, nor accept contributions from such entities, lest they'd serve, as conduits for the type of direct spending that creates a threat to the political marketplace. IBID. Citizens United v. Federal Elections COMMN. Opinion of Stevens, J. that have little or no correlation with the beliefs held by actual persons, ID, at 660. In light of the corrupting effects such spending might have on the political process, IBID, we permitted the state of Michigan to limit corporate expenditures on candidate elections to corporations PACs, which rely on voluntary contributions and thus reflect actual public support for the political ideals posed by corporations. IBID notwithstanding our colleagues.
That's how PACs works. PACs require you to voluntarily take your work money and put them in? I didn't know that.
Addressed only candidate-focused expenditures and gave the state no license to regulate corporate spending on other matters. In the 20 years since Austin, we have reaffirmed its holding and rationale a number of times. See, e.g., Beaumont, 539 U.S., at 153 to 156, most importantly in McConnell, 540 U.S. 93, where we upheld the provision linked here. Section 203 of BCR 8.62 Congress crafted Section 203 in response to a problem created by Buckley. The Buckley 62. According to the Chief Justice, we are erroneous in claiming that McConnell and Beaumont reaffirmed Austin ante at 5. In both cases, the court explicitly relied on Austin and quoted from it at length. C540 US at 204 to 205, 539 US at 153 to 155, 158, 160, 163. See also ante at 15. The holding and validity of Austin
Jesus.
were essential to the reasoning of the McConnell majority opinion. Brief for Appel Lance National Rifle Association et al. OOT 2003, number 0201675, page 21. Beaumont
I head
reaffirmed
up
the
there and get
Austin
some
rationale
items.
for restricting expenditures. The McConnell court did so in the teeth of vigorous protests by justices in today's majority that Austin should be overruled. See ante at 15, citing relevant passages.
Weird. Well, let me scan this one.
Beaumont, 539 US.
Oh, it's
at
unpowered? No?
164, Kennedy, J. Concurring in judgment. Both courts also heard criticisms of Austin from parties or amici. See brief for Appellant's Chamber of Commerce of the United States et al. OOT 2003, number 02. 1756.
Diamond will be
35
relevant.
and 22. Reply brief for Appellant/Cross Appellee Senator.
There you go. Now I can scan it. I thought so.
OOT 2003, number 02-1674, pages 13 to 14. Brief for Pacific Legal Foundation is amicus curiae in FEC v. Beaumont, OOT 2002, number 020403, Passam. If this does not qualify as reaffirmation of a precedent, then I do not know what would. Opinion of Stevens, J. Court had construed FECA's definition of prohibited expenditures narrowly to avoid any problems of constitutional vagueness, holding it applicable only to communications that expressly advocate the election or defeat of a clearly identified candidate. For 24 UFS, at 80, statements containing so-called magic words like vote for, elect, support, cast your ballot for, Smith for Congress, vote against, defeat, or reject, ID, at 43 to 44, and N. 52. After Buckley, corporations and unions figured out how to circumvent the limits on express advocacy by using sham issue ads that eschewed the use of magic words but nonetheless advocate, D, the election or defeat of clearly identified federal candidates. McConnell, 540. U.S. at 126. Corporations and unions spend hundreds of millions of dollars of their general funds to pay for these ads. ID, at 127. Congress passed Section 203 to address this circumvention, prohibiting corporations and unions from using general treasury funds for electioneering communications that are to a clearly identified candidate, whether or not those communications use the magic words. 2 U.S.C. Section 434, F, 3, A, I. When we asked in McConnell whether a compelling governmental interest justify, D, Section 203, we found the question easily answered. We have repeatedly sustained legislation aimed at the corrosive and distorting effects of immense aggregations of wealth that are accumulated with the help of the corporate form and that have little or no correlation to the public's support for the corporation's political ideas. 540 U.S. at 205, quoting Austin, 494.
Alright, well, while it charges, I'll enjoy the ambiance and pay attention.
These precedents represent respect for the legislative judgment that the special characteristics of the corporate structure require particularly careful regulation. 540 U.S. at 205, internal quotation marks omit TED. Moreover, recent cases have recognized that certain restrictions on corporate electoral involvement permissibly hedge against circumvention of contribution. 50 Citizens United v. Federal Elections COMMN. Opinion of Stevens, J. Limits. Ibid, quoting Beaumont, 539 U.S. at 155, in turn quoting FEC v. Colorado Republican Federal Campaign Com, 533 U.S. 431, 456, and N18, 2000.
Good God.
Colorado 2.
They need to figure out something better for doing long, complicated names of stuff like that. Like, they need a new method.
Prevent ing corruption, sustaining the active, alert responsible ITY of the individual citizen in a democracy for the wise conduct of the government, and maintaining the individual citizen's confidence in government. 540 U.S. at 206 to 207, N88. Quoting below the 435 U.S. at 788 to 789, some internal quotation marks and brackets. What made the answer even easier than it might have been otherwise was the option to form PACs, which give corporations, at the least, a constitutionally sufficient opportunity to engage in independent expenditures. 540. 3. Buckley and Bellotti against this extensive background of congressional regulation of corporate campaign spending, and our repeat affirmation of this regulation is constitutionally sound, the majority dismisses Austin as a significant departure from ancient First Amendment principles, ante, at 1, internal quotation marks omitted. How does the majority attempt to justify this claim? Selected passages from two cases, Buckley, 424 U.S. 1, and Bellotti, 435 U.S. 765, do all of the work. In the court's view, Buckley and Bellotti decisively rejected the possibility of distinguishing corporations from natural persons in the 1970s. It just so happens that in every single case in which the court has reviewed campaign finance legislation in the decades since, the majority failed to grasp this truth. The federal Congress and dozens of state legislation. He concept that government may restrict the speech of some element.
The federal Congress and dozens of state legislatures we now know has been similarly diluted. The majority emphasis on Buckley's statement that the concept that government may restrict the speech of some elements of our society in order to enhance relative voices of others is wholly foreign to the United States. But this elegant phrase cannot bear the weight that our colleagues have placed on it. For one thing, the Constitution does in fact permit numerous restrictions on the speech of some in order to prevent a few from drowning out the many. For example, restrictions on ballot access and on legislators' floor time, Nixon versus Shrink, Missouri Government Act. For another, the Buckley court used this line in evaluating the ancillary... Oh, wow! I just figured out one of the most important things that we need to talk about that's connected to this. I can already tell, this is the paradox of tolerance. The people against allowing every single corporation to speak are saying, hello, if you let every single person speak in absolute certainty, there will come a corporation that is very loud but only represents very few people. So it's not exactly the paradox of tolerance, it's more like the problem of democracy itself, the mob rule issue. But that might come into this. I might use that as part of the video. It's not apparent why this is relevant to the case before us. The majority suggests that Austin rests on the foreign concept of speech equalization. The restriction of the way corporations spend their money is no mere exercise in disfavoring the voice of some element of our society in preference to others. Indeed, we expressly ruled that the compelling interest supporting Michigan's statute was not one of equalizing the relative influence of speakers on elections, but rather the need to confront the distinctive, corrupting potential of corporate electoral advocacy, financed by general treasury dollars. Oh, this page is huge. What number page is this? Officially, this is page 138. Oh, this is a hugely important page for when I make the video.
Nixon versus Shrink, Missouri Government PAC, 528 U.S. 377, 402, 2000, Breyer, J., concurring. For another, the Buckley court used this line in evaluating the ancillary governmental interest in equalizing the relative ability of individuals and groups to influence the outcome of elections. For 24 U.S. at 48. It is not apparent why this is relevant to the case before us. The majority suggests that Austin rests on the foreign concept of speech equalization, ante, at 34, ante, at 8 to 10, opinion of Roberts, C.J., but we made it clear in Austin, as in several cases before and since, that a restriction on the way corporations spend their money is no mere exercise in disfavoring the voice of some elements of our society in preference to others. Indeed, we expressly ruled that the compelling interest supporting Michigan's statute was not one of equalize, ing, the relative influence of speakers on elections, Austin, 494 U.S., at 660, quoting ID, at 705, Kennedy, J. Dis. Centang, but rather the need to confront the distinctive corrupting potential of corporate electoral advocacy financed by general treasury dollars, ID, at 659 to 660. For that matter, it should go without saying that when we made this statement in Buckley, we could not have been casting doubt on the restriction on corporate expenditures in candidate elections, which had not been challenged as foreign to the First Amendment, ante, at 33, quoting Buckley, 424 U.S., at 49, or for any other reason. Citizens United v. Federal Elections COMMN opinion of Stevens, J. Buckley's independent expenditure analysis was focused on a very different statutory provision, 18 U.S.C. Section 608 E. 1, 1970 edition, Sup. V. It is implausible to think, as the majority suggests, at 29-30, that Buckley covertly invalidated FEC's separate corporate and union campaign expenditure restriction, Section 610, now codified at 2. The case on which the majority places even greater weight than Buckley, however, is Bellotti, 435 U.S. 765, claiming it could not have been clearer that Bellotti's holding forbade distinctions between corporate and individual expenditures like the one at issue here, at 30. The court's reliance is odd. The only thing about Bellotti that could not be clearer is that it declined to adopt the majority's position. Bellotti ruled, in an explicit limitation on the scope of its holding, that our consideration of a corporation's right to speak on issues of general public interest implies no comparable right in the quite different context of participation in a political campaign for election to public office. For 35 U.S. at 788 N26, see also ID at 787 to 788, acknowledging that the interests in preserving public confidence in government and protecting dissenting shareholders may be weighty in the context of Part 1. SAN candidate elections. Bellotti, in other words, did not touch the question presented in Austin and McConnell, and the opinion squarely disavowed the proposition for which the majority cites it. The majority attempts to explain away the distinction Bellotti drew between general corporate speech and campaign speech intended to promote or prevent the election of specific candidates for office as inconsistent with the rest of the opinion and with Buckley. At 31, 42 to 44. Yet the basis for this distinction is perfectly coherent, the anti-corruption interests that animate regulations of corporate participation in candidate elections, the importance of which has never been doubted, 435 U.S. at 788 N26, do not apply equally to regulations of corporate participation in referenda. A referendum cannot owe a political debt to a corporation, seek to curry favor with a corporation, or fear the corporation's retaliation. Cf. Austin, 494 U.S. at 678, Stevens, J. Concurring, Citizens Against Rent Control/Coalition for Fair Housing vs. Berkeley, 454 U.S. 290, 299, 1981. The majority likewise overlooks the fact that, over the past 30 years, our cases have repeatedly recognized the candidate/issue distinct tie-in. See, e.g., Austin, 494 U.S. at 659, and PAC, 470. U.S. at 495 to 496, FCC v. League of Women Voters of Cal, 468 U.S. 364, 371, N9, 1984, NRWC, 459 U.S. at 210. N.7. The court's critique of Bellotti's footnote 26 puts it in the strange position of trying to elevate Bellotti to canonical status, while simultaneously
Hey, fully
charging a
charged.
critical
That took
piece
a
of its
while.
analysis as unsupported
Alright,
and
I'm going
irreconcilable
to
with
run
Buckley.
to the bathroom real quick,
Bellotti,
and then I will be right
apparently,
back.
is both the font of all wisdom and internally incoherent.
So, I'm
The
gonna
Bellotti court confronted
unplug
a dramatically
this.
different factual situation from
Gotta
the one
unplug
that
like
confronts
5
us in
things
this
just
case,
to
a state statute that
just to
barred
pause for a
business
second. It's
expenditures on
complicated.
some referenda, but
I'm gonna
not
keep
others.
listening though.
Specify Cali, the statute barred a business corporation from making contributions or expenditures for the purpose of influencing or affecting the vote on any question submitted to the voters, other than one materially affecting any of the property, business, or assets of the corporation, for 35 U.S. at 768, quoting Massachusetts General Laws and CH 55, Section 8, West Sup 1977, alteration in original, and it went so far as to provide that referenda related to income tax tie-in would not be deemed materially to affect the property, business or assets of the corporation, 435 U.S. at 768.as might be guessed, the legislature had enacted this statute in order to limit corporate speech on a proposed Citizens United v. Federal Elections COMMN opinion of Stevens, J. State constitutional amendment to authorize a graduated income tax. The statute was a transparent attempt to prevent corporations from spending money to defeat this amendment, which was favored by a majority of legislators but had
Alright, that was quick. I've already returned. Why are they talking about state income tax suddenly? What's going on?
769 to
What?
770 and N3.
How did we get to state income tax suddenly?
As here, the legislature's suppression of speech suggests an attempt to give one side of a debatable public question an advantage in expressing its views to the
Well, you know,
people.
one thing that's
First
been nice
Amendment
is seeing
defended.
that it's
ID
possible
at
that people in the Supreme Court have
788
common
to
sense.
786, footnote
And
amendment.
obviously by that, I'm just saying that they have a worldview that I understand and agree with. Common sense is
Created to
all
affect
down
a
to worldview.
particular policy outcome.
But yeah, I wanted
Even
to
Justice
check something real
Rehnquist,
quick.
in dissent, had to acknowledge that a very persuasive argument could be made that the Massachusetts legislature, desiring to impose a personal income
How did it
tax
just
for
say
more than one
Massachusetts wrong?
committed in that
And like,
desire
why
by a
that wrong?
combination of the Commonwealth's referendum provision and corporate expenditures in opposition to such a tax, simply decided to muzzle corporations on this sort of issue so that it could succeed in its desire. ID at 827 and 6. To make matters worse, the law at issue did not make any allowance for corporations to spend money through PACs. ID
Wow.
768
I just
and
checked
opinion
the
of court. This really
electric
was a
battery
ban on a
system
specific,
inside of the
unidentified subject.
box truck tiny home in which I am currently streaming from. I've had the air conditioning running the entire day, and the battery is still at 100%. This is so cool. How many people can say like, oh, I stream off of solar power? That's what I'm doing right now. That's so cool.
The majority grasps a
Alright, let's get the
quotation
heck outta
from
here.
Bellotti, that speech does not fall entirely outside the protection of the First Amendment merely because it comes from a corporation. Ante, at 30 to 31. Of course not, but no one suggests the contrary, and neither Austin nor McConnell held otherwise. They held that even though the expenditures at issue were subject to First Amendment scrutiny,
Expenditures.
the restrictions on those expenditures were justified by a compelling state interest. See McConnell, 540 U.S. at 205, Austin, 494 U.S. at 658, 660. We acknowledged in Bellotti that numerous interests of the highest importance can justify campaign finance regulation. 435 U.S. at 788 to 789. But we found no evidence that these interests were served by the Massachusetts law. ID at 789. We left open
Nice. Alright, this is the best entrance in the game for sure. I'm gonna drop my I'm gonna drop this here so it acts like a beacon for me to get back. Have fun.
Austin and McConnell, then,
Oh, that might drop more than I expected it to.
Indeed, all 6 members of the Austin majority had been on the
Well,
court
yeah, that's good
with
enough. That's
Bellotti,
fine.
and none so much as hinted in Austin that they sought any tension between
Okay.
the decisions.
So now I need to go back to that one island and scan the thing I forgot to scan completely and totally.
Protection for corporations, whereas Bellotti accepted it. The difference is that the statute at issue in Bellotti
It's a little dark in here.
discrimination, targeted one class of corporations, and provided no PAC option, and the state has a greater interest in regulating independent
Seek fluid
corporate
intake.
expenditures
Okay,
on
one
candidate
second.
elections than on referenda, because in a functioning democracy the public must have faith that its representatives owe their positions to the people, not to the corporations with the deepest pockets. In sum, over the course of the past century, Congress has demonstrated a recurrent need to regulate corporate participation in candidate elections to p. reserve e. the integrity of the electoral process, prevent t. corruption, sustai n. the active, alert responsibility of the individual citizen, protect the expressive interests of shareholders, and p. reserve e. the individual citizen's confidence in. Citizens United v. Federal Elections COMMN Opinion of Stevens, J. Government. McConnell, 540 U.S. at 206 to 207, and 88, quoting Bellotti, 435 U.S. at 788 to 789.
Oh my god, please stop citing stuff. I love that this is great and consistent, but my brain is going to rot.
In 1907, see Automobile Workers, 352 U.S. at 570 to 575. The Taft-Hartley Act in 1947, see WRTL,
Let's get out of here.
US at 511. Souter, J. Dissenting, FECA in 1971, See NRWC 459 US at 209 to 210, and BCRA in 2002. See McConnell 540 US at 126 to 132. Continuously for over 100 years, this line of campaign finance reform has been a series of reactions to document threats to electoral integrity obvious to any voter, posed by large sums of money from corporate or union treasuries. WRTL 551 US at 522, Suitor, J, Dissent ING. Time and again,
Right, did I
we
guess
have
my
recognized
location?
these realities in approving measures that Congress and the states have taken.
Yeah,
None
I'm
of the
close enough.
cases the
Should be fine.
majority cites is to the contrary. The only thing new about Austin was the dissent.
I didn't even know the entrance to this was here. I'm gonna have to memorize this for the next time I play the game.
Interests recognized in the name of democratic integrity since the days of the progressives. For having explained why this is not an appropriate case in which to revisit Austin and McConnell and why these decisions sit perfectly well with First Amendment principles, ante, at 1:48, I come at last to the interests that are at stake.
Yeah, okay,
The
my
majority
front seat's acting like a
recognizes that
beacon, that's
Austin
good.
and McConnell may be defended on anti-corruption, anti-distortion, and shareholder protection rationales. Ante, at 32. Opinion of Stevens, J. Tal interest in preventing corruption or the appearance of corruption is one that is limited to quid pro quo corrupt tie-in. Ante, at 43. This is the same crabbed view of corruption that was espoused by Justice Kennedy and McConnell and squarely rejected by the court in that case. 540 U.S. at 152. While it is true that we have not always spoken about corruption in a clear or consistent voice, the approach taken by the majority cannot be right, in my judgment. It disregards our constitutional history and the fundamental demands of a democratic society. On numerous occasions we have recognized Congress's legitimate interest in preventing the money that is spent on elections from
I have been
exerting
hit.
undue influence on an officeholder's judgment and from creating the appearance of such influence
Stop being
beyond the
so
sphere
angry.
of quid pro quo relationships.
Go get a life,
150, see
Reaper.
also, e.g., at 143
Yeah,
to
go get a hobby, bro. Go
144,
somewhere else.
152 to 154, Colorado 2, 533 U.S. at 441, Shrink, Missouri, 528
Bro,
U.S. at 389.
get a life. Stop attacking
Corruption
me.
can take many forms. Bribery may be the paradigm case. But the difference between selling a vote and selling
External hold
access
damage,
is
you
a
don't
matter of
say.
degree, not kind. And selling access is not qualitatively different from giving special preference to those who spent money on one's behalf. Corruption operates along a spectrum, and the majority's apparent belief that quid pro quo arrangements can be neatly demarcated from other improper influences does not accord with the
Oh
theory
my
or
god, do not
reality
tell
of
me it just
politics.
became nighttime suddenly.
It certainly does not accord with the record con. Gress developed in passing BCRA, a record that stands as a remarkable testament to the energy and ingenuity with which corporations, unions, lobbyists, and politicians may go about scratching each other's backs, and which amply supported Congress's determination to target a limited set of especially destructive practices. The district court that adjudicated the initial challenge to BCRA pored over this record. In a careful analysis, Judge Collar-Catelli made numerous findings about the Citizens United v. Federal Elections COMMN opinion of Stevens, J. Corrupting consequences of corporate and union independent expenditures in the years.
It's crazy to think that Subnautica 1 is like many years old by now. It's probably like, can't be 10 years old, right? It wasn't 2014, it was probably like 2016 or 17.
See also ID at 804 to 805, 813, and 143.
Oh my god, stop citing numbers please, I'm dying.
Indicating agreement. As summarized in her own words. The factual findings of the court illustrate that corporations and labor unions routinely notify MEM bears of Congress as soon as they air electioneering communications relevant to the members' elections.
Wow, are they saying the common sense thing that everyone knew?
To organizations for the airing of these election-related advertisements. Indeed.
Oh, I definitely need to cite this in the video too. Okay, what page is this? This is 145. Okay.
And expenditures in the years.
The factual findings of the court illustrate that corporations and labor unions routinely notify members of Congress as soon as they air electioneering communications relevant to the members' elections. Yes. Who knew? I can't believe this. I can't believe this. This is impossible. Duh. What else? Tell me something I didn't already know. Right, do I now know how to make a purple fragment thingy? Yes, ion cube, diamond. Oh, you're over there? Well, you certainly seem angry. Right, I'll go back to plan.
Years preceding BCRA's passage. See McConnell, 251F SUPA 2D, at 555 to 560, 622 to 625, see also ID, at 804 to 805, 813, and 143, Leon J. Indicating agreement. As summarized in her own words.
And that thing is angry over there.
Passage. See McConnell.
He's flying in all the water.
SUPA 2D at 555 to 560, 622 to 625. See also ID.
You are angry. Why are there two of you?
813 and 143. Leon J. Indicating agreement.
Well, I wanted to go get the grappling arm for this, but I guess not.
The factual findings of the court illustrate
Whatever.
that corporations and labor unions routinely notify MEM bears of Congress as soon as they air electioneering communications relevant to the members' elections. The record also indicates that members express appreciation to organizations for the airing of these election-related advertisements. Indeed, members of Congress are particularly grateful when negative as sue advertisements are run by these organizations, leaving the candidates free to run positive advertisements and be seen as above the fray. Political consultants testify that campaigns are quite aware of who is running advertisements on the candidate's behalf, when they are being run, and where they are being run. Likewise, a prominent lobbyist testifies that these organizations use issue advocacy as a means to influence various members of Congress. The findings also demonstrate that members of Congress seek to have corporations and unions run these advertisements on their behalf. The findings show that members suggest that corporations or individuals make donations to interest groups with the understanding that the money contributed to these groups will assist the member in the
Obviously,
campaign.
one of the side effects of this being a Supreme Court case is that they can't, like, in the middle of discussing one thing, they can't randomly bring up something else, but, like, I just wish someone was like, yeah, we should probably ban political action committees too. That also sounds illegal. They're just unethical or deleterious and antithetical to the entire concept of American democracy. Of any democracy? Like, why is this even a thing? Why is that even allowed?
Seem to have a quid pro quo basis, but other arrangements were more subtle. Her analysis shows the great difficulty in delimiting the precise scope of the quid pro quo category, as well as the adverse consequences that all such arrangements may have. There are threats of corruption that are far more destructive to a democratic society than the odd bribe. Yet the majority's understanding of corruption would leave lawmakers impotent to address all but the most discreet abuses.
Actually, I would say that that is specifically one of the most problematic things for democracy is a bribe. What are you guys smoking?
To some minimal extent, that office holders will decide issues on the merits or the desires of their constituencies, and not according to the wishes of those who have made large financial contributions or expenditures valued by the office holder. McConnell, 540 U.S., at 153.63 when private interests are seen to exert outsized control over office holders solely on account of the money spent on, or withheld from, their campaigns, the result can depart so thoroughly from what is pure or. 63 CF Nixon vs. Shrink Missouri Government PAC, 528 U.S. 377, 389, 2000, recognizing the broader threat from politicians too compliant with the wishes of large contributors. Though discrete in scope, these experiments must impose some meaningful limits if they are to have a chance at functioning effectively and preserving the public's trust. Even if it occurs only occasionally, the potential for such undue influence is manifest. And unlike straight cash for votes transactions, such corruption is neither easily detected nor practical to criminalize. McConnell,
And yet Elon still
540
hasn't been criminalized for essentially compensating people in
153.
Wisconsin to vote.
There
A
should be
literal
nothing
cash for vote.
controversial about the proposition that the influence being targeted is undue. In a democracy, officeholders should not make public decisions with the aim of placating a financial benefactor, except to the extent that the benefactor is seen as representative of a larger constituency or its arguments are seen as especially persuasive. Citizens United v. Federal Elections COMMN. Opinion of Stevens, J. Correct in the conduct of government, Webster's Third New International Dictionary 512, 1966, defining corruption, that it amounts to a subversion of the electoral process, automobile workers, 352 U.S., at 575. At stake in the legislative efforts to address this threat is therefore not only the legitimacy and quality of government but also the public's faith therein, not only the capacity of this democracy to represent its constituents, but also the confidence of its citizens in their capacity to govern themselves. WRTL, 551 U.S., at 507, Souter, J., dissenting. Take away Congress's authority to regulate the appearance of undue influence and the cynical assumption that large donors called a tune could jeopardize the willingness of voters to take part in democratic governance. McConnell, 540 U.S., at 144, quoting Shrink, Missouri, 528 U.S., at 390.64. The cluster of interrelated interests threatened by such undue influence and its appearance has been well captured under the rubric of democratic integrity. WRTL, 551 U.S., at 522, Souter, J. dissenting. This value has underlined a century of state and federal efforts to regulate the role of corporations in the electoral process. 65. 60 for the majority declares by fiat that the appearance of undue influence by high-spending corporations will not cause the electorate to lose faith in our democracy. Anti, at 44. The electorate itself has consistently indicated otherwise, both in opinion polls, see McConnell v. FEC, 251F, Sup. 2D 176, 557 to 550.
Again, they need like
623
to use links or something
624, DC
for their system of organizing documents.
J, and in the laws its representatives have
This is
passed,
crazy.
and our colleagues have no basis for elevating their own optimism into a tenet of constitutional law. 65 quite distinct from the interest in preventing improper influences on the electoral process.
I wonder if reading all of these is going to increase my vocabulary somehow and make it better. I've learned a couple of weird words, but
the imposition of reasonable limitations on the expenditures
some of these I'm
during
not
the
getting
course
too
of
much
any
from.
single campaign. Davis v. FEC, 554 U.S. ____________ 2008.
Nickel or ruby plasteel Cool.
Opinion concurring in part and dissenting in part. In my judgment, such limitations may be justified to the extent they are tailored to improving the quality of the exposition of ideas that voters. Opinion of Stevens, J. Unlike the majority's myopic focus on quid pro quo scenarios in the free-floating
They use the word myopic.
on which it rests so much weight, anti, at 148, this broader understanding of corruption has deep roots in the nation's history. During debates on the earliest campaign finance reform acts, the terms corruption and undue influence were used nearly interchangeably. Pasquale, Reclaiming Egalitarianism and the Political Theory of Campaign Finance Reform, 2008 ULL.
Someone said egalitarianism. Crazy.
Long before Buckley, we appreciated
My old favorite word.
say that Congress is without power to pass appropriate legislation to safeguard an election from the improper use of money to influence the result is to deny to the Natayan in a vital particular the power of self-protection. Burroughs versus United States, 290 U.S. 534, 545, 1934. And whereas we have no evidence to support the notion that the framers would have wanted corporations to have the same rights as natural persons in the electoral
Let me check this.
text, we have ample evidence to suggest that they would have been appalled by the evidence of
Where?
corruption that Congress unearthed in developing BCRA and that the court today discounts to irrelevance. It is fair to say that he framers were obsessed with corruption, teach out 348, which they understood to encompass the dependency of public officeholders on private interests, CID, at 373-374, see also Randall, 548 U.S., at 280, Stevens, J., dissenting. They discussed corruption more often in the Constitutional Convention than factions, violence, or instability. Teach out 352. When they brought our consti. Receive, IBID, free, ing, candidates and their staffs from the interminably burden of fundraising, IBID, internal quotation marks omitted, and protect, ing, equal access to the political arena, Randall vs. Sorrell, 548 U.S. 230, 278, 2006, Stevens, J., dissenting, internal quotation marks omitted. I continue to adhere to these beliefs, but they have not been briefed by the parties or amici in this case, and their soundness is immaterial to its proper disposition. Citizens United v. Federal Elections COMMN. Opinion of Stevens, J. Constitutional order into being, the framers had their minds trained on a threat to Republican self-government that this court has lost.
Ow.
There is no need to take my side in the debate over the scope of the anti-corruption interest to see that the court's merits holding is wrong. Even under the majority's crabbed view of corruption, McConnell, 540 U.S., at 152, the government should not lose this case. The importance of the governmental interest in preventing corruption through the creation of political debts has never been doubted. Bellotti, 435 U.S., at 788 and 26. Even in the cases that have construed the anti-corruption interest most narrowly, we have never suggested that such quid pro quo debts must take the form of outright vote buying or bribes, which have long been distinct crimes. Rather, they encompass the myriad ways in which outside parties may induce an officeholder to confer a legislative benefit in direct response to, or anticipation of, some outlay of money the parties have made or will make on behalf of the officeholder. See McConnell, 540 U.S., at 143, we have not limited the anti-corruption interest to the elimination of cash for votes exchanges. In Buckley, we expressly rejected the argument that anti-bribery laws provided a less restrictive alternative to FEC's contribution limits, noting that such laws deal, with only the most blatant and specific attempts of those with money to influence governmental action, quoting 424 U.S., at 28, alteration in original. It has likewise never been doubted that, almost equal concern as the danger of actual quid pro quo arrangements is the impact of the appearance of corruption. ID, at 27. Congress may legitimately conclude that the avoidance of the appearance of improper influence is also critical if confidence in the system of representative government is not to be eroded. Opinion of Stevens, J. To a disastrous extent. IBID, internal quotation marks omitted, alteration in original. A democracy cannot function effectively when its constituent members believe laws are being bought and sold. In theory, our colleagues accept this much. As
I can go
applied
back
to
to the
VCRA
mountains.
Section
I'll be
203,
fine.
however, they conclude, he anti-corrupt tie-in interest is not sufficient to displace the speech here in question. Ante, at 41. Although the court suggests that Buckley compels its conclusion, ante, at 40 to 44, Buckley cannot sustain this reading. It is true that, in evaluating FEC's ceiling on independent expenditures by all persons, the Buckley court found the governmental interest in preventing corruption inadequate. For 24 U.S., at 45. But Buckley did not evaluate corporate expenditures specifically, nor did it rule out the possibility that a future court might find otherwise. The opinion reasoned that an expenditure limitation covering only express advocacy, i.e., magic words, would likely be ineffectual, IBID, a problem that Congress tackled in BCRA, and it concluded that the independent advocacy restricted by FECA Section 608(e)(1) does not presently appear to pose dangers of real or apparent corruption comparable to those identified with large campaign contributions, ID, at 46, emphasis added. Buckley expressly contemplated that an anti-corruption rationale might justify restrictions on independent expenditures at a later date, because it may be that, in some circumstances, large independent expenditures pose the same dangers of actual or apparent quid pro quo arrangements as do large contributions. WRTL, 551 U.S., at 478, opinion of Roberts, C.J. Quoting Buckley, 424 U.S., at 45. Certainly Buckley did not foreclose this possibility with respect to electioneering communications made with corporate general treasury funds, an issue the court had no occasion to consider. Citizens United v. Federal Election COMMN. Opinion of Stevens, J. Quo corruption, as it found the broader corruption implicated by the anti-distortion and shareholder protection rationales a sufficient basis for Michigan's restriction on corporate electioneering. 494 U.S. at 658 to 660. Concurring in that opinion, I took the position that the danger of either the fact or the appearance of quid pro quo relationships also provides an adequate justification for state regulation of these independent expenditures. ID at 678. I did not see this position as inconsistent with Buckley's analysis of individual expenditures. Corporations, as a class, tend to be more attuned to the complexities of the legislative process and more directly affected by tax and appropriations measures that receive little public scrutiny. They also have vastly more money with which to try to buy access and votes. See sup a brief for Appellee 17, stating that the Fortune 100 companies earned revenues of $13.1 trillion during the last
Fortune
election
100.
cycle.
I ain't heard someone say that in a long time. Fortune
Clients
100.
must engage the political process in instrumental terms if they are to maximize shareholder value. The unparalleled resources, professional lobbyists, and single-minded focus they bring to this effort, I believed, make quid pro quo corruption and its appearance inherently more likely when they, or their conduits or trade groups, spend unrestricted sums on elections. It is with regret rather than satisfaction that I can now say that time has borne out my concerns. The legislative and judicial proceedings relating to BCRA generated a substantial body of evidence suggesting that, as corporate tie-ins
Corporations grew more and more adept at crafting issue ads.
a particular candidate, these nominally independent expenditures began to corrupt the political process in a very direct sense. The sponsors of these ads were routinely granted
especially towards the end of his opinion. It makes a lot of sense.
Knew who their friends were. McConnell, 540 U.S. at 129. Many corporate independent expenditures, it seemed, had become Essen. Opinion of Stevens, J. Entirely interchangeable with direct contributions in their capacity to generate quid pro quo arrangements. In an age in which money and television ads are the coin of the campaign realm, it is hardly surprising that corporations deployed these ads to curry favor with, and to gain influence over, public officials. The majority appears to think it decisive that the BCRA record does not contain direct examples of votes being exchanged for expenditures. Ante, at 45, internal quotation marks omitted. It would have been quite remarkable if Congress had created a record detailing such behavior by its own members. Proving that a specific vote was exchanged for a specific expenditure has always been next to impossible. Elected officials have diverse motiva tie-ins, and no one will acknowledge that he sold a vote. Yet, even if ingratiation and access are not corrupt tie-ins themselves, they are necessary prerequisites to it. They can create both the opportunity for, and the appearance of, quid pro quo arrangements. The influx of unlimited corporate money into the electoral realm also creates new opportunities for the mirror image of quid pro quo deals, threats, both explicit and implicit. Starting today, corporations with large war chests to deploy on electioneering may find democratically elected bodies becoming much more attuned to their interests. The majority both misreads the facts and draws the wrong conclusions when it suggests that the BCRA record pro vides only scant evidence that independent expenditures ingratiate, and that, in any event, none of it matters. In her analysis of the record, Judge Collar-Catelli documented the pervasiveness of this ingratiation and explained its significance under the majority's own touchstone for defining the scope of the anti-corruption rationale, Buckley. See McConnell, 251F, Sup 2D, at 555 to 560, 622 to 625. Witnesses explained how political parties and Citizens United v. Federal Election COMMN. Opinion of Stevens, J. Candidates used corporate independent expenditures to circumvent FEC's hard money limitations. See, e.g., ID, at 478 to 479. One former senator candidly admitted to the district court that, candidates whose campaigns benefit from phony issue ads greatly appreciate the help of these groups. In fact, members will also be favorably disposed to those who finance these groups when they later seek access to discuss pending legislation. ID, at 556, quoting declaration of Senator Dale Bumpers. One prominent lobbyist went so far as to state, in uncontroverted testimony, that unregulated expenditures, whether soft money donations to the parties or issue ad campaigns, can sometimes generate far more influence than direct campaign contributions. Ibid, quoting declaration of Wright Andrews, emphasis added. In sum, Judge Collar-Catelli found, he record powerfully demonstrates that electioneering communications paid for with the general treasury funds of labor unions and corpora. Tie-ins endears those entities to elected officials in a way that could be perceived by the public as corrupting. ID, at 622 to 623. She concluded that the government's interest in preventing the appearance of corruption, as that concept was defined in Buckley, was itself sufficient to uphold BCRA Section 203. 251F, Sup. 2D, at 622 to 625. Judge Leon agreed. CID, at 804 to 805, dissenting only with respect to the Wellstone Amendment's coverage of MCFL corporations. When the McConnell Court affirmed the judgment of the District Court regarding Section 203, we did not rest our holding on a narrow notion of quid pro quo corruption. Instead, we relied on the governmental interest in combating the unique forms of corruption threatened by corporations, as recognized in Austin's anti-distortion and shareholder protection rationales, 540 U.S., at 205, citing Austin, 494 U.S., at 660, as well as the interest in preventing CIR Convention of Contribution Limits, 540 U.S., at 128 to 129, 205, 206, and 88. Had we felt constrained by the view of today's court that quid pro quo corruption and its appearance are the only interests that count in this field, ante, at 32 to 46, we of course would have looked closely at that issue. And as the analysis by Judge Collar-Catelli reflects, it is a very real possibility that we would have found one or both of those interests satisfied in Section 203 appropriately tailored to them. The majority's rejection of the Buckley anti-corruption rationale on the ground that independent corporate expenditures do not give rise to quid pro quo corruption or the appearance of corruption, ante, at 42, is thus unfair as well as unreasonable. Congress and outside experts have generated significant evidence corroborating this rationale, and the only reason we do not have any of the relevant materials before us is that the government had no reason to develop a record at trial for a facial challenge the plaintiff had abandoned. The court cannot both sua sponte choose to relitigate McConnell on appeal and then complain that the government has failed to substantiate its case. If our colleagues were really serious about the interest in preventing quid pro quo corruption, they would remand to the district court with instructions to commence evidentiary proceedings. Point 66. The insight that even technically independent expendi 66 inches fact, the notion that the electioneering communications covered by Section 203 can breed quid pro quo corruption or the appearance of such corruption has only become more plausible since we decided McConnell. Recall that the Chief Justice's controlling opinion in WRTL subsequently limited BCRA's definition of electioneering communications to those that are susceptible of no reasonable interpretation other than as an appeal to vote for or against a specific candidate. 551 U.S. at. For 70. The upshot was that after WRTL, a corporate or union expenditure could be regulated under Section 203 only if everyone would understand it as an endorsement of or attack on a particular candidate for office. It does not take much imagination to perceive why this type of advocacy might be especially apt to look like or amount to a deal or a threat. Citizens United v. Federal Elections COMMN. Opinion of Stevens, J. Tours can be corrupting in much the same way as direct contributions, as bolstered by our decision last year in Caperton vs. A.T. Massey Coal Company, 556 U.S. ____, 2009. In that case, Don Blankenship, the chief executive officer of a corporation with a lawsuit pending before the West Virginia High Court, spent large sums on behalf of a particular candidate, Brent Benjamin, running for a seat on that court. In addition to contributing the $1,000 statutory maximum to Benjamin's campaign committee, Blankenship donated almost $2.5 million to, and for the sake of the kids, a Section 527 corporation that ran ads targeting Benjamin's opponent. ID, at ____, slip up, at 2. This was not all. Blankenship spent, in addition, just over $500,000 on independent expenditures. To support. Brent Benjamin. ID at ____, slip up at 2 to 3, second alteration in original. Applying its common sense, this court accepted petitioner's argument that Blankenship's pivotal role in getting Justice Benjamin elected created a constitutionally intolerable probability of actual bias when Benjamin later declined to recuse himself from the appeal by Blankenship's corporation. ID at ____, slip up at 11. Though bribe or criminal influence was involved, we recognized that Justice Benjamin would nevertheless feel a debt of gratitude to Blankenship for his of 99.97% independent expenditures, $3 million, and 0.03% direct contributions, $1,000, as a contribution. See, e.g., ID at ____, slip up at 1. The basis for the recusal motion was that the justice had received campaign contributions in an extraordinary amount from Blankenship, ID at ____, slip up at 3, referencing Blankenship's $3 million in contributions, ID at ____, slip up. At 14, Blankenship contributed some $3 million to unseat the incumbent and replace him with Benjamin, ID, at ____, slip up. At 15, Blankenship's campaign contributions had a significant and disproportionate influence on the electoral outcome. The reason the court so thoroughly conflated expenditures and contributions, one assumes, is that it realized that some expenditures may be functionally equivalent to contributions in the way they influence the outcome of a race, the way they are interpreted by the candidates and the public, and the way they taint the decisions that the
Oops, that's funny.
thereafter.
I wonder where I left my stuff then.
Caperton is illuminating in several
Where did I go?
respects.
Okay.
It underscores the old insight that,
Oops.
on account of the extreme difficulty of proving corruption, prophylactic measures, reaching some, campaign spending, not corrupt in purpose or effect, may be, nonetheless required to guard against corruption. Buckley, 424 U.S. at 30, see also Shrink, Missouri, 528 U.S. at 392
That's funny.
and 5. It underscores that
I wonder if I can get to it with this little breath. I'm just excited to get done with reading this in the next hour or two, is what it looks like.
540. U.S. at 205, internal quotation marks and brackets omitted, see also Colorado 2, 533 U.S. at 400.
I'm such an idiot. That was hilarious.
Fellow members of the court agree that circumvention
I don't even remember what I was doing now too, but it's because I was trying to also read this too while typing. That's funny.
With electioneering communications will often prefer to use
Non-profit conduits with misleading names. Yes, okay, this entire last section, it's weird. As this document goes on, it gets better in terms of making good arguments for why the court decision should have been the rational one. Oh, I'm looking for lithium. I need lithium. I should just play Agario or something stupid while doing this from now on. I do like a 10-hour Agario stream. Or Slitherio, one of those browser games that's super simple so I can focus on reading. I get bored of those games really quickly.
At a time when concerns about the conduct of judicial elections have reached a fever pitch, see, e.g., O'Connor, Justice for Sale, Wall Street Journal, November 15, 2007.
Oh, what? I got all the way over to the bulb tree?
The court today unleashes the floodgates of corporate and union general treasury spending in these
How did I get all the way over here? How did I do that?
Caperton motions will catch some of the worst abuses. This will be small comfort to those states that
Oh, I'm beyond my crush depth. Oops, that's stupid.
to place modest limits on corporate electioneering even if they believe such limits to be critical to maintaining the integrity of their judicial systems. Rather than show any deference to a coordinate branch of government, the majority
Okay, for the love of God, I literally just need lithium.
67 Today's opinion provides no clear rationale for being so dismissive of Congress, but the prior individual opinions on which it relies have offered one, the incentives of the legislators who passed BCRA. Section 203, our colleagues have suggested, may be little more than an incumbency protection plan. McConnell, 540 U.S. at 306, Kennedy, J. Concurring in judgment in part and dissenting in part, see also ID, at 249 to 250, 260 to 263, Scalia, J. Concurring in part, concurring in judgment in part, and dissenting in part, a dis.
Oh my god.
67-inch we must give weight and due deference to Congress's efforts to dispel corruption, the court states at one point. Ante, at 45. It is unclear to me what these maxims mean, but as applied by the court they clearly do not entail deference in any normal sense of that term. Opinion of Stevens, J. Reputable attempt at legislative self-dealing rather than an earnest effort to facilitate First Amendment values and safeguard the legitimacy of our political system. This possibility, the court apparently believes, licenses it to run roughshod over Congress's handiwork. In my view, we should instead start by acknowledging that Congress surely has both wisdom and experience in these matters that is far superior to ours. Colorado Republican Federal Campaign Com v. FEC, 518 U.S. 604, 650, 1996, Stevens.
Like every time I've ever played this game, it's freaking lithium that stops me. Lithium or nickel ore. But at least I know where to find nickel ore nowadays.
See, E.G. McConnell, 540 U.S. at 158, Beaumont, 539 U.S. at 155 to 156, NRWC, 459 U.S. at 209 to 210. Moreover, J. Judicial deference is particularly warranted where, as here, we deal with a congressional judgment that has remained essentially unchanged throughout a century of careful legislative adjustment. Beaumont, 539 U.S. at 162.
I have no idea how I saw that from like 10 feet away.
Marks omitted. CF Shrink, Missouri, 528 U.S. at 391. The quantum of empirical evidence needed to satisfy heightened judicial scrutiny of legislative judgments will vary up or down with the NOVLT and plausibility of the justification raised. In Ammer, ICA, incumbent legislators.
In Ammer, ICA. In America. That's funny.
Just like all other laws. To apply a level of scrutiny that effectively bars them from regulating electioneering whenever there is the faintest whiff of self-interest, is to deprive them of the ability to regulate electioneering. This is not to say that deference would be appropriate if there were a solid basis for believing that a legislative action was motivated by the desire to protect incumbents or that it will degrade the competitiveness of the electoral process. 68C League of United Latin American Citizens. 68 Justice Breyer has suggested that we strike the balance as fall. Citizens United v. Federal Elections COMMN Opinion of Stevens, J. V. Perry, 548 U.S. 399, 447, 2006, Stevens, J. Concurring in part and dissenting in part, Vith versus Jubileer.
Oh, why do I have a bunch of rubies?
267, 317, 2004, Stevens, J. Dissenting. Along with our duty to balance competing constitutional concerns, we have a vital role to play in ensuring that elections remain at least minimally open, fair, and competitive. But it is the height of recklessness to dismiss Congress's years of bipartisan deliberation and its reasoned judgment on this basis, without first confirming that the statute in question was intended to be, or will function as, a restraint on electoral competition. Absent record evidence of NVIDIA.
Oh, when can I get done reading this? I have like 8 other documents for this exact topic that I have to research after this. Oh, how am I doing on battery for my microphones? The one I'm wearing is dying again. Okay.
Evidence from which to conclude that BCRA Section 203, or any of the dozens of state laws that the court today calls into question,
recharging.
reflects or fosters such invidious discrimination. Our colleagues have opined that any restriction
there we go. Now I'm charging.
Campaign speech
Cool.
that is equally available to challengers and incumbents.
Yeah, I have to read up on some of these other documents. A lot of these other court cases that have precedent. I'm gonna have to read their summaries still. After reading this, those are all things I will read independently on my own in my head.
Because incumbents have pre-existing relationships with corporations and unions, and groups that wish to procure legislative benefits may tend to support the candidate who, as a sitting officeholder, is already in a position to dispense benefits and is statistically likely to retain office. If a corporation's goal is to induce officeholders to do its bidding, the corpo Los, we should defer to the legislature's political judgment that unlimited spending threatens the integrity of the electoral process. But we should not defer in respect to whether its solution insulates legislators from effective electoral challenge. Shrink, Missouri, 528. U.S.
Lithium. Oh my god.
404, concurring opinion. Opinion of Stevens, J.
It's terrible.
Ration would do well to cultivate stable, long-term relationships of dependency. So we do not have a solid theoretical basis for condemn ing section 203 as a front for incumbent self-protection, and it seems equally if not more plausible that restrictions on corporate electioneering will be self-denying. Nor do we have a good empirical case for skepticism, as the court's failure to cite any empirical research attests.
What about the way that I play this game makes it so I am always... I never have enough lithium. I don't understand.
Legislative proposals in recent years have received as much sustained public commentary or news coverage, political scientists and academic experts, with no self-interest in incumbent protection, and were central figures in pressing the case for BCRA, and the legis lat ion commanded bipartisan support.
There's one. Okay, I need like 5 more.
The Supreme Court 2003
Probably.
forward, the constitutionalization of democratic
Holy
politics,
cow, this sucks.
118 Harv. L.Rev 28, 137, 2004. Finally, it is important to remember just how incumbent-friendly congressional races were prior to BCRA's passage. As the Solicitor General aptly remarked at the time, the evidence supports overwhelmingly that incumbents were able to get re-elected under the old system just fine. TR of Oral Argon McConnell v. FEC, OT 2003, number 02-01674, page 61. It would be hard to develop a scheme that could be better for incumbents. ID at 63. In this case, then, there is no convincing evidence that important interests favoring expenditure limits are fronts for incumbency protection. Randall, 548 U.S., at 279, Stevens, J., dissenting. In the meantime, a legislative judgment that enough is enough should command the greatest possible deference from judges interpreting a constitutional provision that, at best, has an indirect relationship to activity that affects the quantity of repetitive speech in the marketplace of ideas. ID at 279. Citizens United v. Federal Elections COMMN opinion of Stevens, J. 280. The majority cavalierly ignores Congress's factual findings and its constitutional judgment. It acknowledges the validity of the interest in preventing corruption, but it effectively discounts the value of that interest to zero. This is quite different from conscientious policing for impermissible.
Oh, that was entertaining. I got a random spam call in the middle of streaming, and I went to go Google if they were legit or not. I mean, not that I actually was going to listen to them at all, but I oftentimes like to answer spam calls with the express purpose of messing with them. Because spam callers are extraordinarily horrible human beings that cause genuine deleterious harm to specifically the elderly and the most vulnerable of populations. So I just muted for a second to go mess with them on the call. I'm back to work now. What am I at? I really want to be done soon. I'm definitely getting tired. 161 of 183. Okay, 20 more pages. Well, what sucks is I know that I'm not going to beat Subnautica in that time, which kind of bothers me a lot.
First Amendment context. It is the denial of Congress authority to regulate corporate spending on elections. Just as the majority gives short shrift to the general societal interests at stake in campaign finance regulation, it also overlooks the distinctive considerations raised by the regulation of corporate expenditures. The majority fails to appreciate that Austin's anti-distortion rationale is itself an anti-corruption rationale, see 494 U.S. at 660, describing a different type of corruption, tied to the special concerns raised by corporations. Understood properly, anti-distortion is simply a variant on the classic governmental interest in protecting against improper influences on officeholders that debilitate the democratic process. It is manifestly not just an equalizing ideal in disguise. Ante, at 34, quoting Buckley, 424 U.S., at 48.69. 69. The Chief Justice denies this, ante, at 9 to 10, citing scholarship that has interpreted Austin to endorse an equality rationale, along with an article by Justice Thurgood Marshall's former law clerk that states that Marshall, the author of Austin, accepted equality of opportunity and equalizing access to the political process as basis for campaign finance regulation. Garrett, New Voices in Politics. Justice Marshall's Jurisprudence on Law and Politics, 52 Howard L. and J. 655, 667 to 668, 2009. Internal quotation marks omitted. It is fair to say that Austin can bear an egalitarian reading, and I have no reason to doubt this characterization of Justice Marshall's beliefs. But the fact that Austin can be read a certain way hardly proves the Chief Justice's charge that there is nothing more to it. Many of our precedents can bear multiple readings, and many of our doctrines have
Oh my god, give me lithium. What is
rest on an
wrong?
equalizing theory. For example, the fact that corporations are different from human beings might seem to need no elaboration, except that the majority opinion almost completely elides it.
Yep.
Austin set forth some of the basic differences. Unlike natural persons, corporations have limited liability for their owners and managers, perpetual life, separation of ownership and control, and favorable treatment of the accumulation and distribution of assets that enhance their ability to attract capital and to deploy their resources in ways that maximize the return on their shareholders' investments. 494 U.S. at 658 to 659. Unlike voters in U.S. elections, corporations may be foreign-controlled. 70. Unlike other interest groups, business corporations have been effectively delegated responsibility for ensuring society's economic welfare. 71. They inescapably structure the life of every citizen.
You should stop promoting
T.
lithium.
Resources
Yeah,
in
I'll
the
do it.
treasury of a Busi
What is the objective of the video anyways in relation to the court case? So,
popular support for the corporation's political
that's a
ideas.
long explanation. About as long as a lot of what the video will be like. The objective of this video, right, so previously I read through all of Project 2025, and the reason for that is because of the quiet part. Like, the underlying idea is for me to talk about topics and policies that I feel like aren't getting enough attention, but despite not being spoken about very loudly and only ever being spoken about rather quietly, these are oftentimes things that have extraordinarily significant and oftentimes negative effects on people's lives. And, you know, I read Project 2025 and I kind of figured out a lot of the underlying things going on in that part of the Republican Party or conservative wing of politics in the United States. With this topic, I have been asking myself, I've been challenging myself to say, like, if I were president for a day, or I had a magic genie and I could only use 3 wishes, and I had to change policies in the United States, so pieces of legislation or court precedent or laws, if I could only target just a sentence worth of things, you know, if I were speaking to a stranger and trying to make sure that they knew what the most important things in their life that need change are, how could I get that down into one sentence? And I know right now that the outcome of this court case, Citizens United versus the FEC, this is one of the things that, you know, if you know, if you could send me back 10 years or send me back like a year before Donald Trump's first campaign, or 2 years before, you know, if you could send me back to the future, but I could only share like one sentence with someone from the past, I feel that I would say overturn Citizens United versus FEC. I would say overturn this as soon as possible, and it will save America from a generation of dangerous politics, because this is the most influential, one of the most influential pieces of politics in American history in my lifetime. And as long as it remains true that this court case is the way it is, it will likely continue being extremely influential. The outcome of almost every single election will continue to be determined based on corporate spending. It has been for 10 years, and it will continue being that way. So I just felt that this is one of the topics where like a lot of average Americans have no idea about this court case even existing. Even ones who were adults when this court case was happening in 2010. I've spoken to some and they don't remember this court case. And I think that might, to some degree, be on purpose. So, in pursuit of saying the quiet part out loud, and in pursuit of investigating and uncovering topics and policies that I feel like need more attention, I discovered Citizens United versus FEC and decided, okay, this is one of the ones where I have to absolutely speak about it. But when I speak about it, I need to be incredibly objectively correct. I need to be incredibly informed on the topic, because if I'm going to turn around to other people and say, you need to know what this is, it's very important, I need to make damn well sure that I understand what it is to an extraordinary degree and with a lot of specificity. So that's why. That's the objective of doing this research, is I'm going to put together a video talking about this court case and talking about why it's so important, talking about the philosophy underlying it, and essentially advocating that more people need to know about this outcome. More people need to understand that modern politics is a consequence of the Supreme Court case. And obviously I'm going to finish up the video by compelling everyone to fight desperately to do anything we can to overturn this court decision, because it's just that dangerous. So realistically, the objective is to do some journalism, like to do some research, to talk about this topic. But this is actually just 1/3 of the like big 3 political topics that I want to do big research projects on. One is Citizens United versus FEC. That's this. Then after this, I want to do PACs, or political action committees. I want to look into the history of political action committees. And then the third, I kind of forget, but there's one other very big thing tied to American democracy that I really want to talk about, but I can't quite remember what it was anymore. Citizens United versus FEC, and then there's PACs. There's one other big political topic, but obviously I barely even remember it, which is honestly reason that I need to do this sort of work and learn these things as well as I have. But that's the objective, to talk about something that needs to be talked about, but I don't think anyone really remembers or has spoken about previously. Or at least I don't see people talk about it nearly enough. Especially like other people in like the left-wing space or political space. When we talk about all these culture war issues that focus on like social topics, I like those matter deeply and those affect people to an extraordinary degree. We're talking about people's lives, but there's like this broader conversation of like, well, yeah, well, how did things get this bad in the first place? Like, why is it that like trans people are like being written out of existence right now? Like, how the hell did that happen? How did we get leaders in office, and not just 1 or 2 extremists or whatever the language you might want to be uses, not just 1 or 2 particularly anti-human, bigoted people. How is it that we got an entire goddamn Senate and Congress of people that are bigoted in a country that was once obsessed with the idea of egalitarianism? How did that happen? And so much time is being spent by people on the left talking about, ooh, you know, here's this shocking headline about how they're rolling back the rights of trans people, which, like, yes, that is shocking. Yes, that should be talked about. Oh, APAC, that's a great reference. You know what? I'll mention that in a sec, but I kind of want to wrap up this thought, even just for myself. Again, like, these streams, as much as they're like, you know, just kind of a fun thing to throw on the channel, they're mostly kind of for me, just to kind of look back through as I do my research. What I do is I scrub through the video clip, and then the video clip, and then I look for moments where I speak for longer, and that lets me remember which sections of the document were most salient to me. But to kind of wrap up, like, why is it that I think this is so important? There's a lot of people on the left, a lot of people in the progressive space that talk about social issues. They talk about the social psychology and the politics, and they do the analysis, but they don't explain this like one extremely important thing that effectively caused all of these other issues. Like, we wouldn't have people like this in office if it weren't for the fact that for the past 15 years, companies have been able to pour billions of dollars into every federal election. Like, how did Donald Trump win twice? Like, yes, you can tell yourself, like, oh, it's because Americans are stupid. Yeah, sure, that's not wrong. But, like, how did it get this bad? And the answer is Citizens United versus FEC. It made it legal for anyone with money to put as much money as they want into making their own propaganda for any political candidate. So that's just why I thought it was so important. APAC is super relevant. Do you know what's crazy? So I don't actually know what APAC stands for, but obviously it's the Israel Pact. It's the, I don't know, maybe it stands for American Israel Pact or something. You know what's funny? I've known about political action committees and super political action committees or super PACs. I've known about them for a long time. And I've known that APAC was the Israel donation money funding mechanism, right? You know what's funny? I never realized until today that the PAC in APAC meant political action committee. I'm so stupid. I'm so used to I thought it was just a different type of acronym, and I only just realized literally today that APAC was a political action committee this whole time. Like, I obviously knew there was some funny mechanism for, as far as I understood, advocating for Israel, the state of Israel in the United States, but I only just realized they were a political action committee, because in this document it actually mentioned APAC. And I was like, APAC? And I had never seen it spelled out. I had only ever heard it said aloud. This is probably like a dyslexia thing, honestly. Yeah, I don't remember what the third topic was, but it was Citizens United versus FEC. It was obviously, oh man, I just totally bonked out because I finally got lithium. Citizens United versus the FEC, and then the existence of PACs at all, and then there was one more thing that was connected to how, oh, gerrymandering and redlining. I'm so stupid. How did I forget? That's how you know I'm tired. Gerrymandering is the process by which in the United States voting districts can be, the lines of the actual voting district maps can be redrawn to help centralize, to help force the votes in a state or a county or a district to go right or left. So if you just redraw the lines, you can kind of like, ooh, this district will actually vote just barely red, but this one will vote super blue if we just choose this area of the town. Gerrymandering is still legal in the United States, even though I've been told about it since I was in government class in my own high school, like a decade ago. So gerrymandering, and then redlining is similar to gerrymandering, except it's more racist and it's more classist. Redlining was this process where banks and financial institutions wouldn't provide loans or opportunities for vertical financial mobility to people of color and poor people. So, like, the fact that those two practices are still legal is actually mind-blowing. So those were the two / the third or fourth kind of topics I wanted to do in like this series of videos, where instead of talking about the culture war social issues, which I do absolutely, because I don't want to say that just because a topic is social, that means it's not as important. I absolutely talk about social issues. The other thing is that if we don't focus on the underlying mechanisms that are creating these social issues, then we're never going to inform people enough for them to realize, like, hey, this is what we have to specifically change to fix the problem. Depth upgrade. I finally have enough to build the stupid depth upgrade. All right, I'm going to go back to reading. Yeah, the Electoral College itself, too. I don't even know what to say about the Electoral College. It's actually not complicated enough for me to have to research. Like, I know how it works because it's actually pretty simple from, like, history class and government class and school. I don't even know how the Electoral College exists. Obviously, like, I'm a big advocate of direct democracy. I think people should have to vote directly on policies rather than, ooh, grab some rubies. Rather than having representatives vote on policies, I genuinely think we should just have people directly vote on pretty much everything all the time. I don't care if we have to vote really often, I'll do it. Some people will do it, lots of people will do it, and they'll care. And they'll have far more control over the outcomes of their communities.
Based on equality that no one other than perhaps Justice White would have even considered joining. Garrett, 52 Howard LAJ, at 674.70 inches state elections. Even domestic corporations may be foreign controlled in the sense that they are incorporated in another juristic tie-in. And primarily owned and operated by out-of-state residents. 71 Reagan, corporate speech and
It's, one of the interesting arguments that's been made in this document, it's very neoliberal, which obviously I do not fuck with. One of the very neoliberal arguments has been, if corporations can advertise, doesn't that mean like China can buy a corporation and advertise? Which, that sort of argument is something that would get an American patriot quaking in their boots. Whereas I am like, oh, okay, and? I don't really give in to the, every other country's trying to subvert American democracy propaganda, the American exceptionalism. But that was an argument these guys were making. Justice Stevens was being like, ooh, what if China is, you know, a major owner in a corporation and they're allowed to advertise to Americans? Isn't that dangerous?
Members of we the people by whom and for whom our Constitution was established. These basic points help explain why corporate electioneering is not only more likely to impair compelling governmental interests, but also why restrictions on that electioneering are less likely to encroach upon First Amendment freedoms. One fundamental concern of the First Amendment is to protect the individual's interest in self-expression. Consolidated Edison Company of NY via Public Serve Common of NY 447 U.S. 530 534 N2 1980. See also below 435 U.S. at 770.
I need nickel ore. I think I might need rubies or kyanite. I can't remember which. But
free to develop their faculties. Whitney versus California 274 U.S. 300.
grab some rubies.
375 1927.
Grab some nickel ore. Grab some kyanite just so we have it.
72-0 in this analysis turns on whether the corporation is conceptualized as
couple more rubies, couple of diamonds.
E.g., trustees of Dartmouth College versus Woodward for wheat. 518, 636, 1819, Marshall. CJ, a nexus of explicit and implicit contracts. C, e.g., F. E. Easterbrook and D. Official, The Economic Structure of Corporate Law 12, 1991, a mediated hierarchy of stakeholders. C,
There's that.
Blair and Stout, a team production theory of corporate
And
law.
then to make the
85 Virginia
deeper
L.
one, I'll
Rev.
have to
247,
do who knows what.
1999, herein after Blair and Stout, or any other recognized model.
Let's upgrade it.
Austin
Straight to the max.
Structure and the advantages of corporations as state conferred in several places. 494 U.S. at 660, 665, 667, but its anti-distortion argument relied only on the basic descriptive features of corporations, as sketched above.
Lithium, titanium, kyanite. Wow, that's easy.
Agree on a precise theory of the
Not too bad.
corporation to agree that corporations differ from natural persons in fundamental ways, and that a legislature might therefore need to regulate them differently if it is human welfare that is the object of its concern. C.F. Hansman and Krochman 4.
Oh, good God, that took so long. I'm so glad I didn't try to ever speedrun this game for a stream. That would have been terrible. It just takes a long time if you don't use like exploits and cheats. If you just do like a raw speedrun, this is hard.
The value of individual self-realization. Reddish, the value of free speech. 130 U. Pyle, Rev. 591, 594, 1982. Corporate speech, however.
All right, that's maxed out.
Speech by proxy. A regulation such as BCRA Section 203 may affect the way in which individuals disseminate certain messages through the corporate form, but it does not prevent anyone from speaking in his or her own voice. Within the realm of campaign.
Yeah, now I have crystalline sulfur. I might be able to make the jump jet upgrade.
Political expression. Beaumont, 539
Sulfur, more lithium. Uh-oh.
N8.
Nickel, titanium.
It is an interesting question.
I don't know if I'll have that.
When a business corporation places
I only have 2 sulfurs. Crap, that
a
sucks.
particular candidate. Presumably it is not the customers or employees, who typically have no say in such matters. It cannot realistically be said to be the shareholders, who tend to be far removed from the day-to-day decisions of the firm, and whose political preferences may be opaque to management. Perhaps the officers or directors of the corporation have the best claim to be the ones speaking, except their fiduciary duties generally prohibit them from using corporate funds for personal ends. Some individuals associated with the corporation must make the decision to place the ad, but the idea that these individuals are thereby fostering their self-expression or cultivating their critical faculties is fanciful. It is entirely possible that the corporation's electoral message will conflict with their personal convictions. Take away the ability to use general treasury funds for some of those ads, and no one's autonomy, dignity, or political equality has been impinged upon in the least. Corporate expenditures are distinguishable from individual expenditures in this respect. I have taken the view that a legislature may place reasonable restrictions on individuals' electioneering expenditures in the service of Citizens United
Whoa.
before federal elections.
Whoa, I just had a weird stutter. My whole computer just stuttered.
J. The governmental interests explained above,
The
and in
owner and
recognition
controllers
the
of
fact
global
that such
financial
restrictions are
capital.
not direct restraints on
I feel like
speech
I've heard
or
that
on
in
its
context of
See, e.g., Randall,
the
548
owners and
US,
controller of
and
global capital.
273, dissenting
Owners.
opinion.
And I'm Googling it.
But those restrictions conceitedly present a
Financial
tougher case,
capital. Haven't I
because
heard
the
that in
primary
context of
conduct
like
actual
other political
flesh and
writing?
blood
Like going back
persons
to
is
something.
involved. Some of those individuals might feel that they need to spend large sums of money on behalf
Owners
of a
and controllers of
particular candidate
of
to vindicate the
global
intensity of their
financialized capital. They include Wall Street, the City of London,
This is
BlackRock. Oh,
obviously
these
not the
guys!
situation with
Well, I know
boosting
about
these
BlackRock, and I
corporations,
sat
as their
through a little
routine
bit of BlackRock
practice of giving
suffering at one
substantial
point
sums to
during
global
Project
international
2025
parties
reading,
makes Hello
because they
Sidley
actually
clear.
mentioned BlackRock
But
indirectly.
540 US,
Large sovereign wealth funds.
148. See, operate
So it's
participation
essentially
in
a
elections.
term that
Any business executive
that
will tell you
captures
is
and
more
puts under an
transactional than
umbrella
ideological.
a
Brief for Committee for Economic
large group of
Development has
people
covered
that
this curious
have
term.
the greatest financial stake in the
In
world.
this transactional spirit, some corporations have
Saudi
affirmatively urged
Arabia
Congress
and
to
the
place
United Arab
limits on their
Emirates too. Yeah,
elected
so these are
money-laundering
people with giant
communications.
oil
These
reserves,
corporations fear that office
giant
holders will
investment
shift
firms
to
like
them for
BlackRock.
supportive
I know
ads,
London
and
is
they will
like
have
its
to
own
spend
entire
increasing
thing, and then
sums on
obviously the Wall Street in
election
the
and
United
for
States.
escalating arms race with their competitors, and that public trust in business will be eroded. CID at 10 to 19. A system that effectively forces corporations to use their shareholders' money both to
Interesting
maintain access
concept.
to and to avoid retribution from elected officials may ultimately prove more harmful than beneficial to many corporations. It can impose a kind of implicit tax. Point 73. 73. Not all corporations support BCRA Section 203, of course, and not all corporations are large business entities for their tax-exempt adjuncts. Some non-profit corporations are created for an ideological purpose. Some closely held corporations are strongly identified with a particular owner or founder. The fact that Section 203, like the statute at issue in Austin, regulates some of these corporations' expenditures does not disturb the analysis above.
Oh, okay. I am not good at typing today at all.
661 to 665.
But it's a concept for capturing like the whole
Opinion of
collective of
regulations
those
through Section 203 in the statute upheld in Austin impose only a limited burden on First Amendment freedoms, not only because they target a narrow subset of expenditures and leave untouched the broader public dialogue, at 25, but also because they leave untouched
YouTube saying it's not getting enough data suddenly. I don't know what's getting on.
Recognizing the weakness of a speaker-based critique of Austin,
I
places primary emphasis not on the corporation's right to electioneer.
Well, I like the idea that this acronym or this concept focuses in on the actual the specific places that have the wealth or the names of the companies, because that's one of the things is like obviously it's almost a synonym for just saying the word oligarch, right? Like these are the oligarchs. These groups are the oligarchs, and then there must be individual people within the groups that are, you know, the true oligarchs. But giving it a specific name that you can kind of point out and look to and be like, hey, look, it's BlackRock. They invest in everything. They are invested in war. They are invested in the industry of war. They are invested in real estate, and they snatch up literal homes and every piece of property they can. These guys are the owners of capital throughout the world. I like the idea of that, being able to point to a specific business or country, definitely a state. I should learn more about the United Arab Emirates and everything going related to that. It's definitely something I never really learned about.
Non-profit
Donation.
corporations that want to
Content
make
with a grain of
unrestricted
salt.
electioneering expenditures may do so.
No, I will. I might check that out.
From businesses in
When I first Googled it, to be honest with you, Mouth Exhaust, one of the first things I saw when I Googled it was someone saying that, like, are the Jews? And I was like, oh, okay, that's, I don't want to see that. But you know what? That's just the internet. There's like this whole meta discussion about, like, it's still true. Like, anti-Semitism is fucking everywhere on the internet. It's everywhere in real life. It's everywhere on the internet. You see it in the weirdest fucking places. There's always someone who's desperate to connect their bigotry to other types of politics.
Roosevelt's remarks. The distinctive threat to democratic integrity posed by corporate domination of politics was recognized.
You know, it'll be really interesting. I should research... see, that's the issue. Is now I want to talk about AIPAC in the coming video. I want to research that, but I can't do it. I'll lose scope. I need to focus in on just... I need to focus in on just this. Just this court case. Then when I do my one about PACs, I'll look at AIPAC.
General Treasury expenditures will give corporations our influence in the electoral process, 494 U.S. at 660, and distort public debate in ways that undermine rather than advance the interests of listeners. The legal structure of corporations allows them to amass and deploy financial resources on a scale few natural persons can match. The structure of a business corporation, furthermore, draws a line between the corporation's economic interests and the political preferences of the individuals associated with the corporation.
I can't believe it, but I just have too much. I just have too many items in this game now.
No matter how persuasive the arguments for a broader or conflicting set of priorities. Brief for American Independent Business Alliance as Amicus Curiae 11, see also ALI, Principles of Corporate Governance, Analysis. And Recommendations Section 2.01, A, page 55, 1992, A, Corpora.
I'm trying to avoid building new lockers for like the past 8 hours in the game.
With a view to enhancing corporate profit and shareholder gain. In a state election such as the one at issue in Austin, the interests of non-resident corporate tie-ins may be fundamentally adverse to the interests of local voters. Consequently, when
I just have too much stuff.
Broadcasting slots on the eve of an election, they can
What in the world is currently bashing into me in this game? What was that?
Or to any broader notion of the public good. 494 US.
Alright, they're talking about natural persons again. They've started really just restating arguments that they've made about 20 times.
Opinion of Stevens, J. In addition to this immediate drowning out of non-corporate voices, there may be deleterious effects that follow soon
after.
Corporate domination of electioneering, Austin, 494 U.S. at 659, can generate the impression that corporations dominate
our Well, you don't need to generate the impression anymore. It is objectively true that corporations now dominate our democracy 15 years later after they made this decision. It's not even just about the appearance of things. It actually happened.
Will be neither responsive to their needs nor willing to give their views.
Yes, wow. Oh, wow.
The predictable result is cynicism and disenchantment.
Wow. Whoa, what page is this? This has to go in the 168. 168, I think so. I can't see it very well from here. 168. Whoa, 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 whoa. When citizens, corporate domination of electioneering can generate the impression that the corporations dominate our democracy. When citizens turn on their televisions and radios before an election and hear only corporate electioneering, they may lose faith in their capacity as citizens to influence public policy. A government captured by corporate interests, they may come to believe, will neither be responsive to their needs nor willing to give their views a fair hearing. The predictable result is cynicism and disenchantment, an increased perception that large spenders call the tune, and perception that large spender and a reduced willingness of voters to take part in democratic governance. Holy shit. 15 years ago. 15 years ago, they perfectly predicted the outcome of this legislation. Gen Z and the entire country is continuing to turn out in terrible rates to every election. The disenchantment is horrific. And that disenchantment has created an opportunity for these big spenders to capture a lot of specifically young men and Gen Z in the United States because they were so disenchanted. Jesus, I can't believe they just said that. Oh my God, this justice has to feel so fucking cocky, and he should. He said exactly what happened. It just led to a modern democracy where everyone feels extremely disenchanted. That's crazy that they're using the word disenchantment, because I use that word a lot. I use that word a lot when specifically referring to younger people and modern politics in the United States. I use the word disenchantment or disenfranchisement, which technically refers to losing the right to vote altogether, but holy crap, 168. Okay, I need to remind. That's why I'm saying it. I'm saying it loudly so that way, literally audibly loudly, so that way on the video I can look for the waveform and find me saying this. Holy crap. The entire first stream was really not that important. It just kind of summarized their final ruling and like basic stuff about the background, but this has been most interesting so far. Wow. Okay, I've got like, 20 more pages.
Only
25?
electioneering, they may lose faith in their capacity.
Wow, holy cow.
To influence public policy. A government captured by corporate interests, they may come to believe, will be neither responsive to their needs nor willing to give their views a fair hearing. The predictable result is cynicism and disenchantment, an increased perception that large spenders call the tune, and a reduced willingness of voters to take part in democratic governance. McConnell, 540 U.S. at 144, quoting Shrink, Missouri, 528 U.S. at 390. To the extent that corporations are allowed to exert...
Alright, I need to get into the mountains biome
the speech of the eventual winners
and
of
look
those
for
races may
the
also
grappling
show.
arm. I don't need it, but I'm gonna want it.
Politicians who fear that a certain corporation can make or break their re-election chances may be cowed into silence about that corporation. On a variety of levels, unregulated corporate electioneer ing might diminish the ability of citizens to hold officials accountable to the people, anti, at 23, and disserve the goal of a public debate that is uninhibited, robust, and wide open. New York Times Company v. Sullivan, 376 U.S. 254, 270, 1964. At the least, I stress again, a legislature is entitled to credit these concerns and to take tailored measures in response. The majority's unwillingness to distinguish between corporations and humans similarly blinds it to the possibility that corporations war chests and their special Citizens United v. Federal Elections COMMN. Opinion of Stevens, J. Advantages in the legal realm, Austin, 494 U.S. at 659, may translate into special advantages in the market for legislation. When large numbers of citizens have a calm stake in a measure that is under consideration, it may be very difficult.
This is the right biome. I need to start looking for crashes and wrecks inside of here.
The corporate form, by contrast, provides a simple way to channel rents to only those who
Hey, look,
pay
a
their
crash
dues,
slash wreck.
as it were.
That was quick.
If
Very
you
good.
do not own stock, you do not benefit from the larger dividends or appreciation in the stock price caused by the passage of private interest legislation. Sitkoff, Corporate Political Speech, Political Extortion, and the Competition for Corporate Charters, 69 U. GL, Rev 1103, 11.
Oh, I've already been here. Pretty sure.
Corporate tie-ins, that is, are uniquely equipped
I had
to
been
seek
here.
laws that
Not
favor
good.
their owners, not
I'll keep
simply
looking.
because
Maybe
they
I'll
have a
find
lot
that
of
grapple
money,
arm
but because of
somewhere.
their legal and organizational structure. Remove all restrictions on their electioneering, and the door may be open to a type of rent-seeking that is far more destructive than what non-corporations are capable of. IBID. It is for reasons such as these that our campaign finance jurisprudence has long appreciated that the differing structures and purposes of different entities may require different forms of regulation in order to protect the integrity of the electoral process. NRWC 459.
Wow.
The court's facile depiction of corporate electioneering assumes away all of these complexities. Our colleagues ridicule the idea of regulating expenditures based on nothing more than a fear that corporations have a SPE-style ability to persuade, ante, at 11, opinion of Roberts. CJ, as if corporations were our society's ablest debaters and viewpoint-neutral laws such as Section 203 were created to suppress their best
Ableist,
arguments.
not ableist.
In the case to knock down yet another
I did
strong
not
man,
read that
our
correctly. I
colleagues
was like,
simply
what?
ignore the fundamental concerns of the Austin court and the Opinion of Stevens, J. Legislatures that have passed laws like Section 203
Grapple arm, no.
to
Okay,
safeguard
sure.
the integrity, competitiveness, and democratic
Crap.
responsiveness of the electoral process.
Where was the
Majority's
grapple arm?
theoretical arguments turn on a proposition with undeniable surface appeal but little grounding in evidence or
Dang it.
experience, that there is no such thing as too much speech. Austin, 494 U.S. at
Oh, grapple arm?
695. Scalia,
Maybe?
J.
Torpedo arm? I don't even need that. That's
174
stupid.
individuals in our society had infinite free time
I need
to
like the
listen
one
to
you
and
actually
contemplate
need in the
every
game
last
to get
bit of
around.
speech uttered by anyone, anywhere.
Crap, I'm running
And
out of air.
broadcast advertisements had no special ability to influence elections apart from the merits of their arguments, to the extent they make any, and if legislators always operated with nothing less than perfect virtue, then I suppose the majority's premise would be sound. In the real world, we have seen, corporate domination of the airwaves prior to an election may decrease the average listener's exposure to relevant viewpoints, and it
We diminish citizens' willingness and capacity to participate in the vote. Wow! Man, with just the last 20 pages.
process.
Huge.
None of this is to suggest that corporations can or should be denied an opportunity to participate in election campaigns or in any other public forum, much less that a work of art such as Mr. Smith Goes to Washington may be banned, or to deny that some corporate speech may contribute significantly to public debate. What it shows, however, is that Austin's concern about corporate domination of the political process, 494 U.S. at 659, reflects more than a concern to protect governmental interests outside of the First Amendment. It also reflects a concern to facilitate First Amendment values by preserving some breathing room around the electoral marketplace of ideas, ante, at 19, 34, 38, 52, 54, the marketplace in which the actual people of this nation determine how they will. 74 Of course, no presiding person in a courtroom,
Okay.
legislature,
No fragment in this
classroom,
wreck.
polling place, or family dinner would take this hyperbole literally. Citizens United v. Federal Elections COMMN. Opinion of Stevens, J.
Wow, I never realized, and this is going to sound really bad and cocky, but I never realized the degree to which that when I make arguments, I sound surprisingly similar to whoever this justice is. I love talking about how I personally love talking about how, like, listen, if you presented this idea to like a random person at the dinner table or a random person on the street, would they think it's reasonable, yes or no? And the fact that a Supreme Court justice is using that same logic, I'm not sure if that's a good thing or a bad thing for me. It might mean that I'm traditionally pretty logical, but it also might mean that my logic is rooted in some pretty deep institutions, which is not something I would particularly want for myself. So,
but when the
who
speakers
knows?
in question are not real people and when the appeal to First Amendment principles depends almost entirely on the listener's perspective, ante, at 1:48, it becomes necessary to consider how listeners will act to ally be affected. In critiquing Austin's
Really?
anti-distortion
I go 30 feet and you instantly attack me? Leave me alone.
Our colleagues place tremendous weight on the example of media corporate tie-ins. See ante, at 35 to 38, 46, ante, at 1:11, opinion of Roberts, C.J., ante, at 6, opinion of Scalia, J. Yet it is not at all clear that Austin would permit Section 203 to be applied to them.
Leave me alone.
Not only in the text,
You are
history,
ugly.
and structure of the First Amendment but also in facilitating public discourse. As the Austin court explained, media corporations differ significantly from other corporations in that their resources are devoted to the collection of information and its dissemination
Leave me alone.
to the public.
Go away.
494 U.S. at 667.
This is the
Our
edge of the
colleagues have
map,
raised
isn't
some
it? I'm not
interesting and
stupid.
difficult questions about Congress's
Yes, that
authority
is
to
the edge of the
regulate
map. I'm
election
turning
and the
around.
press, and about how to define what constitutes the press. But that is not the case before us. Section 203 does not apply to media corporations, and even if it did, Citizens United is not a media corporation.
Is he
There
gonna
would
leave
be
me alone or
absolutely
what?
no reason
Am I
to
free?
consider the issue of media corporations if the majority did not, first, transform Citizens United's as applied challenge into a facial challenge and, second, invent the theory that legislatures must issue all
Oh, why not? Might as well charge.
and treat a local non-profit news. Opinion of Stevens, J. Outlet exactly the same as General Motors. 75. This calls to mind George Berkeley's description of philosophers.
Whoa, now he's getting into it.
And then complain we cannot see. Principles of Human Knowledge /3 Dialogues 38, paragraph 3. It would be perfectly understandable if our colleagues feared that a campaign finance regulation such as Section 203 may be counterproductive or self-interested, and therefore attended carefully to the choices the legislature has made. But the majority does not bother to consider such practical matters, or even to consult a record. It simply stipulates that enlightened self-government can arise only in the absence of regulation. Ante, at 23. In light of the distinctive features of corporations identified in Austin, there is no valid basis for this assumption. The marketplace of ideas is not actually a place where items or laws are meant to be bought and sold, and when we move from the realm of economics to the realm of corporate electioneering, there may be no reason to think the market ordering is intrinsically good at all. Strauss 1386. The court's blinkered and aphoristic approach to the First Amendment may well promote corporate power at the cost of the individual and collective self-expression the amendment was meant to serve. It will undoubtedly cripple the ability of ordinary citizens, Congress, and the states to adopt even limited measures to
Is that a wreck or is that an alien power plant?
domination of the
Can't tell.
electoral process.
Alien power plant.
Americans
Dang
may
it.
be forgiven if they do not feel the court has advanced. 75 under the majority's view, the legislature is thus damned if it does and damned if it doesn't. If the
They're allowed to say the word damn.
corporations an exemption from election,
I didn't know they were allowed to say cuss words.
corporate tie-ins, it violates the newly minted First Amendment rule against identity-based distinctions. If the legislature does not give media corporations an exemption, it violates the First Amendment rights of the press. The only way out of this invented bind, no regulations whatsoever. Citizens United v. Federal Elections COMMN. Opinion of Stevens, J. 2. Shareholder protection. There is yet another way in which laws such as Section 203 can serve First Amendment values. Interwoven with Austin's concern to protect the integrity of the electoral process is a concern to protect the rights of shareholders from a kind of coerced speech, electioneering expenditures that do not reflect their support. 494 U.S. at 660 to 661. When corporations use general treasury funds to praise or attack a particular candidate for office, it is the shareholders, as the residual claimants, who are effectively footing the bill. Those shareholders who disagree with the corporation's electoral message may find their financial investments being used to undermine their political convictions.
Dang it, am I going into the void again? God dang it.
Those who pay for an electioneering communication act to ally support its content and that managers do not use general treasuries to advance personal agendas. IBID. It allows corporate political participation without the temp.
Why is it so hard to not end up in the void in this game?
Funds for political influence, quite possibly at odds with the sentiments of some shareholders or members. McConnell, 540 U.S. at 204, quoting Beaumont, 539 U.S. at 163. A rule that privileges the use of PACs thus does more than facilitate the political speech of like-minded shareholders, it also curbs the rent-seeking behavior of executives and respects the views of dissenters. Austin's acceptance of restrictions on general treasury spending.
Oh, is he going pro-PAC now? He's saying, well, we already had PACs, so we don't need any more. I really hope not. But what am I expecting?
Winkler, Beyond Bellotti, 32 Loyola, LA, L. Rev. 133, 201, 1998. Reform. It provided a central motivation for the Tillman Act in 1907 and subsequent legislation. See Pipefitters versus United States, 407 U.S. 385, 414 to 400.
Oh, it looks like I found the blood kelp trench.
Winkler, 92.
Didn't really intend to, but okay.
887 to 900, and it has been endorsed in a long line of our cases. See, e.g., McConnell, 540 U.S. at 204 or 205, Beaumont, 539 U.S. at 150.
Sure, whatever. It's just a giant dude here, whatever. I don't care.
At 258, NRWC, 459 U.S. at 207 to 208, Pipefitters, 407 U.S. at 414 to 416.
Uh-oh, a crab squid.
Supra. Indeed, we have unanimously recognized the governmental interest in Protect, ING, the individuals who have paid money into a corporation or union for purposes other than the support of candidates from having that money used to support political candidates.
Yeah, leave me alone. Leave me alone.
NRWC, 459 U.S. at 207 to 208.
And I'm being attacked by like 15 things at once right now.
The
This is
court
crazy.
dismisses this interest on the ground that abuses of shareholder money can be corrected through the procedures of corporate democracy, ante, at 46, inter NAL quotation marks omitted, and, it seems, through internet-based disclosures, ante, at 55.76. I fail to understand how this addresses the concerns of dissenting union members, who will also be affected by today's ruling, and I fail to understand why the court is so confident in these mechanisms. By corporate democracy, presumably the court means the rights of shareholders to vote and to bring derivative suits for breach of fiduciary duty.
Yeah, again,
In
the
practice,
sole
however, many corporate lawyers
the
will tell you
sole
that these
job
rights are
of
so
a
limited
business.
as to be almost non-existent.
Non-existent.
76. I note that, among the
What?
many other regulatory possibilities it
What
is
was this? What did you just do? Non-existent. Non-exist. Okay, yeah. Quick pro financing scheme. Alright, stop this. Start it here. Almost done. Real close.
10. Given the internal authority wielded by boards and managers and the expansive protections afforded by the business judgment rule. Blair and Stout 320, see also ID, at 298 to 315, Winkler, 32 Loyola, LA, L Rev, at 165 to 166, 199 to 200. Modern technology may help make it easier to track corporate activity, including electoral advocacy, but it is utopian to believe that it solves the problem. Most American households that own stock do so through intermediaries such as mutual funds and pension plans. See Evans, A Requiem for the
That's the
Retail
Blake Hill
Investor.
Trench.
95 Virginia L. Rev 1105, 2009, which makes it more difficult both to monitor and to alter particular holdings. Studies show that a majority of individual investors make no trades at all during a given year. ID, at 1117. Moreover, if the corporation in question operates a PAC, an investor who sees the company's ads may not know whether they are being funded through the PAC or through the general treasury. If and when shareholders learn that a corporation has been spending general treasury money on objectionable electioneering, they can divest. Even assuming that they reliably learn as much, however, this solution is only partial. The injury to the shareholders' expressive rights has already occurred. They might have preferred to keep that corporation stock in their portfolio for any number of economic reasons, and they may incur a capital gains tax or other penalty from selling their shares, changing their pension plan, or the like. The shareholder protection rationale has been criticized as under-inclusive, in that corporations also spend money on lobbying and charitable contributions in ways that any particular shareholder might disapprove. But those expenditures do not implicate the selection of public officials, an area in which the interests of unwilling corporate shareholders, in not being forced to subsidize that speech, are at their ZE. NIF. Austin, 494 U.S., at 677, Brennan, J., concurring. And in any event, the question is whether
Floating Islands? No?
Opinion of Stevens, J. Protection provides a basis for regulating expenditures in the weeks before an election, not whether additional types of corporate communications might similarly be conditioned on voluntariness. Recognizing the limits of the shareholder protection rationale, the Austin
where
court
am
did
I
not
now?
hold it out as an adequate and independent ground for sustaining the statute
Oh,
in
I can't be
question.
there.
Rather,
Blake Hill
the court
Zone. I
applied
must
it
be
to
in the
reinforce
mountains.
the
I have to.
anti-distortion rationale in two main ways. First, the problem of dissenting shareholders shows that even if electioneering expenditures can advance the political views of some members of a corporation, they will often compromise the views of others. See, e.g., ID, at 663,
Yeah, I have to be on
discussing
the
risk
edge.
that corporations members may be reluctant to withdraw as members even if they disagree with its
Here's hoping.
political expression. Second, it provides an anti-tyrannical reason, beyond the distinctive legal attributes of the corporate form, for doubting that these expenditures reflect actual public support for the political ideas ES Post, ID, at 660. The shareholder protection rationale, in other words, bolsters the conclusion that restrictions on corporate electioneering can serve both speakers and listeners' interests, as well as the anti-corruption interest. And it supplies yet another reason why corporate expenditures merit less protection than individual expenditures. Today's decision is backwards in many senses.
No, I'm in the wrong
It
biome.
elevates the majority's agenda over the litigants' submiss science, facial attacks over as-applied claims, broad constitutional theories over narrow statutes.
I don't even know how I ended up in this biome. How is this even possible?
Presidential holdings, assertion over tradition, absolutism
How?
over empiricism, rhetoric over reality. Our colleagues have arrived at the conclusion that Austin must be overruled and that Section 203 is facially unconstitutional only after mischaracterizing both the reach and Citizens United v. Federal Election COMMN opinion of Stevens, J. Rationale of those authorities, and after bypassing or ignoring rules of judicial restraint used to cabin the court's lawmaking power. Their conclusion that the societal interest in avoiding corruption and the appearance of corruption does not provide an adequate justification for regulating corporate expenditures on candidate elections relies on an incorrect description of that interest, along with a failure to acknowledge the relevance of established facts and the considered judgments of state and federal legislatures over many decades. In a democratic society, the long-standing consensus on the need to limit corporate campaign spending should outweigh the wooden application of judge-made rules. The majority's rejection of this principle elevates corporate tie-ins to a level of deference which has not been seen at least since the days when substantive due process was regularly used to invalidate regulatory legislation thought to unfairly impinge.
How am I in a kelp forest? That is insane.
Beloti, 435 US, at 870.
And I've gotten worse at navigating this game, not better.
Dissenting. At bottom, the court's opinion is thus a rejection of the common sense of the American people, who have recognized a need to prevent corporations from undermining self-government since the founding, and who have fought against the distinctive corrupting potential of corporate electioneering since the days of Theodore Roosevelt. It is a strange time to repudiate that common sense. While American democracy is imperfect, few outside the majority of this court would have thought its flaws included a dearth of corporate money in politics. Opinion of
God, this guy's so common sense.
Supreme Court of the United States. Number
Alright, so now we are in, I believe this is no, this is just Justice Thomas. And we are at page 178 of 183, so he literally will only speak for 5 pages and then give up. Okay, good for you, Justice Thomas. 5 pages and then he gives up. All but part 4 of the court's opinion.
Supreme Court of the United States. Number 08205.
I'm so happy to be almost done.
Citizens United, Appellant v. Federal Election Commission. On appeal from the United States District Court for the District of Columbia. January 21, 2010. Justice Thomas, concurring in part and dissenting in part. I join all but Part 4 of the court's opinion. Political speech is entitled to robust protection under the First Amendment. Section 203 of the Bipartisan Campaign Reform Act of 2002, BCRA, has never been reconcilable with that protection. By striking down Section 203, the court takes an important first step toward restoring full constitutional protection to speech that is indispensable to the effective and intelligent use of the processes of popular government.
Why can't I see the frame rate?
Election comment 540 U.S. 93
Whatever.
265 2003 Thomas J. Concurring in part, concurring in judgment in part, and dissenting in part, internal quotation marks omitted. I dissent from Part 4 of the court's opinion, however, because the court's constitutional analysis does not go far enough. The disclosure, disclaimer, and reporting requirements in BCRA sections 201 and 311 are also unconstitutional.
Oh, so this guy wants to go harder.
CID at 275 to 277 and N 10. Congress may not abridge the right to anonymous speech based on the simple interest in providing voters with additional relevant information. ID at 276, quoting McIntyre v. Ohio elections.
Ooh, that'd be an interesting one to look into. See, I personally think speech should pretty much have to be public.
In continuing to hold otherwise,
I think there are appropriate forums for anonymous speech. I think there are topics for anonymous speech makes sense.
COMMN opinion of Thomas J. Describe in which donors to certain causes were blacklisted, threatened, or otherwise targeted for retaliation.
Yeah, I love that. Big fan. Go for it. That should happen.
The court properly recognizes these events as cause for concern, IBID, but fails to acknowledge their constitutional significance. In my view, Amici's sub-Ms. Science show why the court's insistence on upholding sections 201 and 311 will ultimately prove as misguided and ill-fated, as was its prior approval of section 203. Amici's examples relate principally to
Oh crap, I'm in the crater. I know this area.
That California voters narrowly passed in the 2008 general election. Proposition 8 amended California's constitution to provide that, NLY marriage between a man and a woman is valid or recognized in California. Cal. Constant. Art. I. Section 7.5. Any donor who gave
Article
more
1.
than $100 to any committee supporting or opposing Proposition 8 was required to disclose his full name, street address, occupation, and
Okay, street address is crazy. You should not dox a person to that degree.
Of his contributions. 1 C Cal Government Code in Section 84211 if West 2005. The California
Again, street address is insane.
was then required to post this information on the internet. See sections 84600 through 84601, sections 84602 through 84602.1, West Sup 2010, sections 84602.5 through 84604, West 2005, section 85605, West Sup 2010, sections 84606 through 84609, West 2005. Some opponents of Proposition 8 compiled this Informa tie-in and created websites with maps showing the loca tie-ins of homes or businesses of Proposition 8 supporters. Many supporters, or their customers, suffered property damage, or threats of physical violence or death, as a 1 BCRA imposes similar disclosure requirements. See, e.g., 2 U.S.C. Section 434 Chef 2 F. Every person who makes a disbursement for the direct costs of producing and airing electioneering communications in an aggregate amount in excess of $10,000 during any calendar year must disclose the names and addresses of all contributors who contributed an aggregate amount of $1,000 or more to the person making the disbursement. Opinion of
Right,
Thomas.
I think I'm probably just going to finish this out and stop playing and focus on reading as I finish out.
They cited these incidents in a complaint they filed after the 2008 election, seeking to invalidate California's mandatory disclosure laws.
Okay.
Supporters recounted being told, "Consider yourself lucky. If I had a gun, I would have gunned you down along with each and every other supporter," or, "We have plans for you and your friends." Complaint in protectmarriage.com, yes on 8V Bowen. Case number 2:09 CV 00058 MCE Dad, ED paragraph.
I don't know what to tell you.
Proposition.
They cited these incidents in a complaint in the 2008 election seeking to invalidate California's mandatory disclosure calls to supporters. Now being told, consider yourself lucky. You've got to go down. Hey, listen, man. If you're a bigot, if you're a fascist, if you're a Nazi, and someone says, consider yourself lucky, that's kind of just what you get. I don't know what to tell you. Like, wow, they're so desperate to protect the anonymity of fascists. This is the paradox of tolerance. If you're gonna say something with your chest, then say it with your chest, right? If you're gonna say something and you really believe it, then you better be ready to take criticism for it.
Proposition 8 opponents also allegedly harassed the Mesiur's supporters by defacing or damaging their property. ID, paragraph 32. Two religious organizations supporting Proposi Tie-in 8 reportedly received through the mail.
What's the white powdery substance? Did they find out? Was the white powdery substance baking soda? Like, what was it? Salt?
Paragraph 33.
You're not going to explain what it was?
Those accounts are consistent.
Whoa. Stop. What just happened? I saw damaging their property, white powdery substance. Click. Consistent with the media reports describing Proposition 8 related retaliation. Okay, come on. Let's speed this up.
Disclosure laws. Supporters recounted being told, consider yourself lucky. If I had a gun, I would have gunned you down along with each and every other supporter. Or, we have plans for you and your friends. Complaint in protectmarriage.com, yes on 8V Bowen. Case number 2:09 CV 00058 MCE Dad, ED Cal, paragraph 31. Proposition 8 opponents also allegedly harassed the Mesiur supporters by defacing or damaging their property. ID, paragraph 32. Two religious organizations supporting Proposi Tie-in 8 reportedly received through the mail envelopes containing a white powdery substance. ID, paragraph 33. Protectmarriage.com. Those accounts are consistent.
Wow, okay. Weird, it just doesn't want to...
Consistent. Citizens United v. Federal Election COMMN.
Wow, weirdly enough, I might have to read the end on my own. That's fine. Media reported...
$1,000 to support the initiative. He was forced to resign after artists complained to his employer. Yeah, do it. The director of the Los Angeles Film Festival was forced to resign after giving $1,500 because opponents threatened to boycott and picket the next festival. Yeah, dude, if you do shit, you should be allowed to find out if you choose to fuck around, whether they supported gay marriage or they were against it. You should be allowed to find out. Is forcibly disclosed donor information to preempt citizens' exercise of the First Amendment right. The 2008 election, a newly formed nonprofit group planned to confront donors, conservative groups hoping to create a chilling effect that would drive up contributions. Fucking go for it. Oh my god, if you support something that is connected to a public campaign where the topics are already public, they should have to disclose who is funding it. If you don't stand by what you believe, then don't even fucking try. It's not the United States. Well, it wasn't maybe in 2010, Obama era. The United States was not like a terrible fucking a surveillance state where you couldn't say things or otherwise you'd risk your life. That's not the setting of middle-class United States at the time period. I understand the idea of having full anonymity and full coverage for anonymity for public free speech if things are absolutely terrible. But at the time period, that wasn't necessary to think that way. So it looks like both sides, people that supported gay marriage and people that were against gay marriage, both used tactics to hold people accountable for what they were voting for. It's clear the threat extends far beyond a single ballot proposition. For example, a candidate challenging an incumbent state attorney general reported that some members of the state's business community feared donating to his campaign because they did not want to cross the incumbent. Ooh, interesting. I got to so many people in here. I go to so many people they're saying, I sure hope you beat the incumbent, but I can't afford to have my name on your records. Might come after me. That's actually the first strong argument I've seen so far. The as-applied challenges to disclosure. Let me see if it'll start reading again, if I can get it to start here.
Implement political strategies specifically calculated to curtail campaign-related activity and prevent the lawful, peaceful exercise of First Amendment rights. The court nevertheless insists that as-applied challenges to disclosure requirements will suffice to vindicate those speech rights, as long as potential plaintiffs can show a reasonable probability that disclosure will subject them to threats or reprisals from either government officials or private parties. F52, internal quotation marks omitted. But the court's open eye on itself proves the irony in this compromise. Incorrectly explaining why it must address the facial constitutionality of Section 203, see ante, at 5-20, the court recognizes that the First Amendment does not permit laws that force speakers to seek declaratory rulings before discussing the most salient political issues of our day, ante, at 7. That as-applied challenges to Section 203 would require substantial litigation over an extended time and result in an interpretive process that, itself, would create an inevitable, pervasive, and serious risk of chilling protected speech. Pending the drawing of fine distinctions that, in the end, would themselves be questionable, ante, at 9-10, that a court would be remiss in performing its duties were it to accept an unsound principle merely to avoid the necessity of making a broader ruling, ante, at 12, and that avoiding a facial challenge to Section 203 would prolong the substantial, nationwide chilling effect that Section 203 causes, ante, at 16. This logic, of course, applies equally to as-applied challenges to Sections 201 and 311. Irony aside, the court's promise that as-applied challenges will adequately protect speech is a hollow assurance. Now more than ever, Sections 201 and 311 will chill protected speech because, as California voters can attest. Citizens United v. Federal Election COMMN. Opinion of Thomas, J. The advent of the internet enables prompt disclosure of expenditures, which provide political opponents with the information needed to intimidate and retaliate against their foes. Ante, F55. Thus, disclosure permits citizens to react to their political opponents in a proper or undeniably improper way long before a plaintiff could prevail on an as-applied challenge. Point 2. I cannot endorse a view of the First Amendment that subjects citizens of this nation to death threats, ruined careers, damaged or defaced property, or preemptive and threatening warning letters as the price for engaging in core political speech, the primary object of First Amendment protection. McConnell, 540
Actually, I specifically believe in America, in contrast to Justice Thomas, I specifically believe in a country where if you are a bigot, you should face threats to your career, maybe not your property, maybe not to your life, but yeah, any semblance of your person being a respectable thing anymore should disappear the second that you decide to say, hey, I'm a Nazi. Shouldn't be able to do that. Okay, that's it, finished out. All right. Okay. All right, that is it. I wonder how long that was. The first one was like 3 hours exactly, and it looks like this was 6. Wow, that was terrible. So that means it was 9 hours. I thought it would be 9 to 12 hours, and I was generally close. Awesome. Well, with that, I am now done reading the Supreme Court's opinion on Citizens United versus the Federal Election Commission, and I have learned a disturbing amount. Wonderful. I will have this video in the next month. I have a bunch more that I still have to read and research, and then I have to decide what I want the scope of this video to look like, which is going to be very hard. Alright, I am ending stream. Have a good day. Get subscribed. Share the video. Do all the classic stuff. Like the video.